All right. Coming.
Committee. Today is February 8th. We will start with our bill hearings. Our first bill is House Bill 814. Let's give a warm round of applause to the speaker joining us today.
They never do that for me.
My apologies, Mr. Chair. Let's give a warm round of applause for the chair. All righty. Well, Mr. Chair, whenever, or Madam Speaker, whoever's ready to go first, please begin.
Okay, thank you. Good afternoon. Well, Chair Clippinger, who's co-sponsoring this bill with me, Vice Chair Bartlett, and members of the House Judiciary Committee. For the record, I'm Speaker Adrian Jones. I'm here today to testify in support of House Bill 814, legislation that will reform our juvenile laws. Before I begin, I'd ask everyone to set aside their preconceived notions on this issue. I brought this bill forward because our juvenile system is clearly failing a small set of children who are repeat offenders. They are not monsters or teen villains. They are children. And they are increasingly calling out for our help because they are not getting the services they need. I know this bill is going to disappoint both sides of the debate, and I'm comfortable with that reality. What I am not comfortable with is the way the debate around this bill and the Juvenile Justice Reinvestment Act has been framed. In fact, I'm incredibly disappointed. We simply aren't going to we certainly aren't going back to the way it was 10 years ago or 1 year ago. We aren't going to deny children their constitutional rights. We aren't returning to failed tough on crime policies of the past that could lock up thousands of Black and brown children. But we aren't going to continually cycle a small number of children through a system that isn't meeting their needs or for rehabilitation. We have to be honest with ourselves. No part of our public policy hasn't been touched or affected by the pandemic. Between the passage of the Juvenile Justice Reinvestment Act and today, the pandemic has significantly changed our communities. We have more behavioral health problems now than we did before the pandemic. Our communities are awash in handguns, and they're increasingly finding their way into the hands of children. Acknowledging this reality means that we must make changes. We can't sit by and hope the system catches up with the problems. For those who haven't noticed, we are taking action. We're focused on rehabilitation and addressing the underlying causes of crime. This session, the governor's budget includes $350 million to support juvenile services. It enhances funding for the Thrive Academy, for a continuum of care services, and for a new partnership between juvenile services and human services on a community investment initiative. I'm confident that this committee will look for opportunities in this bill and others to improve the delivery and support of services and treatment. But no amount of money can make up for the lack of oversight in our juvenile systems right now. Egos, political agendas, and finger pointing are getting in the way of juveniles receiving the services they need. This is unacceptable. House Bill 814 will ensure that everyone will be held accountable. DJS, law enforcement, state's attorneys, and yes, our youth. As a parent, I know that children require structure and supervision to ensure that they are getting what they need. This bill begins to create the structure and supervision to ensure that juvenile offenders get the services and treatment they need. As hard as it is to talk about, this bill speaks to children who are harming animals, carrying stolen guns, and sitting behind the wheel of a stolen car. The idea that these are not instances of our children crying out for help justifies logic. The motivation for our involvement is to help. That's it. We just want to help. So I want to remind everyone testifying on the bill that our children's lives and futures are at stake. They deserve all our best efforts, not hyperbole or hysterics. With that, I thank you, and I will now turn it over to Chairman Clippinger to explain the details of the bill and take any questions.
Good afternoon, committee. For the record, I am Delegate Luke Clippinger, presenting House Bill 814 and some of the details of the legislation. This summer, after 30 people were shot at Brooklyn Days in my district, including 15 children under the age of 18, the Speaker asked this committee to hold briefings on the juvenile justice system, including how the Juvenile Justice Reform Act of 2022 impacted issues related to public safety. We had 3 briefings. We heard from parties I would characterize as all the way across the spectrum, from the Office of the Public Defender to those who supported reform of the juvenile justice system to law enforcement. And if there's one thing they all have in common, it's that they all believe that they need the Department of Juvenile Services to be successful. They need the department to be successful in its work rehabilitating our children. But what became clear from the briefings and what we are seeking to act on in this bill is that there needs to be some structure returned to the juvenile justice system that will allow kids who need rehabilitation and support to get that rehabilitation support, to ensure that they are completing the rehabilitation that needs to be done, and to make sure that truly the children who are involved in the most serious cases, including serious misdemeanors, are covered by the system. The bill does a number of different things, but I'm going to talk about and follow up on what the Speaker said about a couple of things that are not in the bill, but that are in budget language. The legislation, or I should say the budget, invests in programs like the Governor's Thrive Academy, an academy that will focus specifically on children who either themselves have been found in possession of firearms or are in the ambit of people who have possessed firearms. Part of the challenge that we have is that kids will get guns, not only to protect themselves, but sometimes in terrible circumstances to seek to take out vengeance on other people. We have to do that work through programs like the Thrive Academy, and I'm very happy that the governor has included that money in his budget. Further, there's budget language that addresses the recently passed interrogation law that we passed as it relates to juveniles, that ensures that local law enforcement agencies are properly training their patrol officers in how that law works. In the bill, there are a number of issues that relate to accountability, including the first part of the bill it does expand the jurisdiction of the Department of Juvenile Services for children who are between 10 and 12 years old who are involved with the possession of a firearm or other weapon, who are involved in animal abuse, who are involved with or alleged to have been involved with sex offenses in the third degree. And a sex offense in the third degree is the use of violence with while at the same time engaging in sexual contact. It's not penetration, it's only sexual contact. And further, it extends the jurisdiction to the theft of a motor vehicle. It requires the department to make an inquiry into all felony complaints and within 15 business days, shortening the time period so that we can move kids into services faster if they need them with the department. It takes on a legislation that was passed in the Senate last year that came from Senator Carter that addresses issues related to kids who are of any age who engage in conduct that results in the death of another person. There was a terrible incident in Baltimore where a 9-year-old shot a 15-year-old with their aunt's gun. And there was no follow-up that was able to be had with the department, and there was it wasn't good for the victim, and it wasn't good for the child either. Senator Carter's bill is included in this larger legislation. It lengthens the possible length of probation to up to 2 years for a misdemeanor as a whole. It would say that right now, under the current law, the current length of probation is 6 months for misdemeanors, go to a year with the option to go to 2. Felonies, right now, it can be a year initially with the option to go to 2. We would make that 2 with the option to go to 4. It also creates an oversight commission that I believe is badly needed. Presently, there are 2 commissions that exist, one in the Department of Juvenile Services that addresses issues related to further reform, the other related in the Department of Human Services that relates to the juvenile system altogether. It combines those 2, creates the Commission on Juvenile Justice Reform and Emerging and Best Practices that will bring together the schools, the Department of Juvenile Services, DHS, and a wide range of other players, including the Office of the Public Defender, law enforcement, to look closely at services that are being provided, to make further suggestions for better services for kids who are and kids who are most at risk, to look at the educational programs and services within the Department of Juvenile Services, diversion programs, and again, a wide range of other issues. We also seek to add and look to gather more data, I should say. And one of the ways that we do that is we require police officers to file a report every time they arrest a child. In some of the conversations, I will say that we're already having on the legislation, including conversations with both the department and the Office of the Public Defender, there have been some concerns expressed that by simply requiring the reports all to be turned over to DJS without saying whether they have to be reviewed by DJS, it creates a impact to the agency that I think you see in the fiscal note. I think we'll be able to address that by making it clear that there are situations where police officers do not wish DJS to be involved, or as we learned in one of the briefings that we had, police officers sometimes have diversion programs of their own that they can divert kids into. That should be an option there so that those cases don't actually have to go into the Department of Juvenile Services system. There are quite a few other things that are in the bill. I know there's been a great deal of conversation about it. I'm certainly happy to answer any questions that you have, and then we can go forward to witnesses. But thank you, Madam Vice Chair.
Thank you, Mr. Chair. Thank you, Madam Speaker. And colleagues, members, if you have questions, please let me know. Delegate Erican, question?
Yeah, pardon me. Thank you, Madam Chair. Thank you, Mr. Chair and Madam Speaker for being here. So it is obviously a very dense bill. If we just go back to the case that you mentioned with the 9-year-old, under this new thing, what would the process look like? What would it be different for that situation?
They would be open, they would be included in the jurisdiction for the Department of Juvenile Services. They'd be first open for the jurisdiction of the juvenile court.
Okay.
So the Department of Juvenile Services would have to take that case on.
Okay, and then for
And they'd have to take it on, by the way, because it would be a felony because it would likely be a felony, I think, in that case. Yes.
Okay. And then for the victim's family, how would that differ? They obviously had no touch points really currently. So how would that differ for what would their experience be like?
There are victim rights, the victim rights statutes that we already have on the books connect with juvenile cases. Again, if the case were a felony, and again, it's hard for me to walk through exactly how that specific case would have worked,
Right.
because it would depend on a lot of different factors.
Yeah.
But that case would likely be referred to the state's attorney's office, and you'll hear from members of the Office of Public Defender and state's attorneys who can disagree one way or the other with that.
Mhm.
But in all cases, I believe that would trigger victim services laws we already have on the books. So
Okay,
so the
and-
victims would be part of that process.
Okay, that's good. I think that's obviously we all agree that's really important that they have feel like their voices are being heard. If the child had been 14 under the new law, what would the difference be?
If the child shot someone and they were 14 years of age, again, depending on what had happened, and if they were charged with a crime of violence, that's the current law, and nothing changes under the
Okay.
current law that says that child, because they committed a crime of violence, that case would ultimately be referred to the state's attorney's office.
And then they would decide which path it took.
The department first would look to see whether the child should be detained. They have a process by which they use a rubric to determine whether the child should be detained or not. If they were charged with, and this is based on the tool that's available online from the department. If the child was being alleged to have committed a first or second degree murder, it would strike me that they would receive the number of points under that rubric to be detained.
Okay.
Then they take next steps to review the case. Under the current law, they'd have 25 days to determine what steps to take. Then it goes from there to the state's attorney to go forward. Effectively goes to the state's attorney to determine whether to go forward with charges
Okay.
or not.
And this bill will change that to 15.
It would change to 15 business days as opposed to 25 calendar days.
Okay. All right. Thank you very much.
Delegate Grammer?
Thank you, Madam Chair. Thank you, Madam Speaker. Thank you, Mr. Chair. I have a question about the kind of listing of crimes for which a court may have jurisdiction. Here's how my concern. So due to the nature of juvenile crime, frequently there seems the course of conduct of a youth is sometimes, to me, more important in trying to connect with that youth and provide services, make sure they don't reoffend. The course of conduct is often more important than the specific law, the specific violation that we're trying to capture. Let me give you an example. Theft of an all-terrain vehicle. Those cases seem to be particularly toxic in my district. The Neil Rivers case, where he was shot in his yard, the Georgia Bartram case, Harborview, we share that community. These specific crimes tend to impact people much more greatly. Under this bill, and I think these crimes are very relevant. I think it's a great idea, but it wouldn't capture cases where youth is kind of escalating. Would it or would it not be appropriate to give a judge the authority to say, in cases where there is really a high interest of public safety, rather than trying to capture each of these crimes perfectly, which if we sat here for a year, we could probably never do that. Wouldn't it be appropriate to give the judge the authority to say, you know, if we find that there's an interest of public safety, we might also say we have jurisdiction over this particular case?
So the case doesn't get to a judge in that way. It's different in a way, again, because the juvenile system is about rehabilitation. And that is sort of the first principle of the system. So you don't have a judge getting involved in many of these cases until later. And it's after the department makes a decision, and then after in some cases, if it involves a felony, then a felony, violent felony or a crime of violence, that the state's attorney would then make a decision as to whether to go forward or not. So I feel that it's important that the current structure stay as intact as possible, to allow the department to have that initial discretion and to have that discretion to decide whether those cases should go forward.
Right.
I think there is, and this bill seeks to and does change one thing with regard to that discretion, and it's an issue that I'm certainly open to discussing more, and that is whether or not the department should be able to divert nonviolent felonies, basically possession with intent to distribute drugs,
right,
whether those cases should be able to be diverted. In the bill right now, it says that all of those cases have to be referred to the state's attorney. Whether that, whether that remains or not is something for this committee to decide. But I think that initial step in the process, where the department uses those objective steps and looks at the child, looks at what happened in the case, and decides what steps to take forward, not only on detention, but on whether a case should go forward or not. I think we should try to maintain those as much as possible. My broader concern, and what we seek to get out in a couple different places in the bill, is there also must be oversight about how that discretion is being used. And that is what the commission seeks to do at the back of the bill, with data from the Maryland Longitudinal, it's a hard word, Maryland Longitudinal Data Center, and also with further information that we would gather about when cases are resolved at intake and when those cases are diverted. We need to get more information about that as well, and there needs to be oversight about that. And that goes back to some of the about when kids return to the system after already being on probation.
And I appreciate that. I apologize for the bad wording. What if the department, everybody was in agreement that this particular case, might not fall within the particular boundary of the law, but might be a case where we want to, again, the course of conduct is really concerning.
I think in some cases, depending on the age of the juvenile involved, the department may already be able to be involved. If you're talking about, I think you're talking about between 10 and 12.
Yeah.
I think that what we did in the juvenile justice reform bill was to limit those cases to people who are 13 and older, largely those kinds of cases that I think you're referring to in the theft of an ATV, which is different from a theft I think is different from a theft in some ways from theft of a motor vehicle. So I think that for effectively what you're talking about is kids 10, 11, and 12. I don't think it's appropriate to go beyond what's in the legislation. And quite frankly, and again, in some conversations, I think there are parts of what's in the bill right now that we can and probably will look to trim back, specifically in some parts of the animal abuse section. But having said that, the goal was with our legislation in 2022 that we want to try and get people into the most appropriate services we can, particularly in those lower level cases.
Yeah.
We didn't want to include them in those lower level cases going forward. We wanted to make sure that they got appropriate services.
Yeah.
What we're doing with this legislation is we're addressing the fact that I believe that there are more crimes that are serious and that need to be addressed when a kid is 10, 11, and 12.
And I would like to talk through that. We've lost the ability to use joins in Baltimore County for some of these youth. So I think this is important. Thanks so much.
Delegate Crutchfield.
Thank you very much, Madam Vice Chair. And good afternoon, Madam Speaker. And of course, good afternoon to our chair. And my question is really to the chair. I want to first of all, thank you for the JJRA legislation. You were the architect of that in 2022. You were part of a commission, or I'm sorry, a council, JJRC, that included both yourself and I as members of that. And that was over a period of 3 years of hearings, debate, stakeholders, and the results was your legislation. Again, I want to thank you for that. It went a long way in transforming our juvenile justice system. But I am a bit disappointed and a little bit concerned about some of the items that are now in this new legislation. I feel like to some degree it is erasing all of, not necessarily all, but a lot of the good work that was done previously. I mean, we made a clear effort to eliminate the youngest children from being exposed to the juvenile justice system. And now you have gone ahead and brought them back into the system in a new and different way. And so as you mentioned earlier, the juvenile justice system is all about rehabilitation, accountability, but I just want to make sure, and I know that you, of all people, are very concerned about these issues. I know that. I've talked to you about it. But I want to make sure that it's clear about where you're coming from in adding in these felonies and making sure that these are felonies or the way you've done this will allow for the rehabilitation of children.
And I thank you for that. And it was, the council worked for several years. And I think one of the things that, well, you're talking about some of the new crimes that are brought in,
Correct.
especially
That
from
is
10,
correct.
for 10, 11 and 12
That
year
is
olds.
correct.
So one of the crimes that's included in this legislation that was in fact a JJRA recommendation was 3rd-degree sex offense, which again, and I hate to do this over and over, but it's basically having sexual contact that doesn't include penetration, but using violence at the same time. That was recommended by the JJRA. It wasn't included in the final legislation. It does seek to address that issue. The significant issue that we have seen, especially over the last couple of years, has been dealing with kids who are found in possession of firearms and kids who are found in possession of weapons, and furthermore, to a lesser extent, the animal abuse cases, but then to a bigger extent, the car theft cases. So the thought by including those cases in there is again to recognize that the department is there for rehabilitation. The present system would allow them to go through the SINS process, a process that is voluntary, that the kids can be withdrawn from at any time. And that does not allow for the structure that needs to be in place for some of these more serious cases. And in these cases, they are misdemeanors, to be clear. These are not felonies. These are possession of a firearm, possession of a ghost gun, possession of a stolen firearm, possession of a gun that was purchased in a straw purchase. These are the kinds of crimes where if you have a 10 or 11 or 12-year-old, that we as a state, I believe, would look at those cases, those alleged cases, and say, what on earth is going on? And we need to take another step back and say, and stop the train and say, all right, we have this child who is not only in need of services, but needs something more. But we need to make sure that they're in a structured system so that they can get those services and so that they can move forward from after that. And that's why I think it's important that the governor's funding of the Thrive program is so important, because if we, again, by creating that program and tying even especially some of those younger kids into that program, I think it helps divert them from the system in the long run. And it can begin to address the issues that made them want to pick up and possess that firearm in the first place.
Question, please, Madam Vice Chair. So with that in mind, I mean, that's sort of eliminating some of the things such as informal adjustment, other things that that DJS could do short of them actually being into the juvenile system. And so again, we have data that indicates, the younger you go in, the more exposure you have, and the more often that you end up in the system continuously. And so, again, I know that, you have brought thoughtful legislation and you always have thought about these ideas around children. But again, I just want to make sure that what you have in mind is really going to prove out to be a way in which children will really get the resources and the help that they need. And I just have not seen that by having younger children, or there's no data that indicates having younger children go into the juvenile system early will at all do that.
I think that there are a couple of things that we learned from the data that comes from the Department of Juvenile Services. Is in fiscal 22, the number of, I think it's the number of kids between 10 and 12 who were brought into the system, it was about 1,100. 4 of them, I think, were detained of the 1,100, and those were cases that rose to the level of serious felonies. I think that our bigger challenge here is if the programs otherwise that would be available would be strictly voluntary, that in cases where you have kids with firearms, kids who clearly need greater and better services, and they need structured services that provide that structure, I should say. I believe that making, again, what the bill does is it says in page 3 of the bill that it provides for jurisdiction to the juvenile court. So the process still goes forward with DJS. They would still go through the process determining whether or not a person was going to be detained, much less whether they would resolve it at intake or not, depending on the kind of case it was, and depending about how their existing tools rated those children. So with regard to, and you mentioned diversion and the other area of the bill that goes in the area of it does scale back diversion to some extent. It's the area with nonviolent felonies. The question that has come up from particularly state's attorneys has been, if the child does not adequately complete the diversion program, state's attorneys, because of the compressed time frame that already exists to try these cases, have a difficult time getting the information and putting together the cases so that there is something at the back end of diversion to provide an incentive to complete the diversion program. I will say that I think that I believe that part is very important, but I also think that there may be ways to address that underlying issue that the committee can consider, and I'm happy to talk to you more about that.
You're open to suggestions and ways that we can make legislation better. So I do appreciate that from you, Mr. Chair.
Okay, I just have a couple of quick questions, and I know that Delegate Boucher and Delegate Simpson have questions. And then what I'd like to do, members, is if you could hold off your questions, we're going to have several panels after this, and then you can continue with your questioning to allow for time. My first question is, I know we have rules that it has to be a question, but it's going to start with the "isn't that so?" and then we'll go from there, if you don't mind, Mr. Chair.
That's what happens when I'm over here.
That's right. So, I look at House Bill 814 as a youth violence prevention bill. That's what I've been calling it. And I probably will put in an amendment to change the title, but that's that. And I look at it that way because of those new offenses that are listed You were very polite in not getting into some of the third-degree sex offense, but I mean, that includes suffocation and strangulation and disfigurement and infliction of serious physical injury, or even engaging in sexual conduct with someone who's substantially impaired. Those are serious offenses. My question to you is a little bit rhetorical, but possession of a firearm, you know, I know that the council looked to crimes of violence. I know that possession of a firearm is not necessarily listed under crime of violence. However, where does a crime of violence when dealing with a handgun start? Isn't the first step the mere possession of that handgun?
In order to commit a crime with a handgun, you would in fact have to have a handgun. Not to be smart in answering your question, Madam Vice Chair, but it is the first part. We know, and we do know that people illegally carry, and in many cases, juveniles and children illegally carry firearms for a wide range of reasons. A lot of them carry them because they don't feel safe in their neighborhoods. Others carry them because they intend to do something bad with them. At the end of the day, when, again, we've seen the data, and we've seen the data both in the JJRC and in repeated testimony in this committee, that children have issues with impulse control. They have issues controlling themselves and their behavior. The possession of a firearm by any child from 10 and above is a major problem. It's a reason that, as I've said before, we need to stop the train and find out what's going on. And whether that child needs cognitive behavioral therapy, as several organizations provide, and we heard about in the briefings that we had, whether the child needs any of a range of different services that are available, we need to get that child to those services. And we need to make sure that those services are provided. That second part is very important. We have a responsibility to the public. We have a responsibility to the people of the state to make sure that those services are provided. And when we don't do that, or when we can't be sure that some of those services are provided, that's a problem.
Thank you. And the speaker looked at me a little funny when I said I was going to change the title. So maybe I won't do anything to change the title.
Don't do that.
But I'll shout it from the mountaintops. The other thing I wanted to point out with respect to data, our data does our data, because I want to form it in this, I want to make sure it's a question. Does our data, or does the data that even JRC looked at, show that children are more likely to be victims of crimes, including homicides, than perpetrators?
Yes.
Is that a true statement? Okay, and also, is it a true statement that firearms are the leading cause of death for children and teens in the US?
Yes.
Okay, thank you. So I'm gonna go to Delegate Boucher and finish up with Delegate Tolles. Delegate Conway, I see you, but I'm gonna ask you to hold your question till the next panel. And the same thing with Delegate Cardin. Please, if you could hold it for the next panel. Thank you.
Thank you, Madam Vice Chair. I want to draw your attention to page 9, line 27 to 29 in the bill. The Supreme Court of Maryland may adopt rules concerning age-appropriate language to be used to advise a child who is taken into custody of their child's rights. Will this explicitly explain to the child their Fifth Amendment rights to ensure that their rights are protected? And the second part is do children have the same civil rights guaranteed to them as adults?
So in the bill, that does not change what is existing law. That is existing law. That's part of the law that we passed as in the Juvenile Interrogation Act. So that's existing law. It will remain existing law.
Nothing will change that.
No.
Thank you.
All right. You have, your second question is what?
Children receive the same guaranteed rights as adults, basically, and there's no differentiation in the two.
That's what the Supreme Court has held.
All right, thank you.
Yes.
Delegate Simpson.
Over here.
Hi.
Thank you very much. I do appreciate the spirit of this bill. And my concern is, or can you walk me through, actually it's not a concern, can you walk me through how does this address the safety of children? Because all the crimes that are listed, the crimes of violence, not all of them, but the crimes of violence, the sex offenses, the animals are indicative of kids that may be abused or sexually abused themselves. Where is that assessment? Where is the, and then some of the others are, how are we addressing, as we've discussed, some of these kids, it may be neglect. I mean, they're over 8 years old and therefore they're not being supervised and their parents are unable because they have several jobs and things like that. Do we have community services in which before and after? I mean, I don't know that I want to keep extending probation, but I would like the kids to have programs that they can attend.
So is your question,
There's the assessment of the child welfare,
right?
The protection, whether or not they're being abused. And I think the other is, how are we addressing, I don't want to call it neglect because I don't think anybody's doing it purposely, but providing that supervision, not just voluntarily, but, to the communities that need it.
Part of the challenge with talking, and I don't want to be dismissive of the question, particularly with neglect, but part of the challenge that we have addressing those issues is that that we're dealing with legislation that is effectively deals with the jurisdiction of the juvenile court. That's what we're dealing with here, and we're not necessarily dealing with some of those much broader issues. And to go to a point that has been made over and over again, there's a wide range of issues that go into a child who enters into DJS, who enters into the jurisdiction of the juvenile court system, and those issues touch nearly every committee in this legislature. They touch education. It can touch the availability of parks and recreation. It can touch any number of different issues. So it's kind of difficult as we're talking about this, so I want to acknowledge that there are those issues that are in different places. And that's why I mentioned the money that's in the budget that will seek to address some of these other, some of those programming issues. But the bill has to focus on juvenile jurisdiction, and it's kind of hard to go to some of those issues. But to your question about when the child's evaluated, that's part of the process that happens when a child is alleged to have committed a crime. And that's, again, the focus of the bill. That does happen then. Should it happen at other times? Does it happen at other times? That those become issues for other bills and other committees.
There needs to be anything of kind of an amendment, or at least some better coordination between child welfare and the juvenile system, especially for these really young kids.
This is part of the reason why we're bringing together DHS, and DHS isn't the only organization that provides some of those services, but why the larger commission would be inclusive of DHS and DJS and the schools and seek to get people together. One of the challenges that I think this committee found when we had our briefings over the summer was that the silos here are ridiculous, and law enforcement will come up to this point and stop. The department comes up to this point and stop, and ne'er the twain shall meet sometimes. Sometimes they do, sometimes they don't. Sometimes it depends on what jurisdiction you're in. Sometimes it depends on the kind of case that you're dealing with. And that's a particular challenge that it's going to take, quite frankly, the executive branch to change the way that those processes within the department work, to make sure that there's something consistent across the state. And frankly, I should say, we move the oversight boards from being under the purview of DJS and the bill and under the purview of DHS to being under the office of the governor's office of, or whatever we're calling GOCAP today. to make sure that there is some other group that is truly supervising and overseeing the services here so that they can provide more of a global 20,000 foot level look at what's going on. Thank you.
Thank you. That concludes this part of the panel. I do have another panel that we're going to call up. Do you want me to call that up now, Mr. Chair?
Yes, please.
Okay, we have State's Attorney Bates, State's Attorney Braveboy, State's Attorney McCarthy, and I believe ASA Rosenthal, Catherine from the Baltimore City State's Attorney's Office. Okay, great.
Chair, I did sign up for this group, so.
Well, we don't have you on this panel, Mr. Schellenberg,
Okay.
Mr. State's Attorney, but we will have you coming up. We have several panels coming up. And Ms. Rosenthal? Is she in here?
She is.
Okay. I thought I saw her. Okay. So whoever of the state's attorney wants to go first, please do so.
Go first.
Flip a coin?
I think by virtue of being the oldest, they're going to let me go first.
All right.
May I say, I'd like to thank the sponsors of this bill for engaging in conversations over many months to address some of the issues I think that have been identified almost uniformly by all the state attorneys around the state. I think almost anything I'm about to say, I've heard echoed in almost every jurisdiction where we've been having this conversation probably throughout the last 8 or 9 months. I do think that this bill is a balance. I think there's many issues that I think some of them were actually raised by questions that were asked here. Some of the other issues that state attorneys have about some of the changes that have been made are not addressed in this. I do think that this is a balanced, reasonable approach to addressing majority of the issues. I know that for my own jurisdiction, we desperately need your help to address the issue of crime. They're doing it in a neighboring jurisdiction. Similar things are being addressed in Washington, D.C., which abuts me, and that was just sponsored by the mayor in that city last week. Our gun crimes year over year are up 220%. My auto thefts are over 200% up year over year. My carjackings are up 85%. Number of young people shot has increased. Last year we had 40. Last year we had 96 that were seriously physically injured. That's just in Montgomery County. In the area of carjackings, we don't solve every carjacking in Montgomery County, but in the cases where we've actually made arrests, 70% of the kids arrested for carjackings in Montgomery County are juveniles. We only see, as state attorney, we see about 30% of the cases that come into the juvenile justice system. Most of this goes to DJS. And I think all of us would sit here and say to you, I think that they need, and because we do understand the philosophy and what juvenile justice is about, they need and have inadequate resources. Last year, I think they have, if you took every single spot that's available in the DJS, I think you have 793 spots. 1,600 individuals were committed to those spots. Delays in placement, which take in my county 3 to 4 months. Inadequate length of treatment, which is usually averages between 4 and 5 months. If you look at the studies about opiates, you need 18 months to 2 years of treatment to overcome an opiate addiction. We give you 4 months, push you out the door. That almost dooms that child almost coming back into the system immediately.
I'm sorry, Mr. State's Attorney. We probably will
That's
have
fine.
questions for you and then you can continue, but we
I-
want to be a little stricter today on the calendar, on the clock, given the length of witnesses we've got. We want to make sure we get through
I
them.
will end with saying I urge a favorable vote on this bill.
Okay, great. Thank you.
Thank you so much, Madam Chair and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here today to speak in support of House Bill 814. This represents a comprehensive approach to juvenile justice reform, addressing critical issues while promoting public safety and accountability. Similar to my colleague last year, we were referred over 1,000 juvenile cases, primarily cases that are felonies that involve very serious offenses. 314 of them were motor vehicle related offenses. 89 were carjackings, 199 were armed robberies. Our concern is that young people are using dangerous weapons in the commission of very violent crimes, putting both themselves and the public at risk. Our goal is not to lock every child up. The goal really is rehabilitation, but there has to be accountability. And what we don't always know in the system is what is happening to the child. Are they receiving the services ordered by the court? And if they are not receiving those services, why aren't they receiving the services? We're thinking that these services are being ordered because defense counsel, state's attorney's offices, along with those medical professionals who evaluate young people are making recommendations to a judge, along with the Department of Juvenile Services are making recommendations to a judge on what the appropriate treatment should be for a child. And if a child is not taking advantage of the treatment plan, then how do we know whether or not that child is progressing and will not reoffend? So have some additional safeguards in legislation that will provide for accountability is extremely important. And that's why we support this bill. And I'll be happy to answer any questions at the appropriate time. Thank you.
Thank you. State's Attorney Bates.
Yes, thank you, Madam Chair. I'm here today to express my support of House Bill 814, the juvenile law reform. This comprehensive legislation speaks to the very essence of the issues that we have raised and seen over the past year, as states' attorneys and law enforcement officers have been struggling to ensure public safety. This bill outlines a wide variety of solutions to problems that currently exist within the juvenile criminal justice system. And if passed in its entirety, I believe that it will be responsible for moving toward fixing a number of the issues that we've seen. Whether it's extension of probation or forwarding of cases to the state's attorney's office for notification in a timely manner, these fixes will help address a glaring hole in the existing law that has allowed for juvenile offenders to fall through the cracks for far too long. In regards to probation, it does a disservice to both the public safety as well as to the juvenile offender when a child is given an arbitrary time frame for probation without taking into account the amount of time that they will need to not only accept the child into the program and services, but to ensure first and foremost that the young person, the child, will be able to get all the services, all the support that they need. And that is why we need to really focus on the rehabilitation and the programming for all of our young children. As it relates to the provision, ensure the Department of Juvenile Services forwards the cases to our offices. That is so important. This will allow us to, meaning the prosecutors, to deal with the cases, to reach out to victims, to reach out to witnesses more quickly, as the current process is flawed and does not allow for the communication between all of us within law enforcement to hold the young people accountable. At the end of the day, we, as prosecutor, myself, and state's attorney for Baltimore City, thoroughly support this bill and would ask for a favorable ruling. Thank you.
Thank you. And now I'm going to go straight to Delegate Conaway and then Delegate Cardin.
Thank you, Vice Chair. Thank you, panel, for coming in to testify. Earlier, the chairman spoke about providing services. I keep hearing accountability, but I'm questioning, when is the society going to be accountable for teaching these juveniles that we're talking about, 9 years old and below, what laws apply to them? They might be doing things that we're describing as very egregious activity, which they just don't know. They're joyriding or something like that, and an accident happens. When are we going to teach the juveniles these laws so that they don't get caught up in the system?
Well, I think most of us who've raised children or grandchildren, as the case may be, it begins, I think, in our homes. And I think it does extend to our schools. I think this is a communal responsibility. It's not isolated simply to the courts.
Please.
Yes, sir.
Do you know that the Castle Doctrine is not valid in the state of Maryland? You do not have the right to confront someone if they break in your house. If you're upstairs, you have to use regress. Are you aware of that? I wasn't aware of that until I got here. So when are you going to teach these things?
I thought Maryland did recognize the Castle Doctrine.
You
We've
can't-
seen it raised as a defense, and
No.
It is at the bottom.
I put the bill in, so
Okay.
I know.
Okay,
Thank you very much.
okay. That's all we did right.
Okay, Delegate Carden.
Thank you, Madam Chair. Thank you all very much for coming and providing your compelling testimony. One of the things that, Mr. McCarthy, that you said, which struck me, so 70% of all your car thefts in the county,
Auto, carjackings.
70% of all your carjackings,
Carjackings where there's been closures.
okay, are juvenile. What
Yes,
does
sir.
that mean when there's been closures? You mean?
Well, because every time you have a carjacking, you don't always find the car or arrest somebody. So when I say there's a closure, it means we've actually arrested somebody. And then when you actually arrest them, you've closed the case. And then you actually know what the age of the offender is.
So one of the things that we're dealing with, I think, in this bill, and we're trying to deal with effectively, is making sure that there's communication of data so that we can assess and properly make sure that we're all talking about the same facts, the same information.
Right.
One of the things that we had during our briefings was that, and you guys came to a number of our briefings and helped us understand, and the other state's attorneys, I think, will have an opportunity to respond, is that the information we're getting from you and from the police is very different than we're getting from the Department of Juvenile Services or from the Public Defender's Office, for example. And so if we are setting it up so that there can be a diversion program that you or your police officers can participate in with somebody without it going through Department of Juvenile Services, is that information right now, is that information at all getting to the folks who can assess it and report to us? And if it's not, will it be getting to them? Like, will your police officers be letting us know, yeah, we tried to arrest or found 10 kids this week, who we just let go? We need to know that information in the department so we can assess how many of these incidences are happening without anything being done about it. So I'm wondering if you guys can enlighten us on what is happening in terms of communicating that information to the department.
So we get referred cases, primarily felony cases. There are other arrests that are made, juvenile arrests, that really fall under the purview of the Department of Juvenile Services. So when those J1s are filed, the Department of Juvenile Services will handle those types of cases. So we wouldn't know about them. We don't get referred those cases. And so any treatment plan or follow-up is totally, I think, within the purview of the Department of Juvenile Services. They don't have to tell us, what they're doing with the young person.
From Juvenile Services to you, I'm talking about, what about from your police officers to Juvenile Services, things that wouldn't rise to the level that maybe a felony that you would know about? What are your police officers doing in terms of informing all of us about what's happening so that we can all work off the same data?
So we have in our office, we have been getting just the copies of the juvenile arrest reports. So we know which juveniles have been arrested. But again, we don't get those referrals. Those referrals have to come from DJF. We can't just on our own, prosecute cases unless there is a referral from DJS. So on our side, we are getting at least that information from the police department. But again, many of those cases don't get referred to us formally.
Can I say something about numbers?
Yeah, let me say something.
Okay, good. No, I think the thing about this is very frustrating because I think when you look at the numbers, I think the category of offenses that people in the community are really concerned about, there's absolutely no question. Carjackings, auto theft, gun offenses, they're off the charts. I can give you numbers about things like larceny arrests in Montgomery County, and because I hear DJS say juvenile arrests are down. Well, they're down because the arrests are not occurring by the police. We're down 250 officers in Montgomery County. The arrests are not down because the crimes are not occurring. Couple of numbers. Larceny theft arrests in 19 were 387. Last year it was 128. CDS events, arrests in 2019 were 344. These are only for juveniles. It went down to 39. There were liquor law violations, 107 arrests down to 16. Disorderly conduct, 32 to 5. There have been declines in crime. So if you want to look at both things can be true. If you want to look at overall numbers and say there's less kids getting arrested, I'm going to tell you in Montgomery County, that might actually be true. But when it comes to violent crime and the crimes that people care about, the numbers are exploding.
And also to answer your question, one of the things I also realized in talking to my colleagues is that the juvenile system is a little different in almost every jurisdiction around the state. For instance, in Baltimore City, we have a juvenile holding facility that the officers will go and take, it's like regular adult jail, so to speak. And the officer may take the juvenile there, DJS will be there, and they'll say, okay, we're not going to proceed. That officer may take that child back to their parents. So we would never know anything about this case whatsoever. One of the things that I began to understand and figure out is that DJS was operating a silo, we were operating in our, meaning state's attorneys on our silo, and that the police were operating in their silo. I think one of the things that this bill does, it says, hey, let's have this oversight committee to ensure that everybody is on the same page. I think that helps tremendously, because the police will get upset because they'll feel nothing's going to happen to this young person. So they're not even wanting to arrest them or do anything to them. But then they also get upset because we have a shortage of officers. Then they make an arrest. And before they know it, they're there their whole shift. But there are only 5 or 6 officers helping to patrol that whole area. So, what do we do there? I mean, look, at the end of the day, we want to ensure that the young people are held accountable and they receive the services. But if we do not have the starting aspect of the intake and the communication from the very beginning, then it doesn't matter what process we put together.
The order I have would then go Delegate Tomlinson, then Sample Hughes, then I'm going to get another list here, and I see you and you down there. I got you.
Thank you, Chairman. My question is for State's Attorney McCarthy. Before the bell hit, which I think is a new sound, you were starting to
vote.
Yes, you were starting to talk about the drug element, getting those who are addicted to drugs, the proper treatment, and holding those accountable who are putting drugs out on the streets are 2 topics that are very important to me. Can you kind of continue what you were talking about there as regards to how the drug element relates to juvenile crime?
First of all, there is a fentanyl issue in our youth community. We had 11 students die of overdoses in my school system last year. There is distribution of fentanyl by juveniles within schools and in all segments of their community. When you look at the studies that suggest if we want to actually break the cycle of a fentanyl overdose, it is my understanding from the stuff that I've seen, you need about 18 months to 2 years of treatment. I think this goes back to what Ivan and Aisha were saying. What we're providing is a Band-Aid on something that requires much longer treatment. And the percentage of kids you actually are taking off of the drugs, or whether it's alcohol, whether it's drugs, I don't think we're adequately treating them. Opiates is probably the easiest example, because what we're giving them probably will leave us with 95% of the problem we started with, because they're not in treatment adequately. And that's just by research of people who have dealt with these opiate addiction kinds of things. And it's everywhere in our state, and it is certainly in my community. They're not getting enough.
And can I just mention, when we talk about accountability, it's not just accountability for the child. It's really accountability for the adults too, all the adults that are in the system as well, that we are making appropriate recommendations and that we're following up and following through on those recommendations. If a child is ordered to a treatment program, but they can't get in that treatment program because there's not a place for them or space for them, then it's up to us to figure that part out. And we all have to work together. We can't just say, well, that we don't have space, and so 3 or 4 months later, maybe we'll find a place for this child who really needs services now. I think that that's the kind of information I think the legislature needs to figure out where to make the investments within the Department of Juvenile Services. And so it's really about accountability all around. And I think that this is what this bill seeks to do. It's not just about the child, it's about all of us as well.
Delegate Sample Hughes, please.
Thank you, Mr. Chair. and Thank you, state's attorneys, for being here and your consistent advocacy on this issue. Apologize if I have too many questions for you, but some of my questions were for the previous panel, given the fact that I've not only heard from my jurisdiction, Wycomico and Dorchester counties, but also Baltimore County, including the Speaker's District, too often. So I just wanted to ask you a couple of things. With regards to the commission that is being proposed in the bill, I know that's supposed to streamline and allow you, law enforcement, yourself and many others, to no longer work in silos. But does the bill call for funding for training to happen at the very top with DJS's process regarding the SINs? So everybody's operating off of the same page and fully understanding it. And the reason I'm going there is because it was noted that jurisdictions operate a little differently. Well, in some smaller communities, rural areas, a lot of the jurisdictions are crossing jurisdictions to help each other with the juvenile crime. And so while one county may be effective in getting those SINs cases or those cases directly to the state's attorneys, where others might take another path and not have the support of DJS. So I was just kind of curious, is it just going to be an opportunity for everybody to really get the training, understand what the policies are and how to effectively move through them throughout the entire state?
I'll go ahead and take a stab at that. One of the things that we also figured out was that when it comes to SINs, give an example. We had an issue of a 7-year-old, a 9-year-old, and a 10-year-old. They did a crime trying to break in New Year's Eve. Saw them on video, the whole nine. Officer sees them, gets them, and doesn't really know what to do with them. Brings them to my office, and I figure out what to do. I said, look, let's figure out this SINs petition. So I have that officer who I know and my chief of staff go and try to fill out a SINs petition. DJS didn't understand what to do with the SINs petition. They didn't have a clue as to what to do because they didn't understand it. What I clearly realized is that when it comes to the SINs petition, I think we just need to stop and figure out and train every single jurisdiction on the SINs petition, train and make DJS the true experts. And then whether it's DJS, whether it's a private, I don't know the funding of the bill, but I would make a suggestion that we have to start with the SINs petition from scratch. Because when you look at the numbers, different jurisdictions use them differently. I don't believe that, Prince George's County, they don't really use the SINs petition as much. In Baltimore City, we're not hardly using the SINs petition. And I don't know in Montgomery County, I don't believe they're hardly using the SINs petitions. But then I believe in Howard County, they do use the SINs petition. So what I'm realizing is that it really depends on the leadership within that area with DJS on how that SINs petition is going to be really used. And that's why I do feel that having this group, this commission can look at those particular issues, but it really has to be education of DJS, education of law enforcement, and the education of state's attorney's offices, so we can also have a better understanding. I would much rather say, okay, this 7-year-old, what are we going to do with this 7-year-old? Now, luckily, the officer and my team went with the officer to the school to try to help the mother to see what we could do, because these were all her children. And understanding what she was going through and having the school try to direct her to resources. And that's really, I think, the purpose of DJS. So what I do realize is we want to use the tool, but we don't really understand the tool. And I think that's because the person who owns the tool isn't explaining the proper usage of it.
Because when I was in a community meeting with everybody at the table, that was the concern, is that there was a gap and there was a misunderstanding of the tool, but not being used effectively, obviously. So I'm glad you answered that and raised that point. My other question for you is regarding, just for clarity purposes, when it was mentioned about the diversion program, for instance, if a local police department has a diversion program, am I understanding it correctly that it does not go at all to DJS? I mean, just as for a formal record to say, hey, this kid did XYZ, we have him in the local diversion program, but you don't have to act any further, but you at least are notified, DJS.
We actually had exactly that. And in light of the numbers that I cited earlier, the kinds of cases would be the larceny thefts, the minor drug offenses, and things like drunk driving by individuals under the age of 18. That program, we did divert them pre-DJS, And the first thing that happened is they got an evaluation by Health and Mental Hygiene in Montgomery. They called it SASCA. They would do an evaluation right away to see, did that child need mental health treatment? Did they need alcohol treatment? What's actually happened? That program has evaporated because we don't get that information anymore. It's now gone. Our program is not in place any longer for a variety of reasons. Because and we had hundreds of kids, we did it for about 12 years. Wasn't new to us. And we were doing it. And I appreciate that because I don't know that people recognize that sometimes we did divert kids. And the first thing we did is get them an evaluation by a mental health specialist. What does this child need pre-DJS? And we did that for hundreds of kids every year.
So in Prince George's County, we received referrals from DJS. We still receive referrals from DJS. We work with local nonprofits on cases that DJS does not intend to pursue, but they want to ensure that the kid is receiving services. So they do get intake through DJS, but then DJS does divert them to a number of programs within our community, one of which myself and the sheriff really participate in. And that has been very successful because if a child completes that program, they're done. DJS does not pursue it. I believe their record is taken out of the system. If they don't complete the program, meaning they're referred back to DJS because they are not complying with the terms of the program, then DJS will determine what else they want to do with that child. Now, I think that does provide a level of accountability all the way around because these are kids who are known in our community as having some issues, but those issues are not of the nature that where we think that they need to have a juvenile record and they need to, be taken through a formal process. That has been very successful. In fact, the program that I'm working with the sheriff on now that we stood up over the summer, we not only provide services to the children who are referred to us, but we also provide services to their parents because what we're finding is that parents are dealing with a lot of stress. Some of them have mental health issues that they need counseling for, and they've never received counseling because they're worried about their child, they're worried about their job, they're worried about where they're going to live. So we try to help the parents navigate through those issues so that they can be more focused on raising and rearing their children properly. But it is very deep, and a lot of parents and guardians, because a lot of them are not just birth parents. What we're finding also is that a lot of grandparents are being called upon to be the primary caregiver of children. And that's very difficult because there's a huge age gap, technology gap, everything that you can think of. So having a scenario like that really helps us to understand what is going on in that child's life and how do we impact it. So I did want to say that DJS in so many ways deals with kids extremely well. I think that that in many instances, DJS and the services that they provide are working for so many of our children. I think that when it gets to the more serious offenses, and that's where we're finding that there is maybe not the level of communication and accountability that we need in terms of services. There's a lot of kids for programs for kids who have committed minor offenses, misdemeanor offenses, nonviolent offenses, or even second-degree assaults that may be school fights and things like that. But when it comes to gun offenses, carjackings, other more serious where there's victims involved, those types of crimes, those services, I think that's where we need the greater accountability. And I think that's why this bill is so important. And I think it does provide more transparency amongst all of us and then greater accountability.
Response. I guess, and this is not a question, but just a statement and observation. And looking at the point system with DJS, it almost appears to me that it's more child-centered focus, and I guess that's supposed to be the case. But I guess it comes to the concern of where does the public safety in the community come into play with those numbers in the point system. So thank you, Mr. Chair.
Delegate Kaufman.
Thank you. And let me preface my question by first of all congratulating the chair on a job well done. And I just want to briefly say that I've heard complaints from the left and the right on this bill, which if nobody's happy, it tells me it's a pretty good, reasonable bill. But my question is this, Mr. Bates, you talked a lot about consequences and, accountability and things like that for kids. And so I appreciate that. But the focus for DJS, going back a little bit to Delegate Crutchfield's question, is rehabilitation. So how, in your view, does this advance rehabilitation? Because unlike the adult penal system, the goal is not punishment at the juvenile system. It is rehabilitation. So how does this advance rehabilitation, which is the mission of the agency?
Without a doubt, I think this bill does it. In the way, for instance, let's take a hypothetical. Let's take a young person who's in a vehicle and the vehicle's stolen. And it's a misdemeanor. And they go ahead and plead what's called a fact sustained to the misdemeanor of unauthorized use. Their probationary period for any programming would be 6 months. But let's say it takes 3 months before they're ever able to get in a program, and there's an 8-month program. They may start the program, but they don't finish the program. It's very important that when we have the opportunity, we do not want, and I do not want, none of us want our young people to be ever involved in the criminal justice system. Our goal is the services. What we realize with this bill, it allows the opportunity for the young people to be in the program, to receive the programs that they need so they can have the rehabilitation that they really need. At the end of the day, everybody wants the same thing. We want positive young people. They are our future. No matter what happens, those are our children. And we need to ensure that our children, one, are held accountable, but also more importantly, they understand the natures of their actions and they are prepared now with this, what they need, so they never have to have those types of actions or interactions any longer, and any services that they need, that they are there for them to have. That should be the goal.
Can I ask a follow-up, Mr. Chair? Thank you. I understand what you're saying, Mr. Chair, but I mean, I've elevated you, Mr. Bates.
No, I definitely do not want that job. Oh, please, no.
Your neighbors, I think.
I'm already where I am. That is my delegate who's doing a phenomenal job. And let me just say how much I appreciate the work that my delegate does.
But so
I'll let Delegate Edelson know.
I appreciate that response, but to me, and I've learned a great deal from the chair and he's educated me a lot, but to me, it's also an issue of funding and more of a conversation for Chair Barnes in the Appropriations Committee, because there's such long wait lists for these programs. So it may not be, is it sometimes the case that it may not be the child's fault that they didn't get into the program while their probation was ongoing, and instead an issue of wait list and funding?
100%. And I think that all of us up here in agreement that there needs to be the proper funding for the proper programming for the children. The children should not have to wait to receive the services that they need. I think that is something that's very important to ensure that they can and will receive the programming that they need as quickly as possible with young people.
Delegate Phillips, then Taylor, then, well, he's not in his seat. Phillips.
Thank you, Mr. Chair. And Mr. Chair, I know this has been a challenge. As you mentioned, we spent hours during the interim listening to a number of stakeholders on this issue. And I have filled up a notebook. And so it's going to be really difficult for me to slim down my questions, but I know I have to because you'll stop me. And Mr. Bates and I have sat and had numerous conversations over this interim. So one of the things that the chairman mentioned is this issue of silos. And I know you've mentioned that the commission will go a long way to helpfully break down those silos. But my concern with the commission, I don't have a concern with the commission, but that really is after the fact. And it's actually at the macro level. We're dealing with children at the micro level, individual children. What can we do to break down the silos on the front end. For many of you, you've said to me that you need to have information earlier in the process so you can make some decisions. At the same time, I'm not a fan of adjudicating children. I'm not. And so the question is there a way that you could assist us with breaking down the silos without taking them through a juvenile justice process where they get adjudicated?
Well, a couple of things. One, I think first and foremost, the most important aspect is going to be the intake. For instance, when you look at the violent crimes, when you look at the handguns, but then also the nonviolent felony, i.e. car theft. One of the reasons we need to be involved, meaning we, the prosecutors, as quickly as possible, when you have a car theft and unauthorized use of felony and a misdemeanor, they look exactly the same. But also you have to remember that now the victims. If we're going to put together a car case and we don't receive that case from DJS for 15, 25, 30, 60, 80 days, then we've missed our window of opportunity to put together a good case, to talk to the victims, to talk to the witnesses, to have the officer do what they need to. And that's why those cases in terms of nonviolent felonies, such as car thefts, are so important to allow us, meaning prosecutors, to be there at the front end. It's also important for us to understand what young people may be having contact or may be been arrested with the police, because we're finding out some are coming back 3, 4, 5, 6 times. If we would have been able to steer them toward their services day one at that first contact, then that is our goal. We have diversion programs. Our focus is not to have young people in the criminal justice system either, but our focus is to ensure that young people are, one, held accountable for those actions, because if you divert the unauthorized use, the owner still has a $500 to $1,000 deductible. Someone still has to be accountable, and these young people are still in that individual's car and they've still broken the law. But what do we do with that person, that individual? Tell them, oh, well, here's your car back. You have to just suffer the consequences, but for us, it's a balancing. And if we can be involved at the very beginning with this young person that's in the unauthorized use, that's a mere passenger, hopefully that young person is never the individual who's now charged with the theft of the vehicle, or God forbid, a carjacking the vehicle. That is why it's important for us, we feel, to be involved at the very beginning so we can ensure that they are getting the services with DJS that they need.
I appreciate that. Hold it. All due respect. That was a prosecutor's answer. And it still did not address how do we break down the silos so we look out for these young people. That's what I want to know. So if we can get it, if you are involved earlier, so we can take care and make sure that those persons who have been harmed, they feel like they're being addressed, their issue is being addressed. But at the end of the day, I'm worried about, once again, over policing and over adjudicating our children. And what you just described, Attorney Bates, was how we take them down the process of adjudication.
Yeah. So can I just say this? So when someone commits an offense, most of the offenses we're talking about here are victim offenses. So there is a victim on the other side. And sometimes that victim is a child too. So we have to absolutely teach our children empathy. They need to understand right from wrong, and there has to be consequences. Now, I think that understanding where they are earlier in the process helps us to evaluate the treatment plan for that child much earlier. Similar to most cases in the justice system overall, most of our cases are handled through a negotiated plea agreement. So if we know the child's history, if we know any diagnoses that they might have, what their ACEs are, any adverse childhood experiences, anything that is informing that child's behavior, the earlier we know in the process, the better decisions we can make when making recommendations to a judge. But mind you, we also have to keep in mind that we have a community and we have a victim to also protect, and the child needs to understand that it's not all about them either. A lot of our young people, it's about me. But when you commit an offense, you're impacting somebody else. You're impacting your community. They need to understand that too. But in terms of what we're asking for in this bill, and I think what the chair and Madam Speaker, they're addressing, is the fact that we need that information earlier in the process so that we can make appropriate recommendations. We don't always recommend that children get locked up. In fact, most of the times we don't recommend that the child is detained. We're recommending treatment. But once we get that treatment plan together and everyone's in agreement with that plan and the plea is accepted and the plan is in place, then that plan has to be effective. It's got to work. The child has to get the treatment on the timeline that's recommended. So that's why I think this bill helps us, because it brings us into the process earlier, and it gives us an opportunity to make appropriate recommendations earlier in the process.
May I ask one other question? And I know we have opportunities otherwise. Has to really do with the expansion of the crimes, particularly for 12 and under. My sense is we went maybe a little bit further than we needed to. When you look at the number or the types of crimes that we now potentially are charging children with, 12 and under, in my discussions with most folks, guns, cars, we've gone beyond that. Do you have any statistical data that suggests that 12-year-old and under are doing a number of other things much more frequently than they did before?
But the only thing that somebody mentioned this earlier, it might have been the chairman who mentioned that there had been 11. I apologize if I say the wrong number, but apparently when you were doing the study, there had been I'm assuming that the numbers would be relatively consistent, that you're talking about a cohort of individuals that were charged be about 1,100, but you would have to carve out, and I don't know that we have those numbers. They're probably attainable, and maybe the chair knows better than I do, that we could carve out, based on the information was maintained by juvenile services, we could carve out for those categories of crimes. Let's say if it's auto theft, or a lot of people talk about second degree assaults, because I get calls all the time from my school leaders about violence that's occurring inside their schools with 10 and 11-year-old kids. And they say, you've got to help me. I'm losing control of my school. So whether it's second degree assault, whether someone mentioned third degree sex offenses, again, I think maybe the chairman mentioned that, we can probably cull those numbers out. But I'm going to just cite the number I heard here today, which I didn't know before, very quickly. It was higher than I suspected it would be if I was going to be, when I heard that, but I heard 1,100 earlier.
And I'll clarify my comments. It's 1,100 total across all crimes, as opposed to those specific crimes that are included in there. I don't have that number right in front of me, but I'll get that to the committee as I can. All right. I'm going to try and keep things moving a little bit. I'm going to ask the members of the committee to be succinct in your questions, please. Delegates Taylor, Simmons, Tolles, Crutchfield.
Thank you, Madam. Thank you, Mr. Chair. What scares me is that we would enact this type of legislation, or this legislation, and kids at an even younger age would be detained for even longer periods without the adequate diversionary programs in place. Do you believe that this legislation goes far enough to address, and maybe this was a better question for the previous panel, the funding, the capacity, the variety, and all the other needs of our diversionary programs to meet all the different needs that our kids have? Do you think that if we enact this legislation, that we'll be ready?
Well, I think we have to start somewhere. I mean, just like, this body did when it came to the blueprint for excellence. The question is, did that go far enough? But we had to start somewhere. We have to have some aspirations, some goals for our young people. And again, this bill is really designed to say that, everybody in the system has to be held accountable, including you all as the legislative body, to determine what resources do you need to put into this system. But how do we do that? We need to evaluate what's happening now. We need a board that can come together, a commission that can come together to talk about what's working, what's not working, what's needed. I think this bill goes a long way to providing that framework of what we should be doing for young people in our system, and then holding ourselves accountable at the end of the day to making sure that the resources are there to execute on this vision. Again, I think we have to have a vision.
Yeah.
And the reason why we are here is because we have seen a rise in violent young offenses committed by young people. We're not here just as an exercise because we think it's interesting to have a debate about youth crime. We're here because all over the state, we're hearing from our constituents, we're hearing from our schools, we're hearing from our children. We're hearing from our children. If you talk to children, they are scared, many of them, in their schools and in their neighborhoods. So we have to do something. And I don't know that any one thing is going to be perfect, but what I can tell you is that we believe that this is a substantial step in the right direction. Should there be tweaks? Do we need to debate some of the provisions of the bill? Can we make changes? I'm sure that your chair and Madam Speaker and on the Senate side, that those discussions will happen. But I think that the goal is to do something to advance public safety and to address the needs of our young people. And I think this is a very good start.
Can I just, I love your question. And I loved your question because I always thought that if you were going to really reform juvenile justice, why wouldn't you begin with the segment of the system that deals with 70% of the kids? And I think I really do think that we need to take a very close look at whether we have adequate programs for the kids. And I think we all have that sense that providing programs and education is the key to our way out of this. But at the same time, I think there were some changes made that where I think there's some unintended consequences that have come about from some of these changes that I think there is an attempt in this bill to address. And the concerns are uniform. And again, look, there's 3 of us here. I think we're pretty representative of the other 24 or 23. But in any instance, again, I just think we started in the wrong place. We should have started with juvenile services and make sure the programs were there, then do what else you're going to do. We just started wrong.
Welcome, state attorneys, and just want to start off by thanking y'all for all the hard work y'all are doing in y'all space to try to balance our society in the way that we're dealing with our young people today and all the programs that y'all are championing. I think one of the questions for me, when we look at a lot of problems that are going on to support the young people and the families, right? So we often not talk about the families of these young folks, but we talk about them like if they're in the world on their own, they're not. As we look to do more to support families in the space, and as we look at the criminal justice system and how so often right here in the state of Maryland is that pathway of young people turn into adults going into our prison system, as we look at the racial disparities in our criminal justice system, as we fight to make moves, my question to you is this: is your job as a state prosecutor is to defend those who have committed the crime, those who are victims of the crime, or both? And do you find that at more than once, your hands are tied no matter what you do?
I'll take a stab at that. I think my job as a state's attorney is to uphold the law. And, but also in upholding the law, we're also the ones who are going to be the voice of the victims. But we have to ensure the criminal justice system is fair to everyone, and that we basically make sure that the laws that are in place, that they treat everybody the proper way, and that we do not do anything based on our personal issues, our personal biases, to harm the integrity of the criminal justice system. And when I look at it, that was what I believe the role of the state's attorney, the prosecutor, is in making sure that we protect the citizens of our jurisdictions that we've been elected.
I like to state attorneys on the panel.
Yeah, the laws are clear around juveniles and how they should be treated in the justice system. The standard there really is best interest of the child. We're looking at what is in their interest. And I liken it to growing up. My parents had my best interest at heart. But if I did something wrong, there were consequences. Didn't mean that they didn't love me, didn't mean that they didn't want the best for me, didn't mean that they didn't believe in me. But what they did want is for me to understand right from wrong and to make better decisions in the future. And I think that as state's attorneys, we have to appreciate that that is the law here in the state of Maryland. And I don't think it's wrong. I think it's right. Really, the question is, how do we get to that place of providing what is in the best interest of the child? And sometimes we may disagree on what that looks like. That's why there is a judge that ultimately determines what it's going to look like after hearing from us, after hearing from DJS, after hearing from defense counsel, any experts that may weigh in on the subject matter. So, I think that we just have to stay true to upholding the law, as my colleague said, and embrace the goals of the juvenile justice system, which we do, but understand we have a very important role to play, and that is a role that focuses on public safety as well. And to me, there's nothing wrong with children understanding that they have offended someone, to make the appropriate apologies, to feel empathy and sympathy for someone else and their loss. I mean, that's very important when you are looking at building character, helping to rehabilitate someone. So I think all of those things can happen. It's a tough job. It's not easy, but it's what's required under the law.
I think our primary job is to keep our communities safe, both in their homes and their property and their families and their loved ones. I will also say, I think the if you do it better, or if you want to be really successful, be creative. Be creative in creating. Aisha talked earlier about a program that she started with her sheriff to deal with kids there. We have programs. We have Speak Up, Save a Life, where we talk to every high school kid in my county about the fact that 1 out of 3 teen relationships have violence in them. We try to prevent and teach proper ideas about respect and for one another as you begin your dating relationships. Long term, maybe reducing domestic violence in my community. We have opiate programs. We have gun programs. We run the truancy prevention program in my county. It's run out of my office. I started it 13 years ago, where nothing's punitive about this. It's about getting kids to go back to school. Because quite candidly, if anybody in this room doesn't think that the rising rate of truancy is driving a lot of this juvenile crime, we all know that that's true. We all know that's true. So if there was an objective for the state attorney, creative program, do something that makes sense long-term for everybody and get kids back in school. And so I think it's keeping us safe, but doing it intelligently, using education as a tool to making us safe, whether it's drugs, whether it's guns, whether it's just not going to school. And we can do that.
Thank you, Mr. Chair. And so what State's Attorney indicated, McCarthy mentioned frequency just now regarding truancy. I believe that one of the things our children, or one of the issues I believe our children have is, yes, I will tell you, and I will continuously say that children do, whether you're young, 11, 12, I think you do understand, you do know what's going on. I do think you have a level of what's right and wrong, but what I am concerned with, at least in terms of a legislature, is how our kids experience trauma. And how they come to school. So while they may know what they're doing, how do you deal with that when you have so much trauma going on at home? So it's not just truancy, as you indicated, it's truancy and trauma. And so State's Attorney Bates, I'm looking at your letter. I have a stack of all the testimony here, and I'm looking at your letter, and you reference a lot while you were sitting up here regarding services, and a 6-month, 1 year, based off your testimony you put that you submitted to this committee, a 6 months to 1 year minimum for misdemeanor felony charges respectfully are not enough. So you support increasing that time period to ensure that children are rehabilitated and can fully appreciate the services provided.
And so can you tell me, how do you believe this bill will help with rehabilitating our children and dealing with trauma in our community? How do you think this bill will go toward helping that?
Well, one of the things that I think about is with young people, have they had the opportunity to complete a program? In Baltimore, there's a program, ROCA, and ROCA deals a lot with gun violence. It's a 4-year program. And what it does, it talks about dealing with the trauma, talks about the way they think. It talks about them growing up to be real people. And I think to me, it's very important that when you have a program, that the young person is allowed and supported to complete their program for the rehabilitation purpose, because it holds them accountable to say, okay, I violated the law. I'm going to go ahead and be in this program. And the program also deals with their issues. And that's why when I sit down and look at a program such as ROCA, that to me is a very important program in allowing. This bill says we can extend the time periods to allow the young people to complete their program. That's how I look at in terms of the probation, not i.e. a punitive, but is it long enough to allow the young person to complete the program to get the rehabilitation that they need?
Had that program in place, right?
ROCA?
Yeah, how long has ROCA been in place?
ROCA has been there, I think, about 4 years, 3-4 years in Baltimore. I view it as being extremely successful. I think it's one of the reasons, excuse me?
Extend the time if it's been very successful.
Well, a number of those people have been in the adult system, and sometimes they're focused on the adult system. But there are a number of other programs. For instance, you have a young person with a misdemeanor handgun, then they're receiving, say, a 6-month program. And say the program is 6 to 8 months, depending on the DJS program. It may take 90 days to even get into the program. So before you know it, then they may not get into the program because they're going to they may be finished their probation before they're able to really be in the program and complete the program. To me, if you are not looking at an arbitrary time period, then maybe you sit down and say, we will place you on probation as long as it takes you, the young person, to complete the program.
And just in that system, in the juvenile system, they do have statuses pretty regularly to determine whether or not, number one, the child has completed or gone to the program, how they're doing in that program. So oftentimes the juvenile judge is asking, how are they performing in the program? Are they receiving services? Are they showing up? And sometimes probation is actually, they end their term of probation early if the child is doing well, because the goal isn't to have the child on probation forever, receiving services forever, if they are rehabilitated. But if they are not, which happens many times, kids don't go to the programs. They are not going to school. They're not doing the things that they're supposed to be doing while on probation. And then the question is, okay, now their arbitrary probation time ends. They haven't really received adequate services. Now what do we do? So those are the kind of things that we see. But certainly if a child is rehabilitated prior to the end of their term of probation, oftentimes judge says, okay, well, you're done. DJS can recommend that their probation term end, and that is, or terminate. And that is not unusual either if the child is doing well.
Thank you. I'll have follow-up for DJS I don't know if they're on the panel, if they're coming in, but follow-up for them.
They're not, but you can follow up with that.
Thank you. Thank you.
Delegate Crutchfield, then Pasteur, then we're moving on.
Thank you, Mr. Chair. And thank you to all the state's attorneys to come and provide their point of view on the legislation. I think I'm going to focus in on my own state's attorney, Mr. McCarthy, for a moment.
I think we've had this conversation.
I think we probably have numerous times. You know, you mentioned the rise in violent crime in Montgomery County, but you only provided one number regarding youth. And you said with carjackings that have been completed, there's been what, I guess 70% of those where it has been
where there's been an arrest.
Well, okay, where there's been an arrest, it involved a youth. Do you have the breakdown on the ages? Because again, as you probably heard earlier, I'm very concerned about the new charges for children between the ages of 13 and 10 in this legislation. So do you have the breakdown on what the age of those children were in the carjackings?
I know the tracking numbers, the information I got directly from the chief himself, Marcus Jones. I would assume that they could, I do not have it. I can likely get it.
And if you have any numbers regarding children committing any crimes around gun crimes? Do you have anything around crimes involving animals or any of the other new charges?
Are you talking about under 12 or overall?
I'm talking about under 12, under 13. That is what I'm talking about, 13 to 10-year-olds, okay? Which is the focus of these new charges in the legislation. So if you have that, if you could get that to me,
I
I'd
think
really.
those are obtainable numbers. I do not have them.
Okay, but I'd really appreciate that to understand that, all right? And then the other thing I wanted to ask you a little bit about is that there is some language in here, I think that you truly support regarding state's attorneys now having overview or actually getting, I guess, or being able to review complaints for those children that have already been under DJS guidance. There is language in here that talks about further overview by state's attorneys. And so what I wanted to understand from you is, what are the consequences of that? If, for example, you had a child that was one of the children that was arrested for carjacking, and now that child is able to come under your review, what happens next with that child?
That particular portion of the bill is not a portion of the bill that I've ever discussed with anybody before, nor am I particularly familiar with that aspect of the bill.
But I know we've had discussions about this generally, this area, and your belief that there should be further overview by state's attorneys.
Right. Let me say, I am completely in favor of us having the right to review all felonies. Right now, there's a great difference between crime of violence, which would carry things like carjacking, and felonies, which would be things like distribution of fentanyl or third-degree sex offenses or auto theft. I think we should have the authority to oversee them. I think everybody has their own examples of this as we've begun to discuss it. The one that basically caused me the most alarm is when we had a young man that was sent to us on his 7th car theft. We never heard about 1, 2, 3, 4, 5, 6. He was held at intake 6 straight times. And then we got he was reported to it. And this is something that your communities are concerned about. We get him the 7th time around, had no information whatsoever, nor did we ever know the first 6. We know it now because we got 7, but we didn't get 1, 2, 3, 4, 5, 6. And I think anecdotes like that I hear around the state where people are being consistently held at intake in matters where we would like, and we think the community may even be demanding that we have some oversight over that because they expect us to keep them safe. And without that oversight, we can't do that.
To that child.
Well, every child is going to be treated individually. I don't know that I can answer that question.
Right, I understand
It really depends
that.
upon the child and the circumstances.
I understand that, but what are the possibilities? What could happen? What are some consequences that could happen with a child like that?
Are you assuming if we have oversight? If we have oversight, there is the possibility that the state's attorney for that individual county could decide that they wanted to paper and charge a delinquency in that case, or they could refer it back to juvenile department, or they could screen it, because just because a case comes to us, by the way, doesn't mean we paper it. I'm sure that Ivan and Aisha can tell you what their numbers are, but just because a case gets forwarded to the state's attorney's office doesn't mean the child automatically gets charged. It means it's reviewed. We may look at it and think the statement was taken improperly, the search was bad, we can't prove the elements of the offense. It's somewhere in the order of 20% of the cases that are forwarded to us, we find we can't go forward even if they're sent to us. We do our job as lawyers then.
Or anything to support what you would do in a situation with a child. That's what I was focused in on. And you just mentioned, 20% of overall cases.
You might review it and
okay.
You may send it back to DJS. You may review it and dismiss it because it's not a viable charge. Or you may prosecute the case.
Okay.
I guess there's 3 options in every situation.
Thank you.
Okay, thank you, Mr. Chair, and I want to thank you for coming, and I particularly am happy to hear the things that you really have said, because it does remind all three of you, particularly you, Mr. McCarthy, and I'm gonna come back.
I thought you were looking at.
No, I'm looking at you now. But all of this conversation does remind me of the African proverb that says, when the children don't feel the warmth of the village, they will do what? Burn down the village to feel that warmth. And someone asked me, what does that mean? Come on, that's dumb. But I have heard delegates today ask the question, and you know what I particularly like about what you've all said? You've all said and shown your real humanity, because sometimes I've looked at these bills and these conversations about what we're going to do with these children, and listen to person after person say that, and I start wondering, but where's the humanity? Do they not know these are children? But each person, beginning with the speaker. So I'm going to get to the question, which is, so process. Why, as you said, Mr. McCarthy, we did it backwards. Okay, we did it backwards. And you know what? Sometimes what we produce on paper is how we even staple it. Because it takes 17 pages before we get to having commissions or groups who are going to hold folks accountable for making sure we are taking care of our children. 17 pages before we do that. And we've had commissions before. Lord knows I'm making him the speaker, the chair and I, and the vice chair, because I called her one morning and said, I'm a quit. I'm not a quitter, but I'm done. You said education. The speaker said that the system has to catch up. This is where we are. So who this time is going to be accountable? Let's start with that question. It's in this bill. From 17 to the end, who's going to be for real accountable to make sure that this time we're going to have people who are going to review, have oversight, and who are going to be deliberate. We let MSDE fiddle and diddle around with what they were supposed to do. And then we said, okay, let's just have a whole new system. That's still not happening. So that's my question. You've all said it. I know you're good people. I like you because, see, when I met with Mr. Bates the first time, I was real prepared to not like him and go real Sheriff Pastor on him. But he said, so I'm gonna tell the truth right now and say the devil, did you not say to me, and be very careful, because I sort of like you, so be real careful. Did you not say to me that adults, we as adults, first victimize children, and now the children are victimizing other people? And I said, well, I've never heard you say that in public. I need to hear you say that. Didn't you say that? That's a question.
Well, you know, without a doubt, I did say that, but I also look at it like, you know, we love our children. Like, you know, I got a 7-year-old daughter, and some days I have to give tough love. And sometimes when I sit her down, I run around the corner and I'm tears all up in my eyes because I'm worried she's gonna still love daddy. But I know if I do not give the discipline she needs in that household, she's gonna go out to this world and it's gonna be a rough, tough world.
You don't give the discipline in that household, she will go out and be a wackadoodle, and a wackadoodle in jail, right? Come on, don't cover your face.
And
okay,
well,
in jail.
Yes.
But what I'm saying to you is that question, and I want you all to answer it. We have it in here. That's a good part and a beautiful part of this bill. We have laid out a structure as before, but we have laid out a structure to make all of us accountable. I want to know we know who's going to be responsible in the first 16 pages. You, the police, everybody. I want to know who's going to be responsible from page 17 to the very end for making sure that we don't, or you won't, because I would not be sitting behind this desk. But who of you in a few years are not replaying this and saying that what we passed did not work?
I mean, I think what this does is it makes holds all of us accountable. You know, there are provisions that say, okay, the child's accountable. There are provisions that say, okay, prosecutors and DJS and all of us need to talk to each other. But ultimately, all of us, including the legislature, has to work together to make sure that the resources are there for our kids. We have to identify what the needs are. And I think that, you know, having a structure where there is accountability to participate in programs that are ordered, so that we make sure that we have adequate programs available to our children, all of that is that is the adults in this room responsibility. We should be advocating from the state's attorney's perspective. You all should be looking at ways of helping us fund it. The governor also has a role to play. The governor was at the press conference, from what I understand, when this bill was advanced by the leaders. And I think that shows a commitment from the highest levels of government to support some changes, some reforms, not just for the sake of our children, but for the rest of us too, that we all have a role to play.
Society, you kill the children, you kill the whole thing. So that means when the commission comes back to whomever to report, or commissions come back to report and make recommendations, then from the legislative point of view, and from the state point of view, and from appropriations point of view, folks cannot just say, oh, okay, file that. Let me just file that report. Oh, that was nice what they said. Now we have to give some backbone to it and say, okay, this is what they came up with, because you're right. When children don't get consequences, they really believe that they can go out and do whatever. And that goes to another bill out there where we're now trying to look at people who are incarcerated, who were incarcerated when they were teenagers.
Isn't that so? Okay, sounds good. It's 2:00. And there are a lot of people who want to speak, but thank you all very much. We do have another 2 more panels in favorable with amendments. And then we have 5 panels in opposition. So we have quite a few people left to go. I'm going to ask, and I know I'm this, my name's on the bill. I got it. I want to be respectful for people wanting to ask questions. I'm going to ask, perhaps beg and plead, questions, not speeches, the rest of the way, please, so that we can get to everybody and give them the opportunity to speak. With love in my heart to everyone here. Now, Scott Schellenberger, Laura Wilt, Steve Kroll, and Russell Hamill has signed up from the Chiefs and Sheriffs. Whoever would like to go first.
Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. Obviously, I'm here in favor of House Bill 814. I would agree with the statement that someone made. People on both sides are not perfectly happy, but I think this is an excellent step forward that does a lot of things that I think we need to do. When you see and hear the expansion of the jurisdiction over a child as young as 10, particularly the delegate's description of a third-degree sex offense, I think it certainly goes a long way in making folks understand why that's being added. I know that juvenile court is private, and I wish that you all could go in and see a courtroom, because it is not a very adversarial place. It is all a place about everyone trying to get to the bottom of what issues
that child and his family have and how they can help them. And that's what everybody's goal is in the juvenile court. It's nothing like when you go into an adult court and you're in circuit court and you're on a violent crime. Even when we're talking about a violent crime, the juvenile system is completely designed to help the juvenile and the family. One of the most important things I think that this bill does is it expands the length of time for probation. Now, everybody may say, well, isn't that harsh? No, that probation is designed to get to the root of the problems that juvenile has. And if you have to wait 3 months, and unfortunately, there's a waiting list for a lot of these good programs, and I was happy to hear about the $350 some that is being devoted to expanding the programs. I think you should put more money into the system so that the longer we help these children, the less likely it is I'm going to see them when they're 19 years old and they've killed somebody. So I completely agree with this. The length of probation is not that bad, and I think it does a lot to make sure they get the right kind of treatment.
All right. Good afternoon. My name is Laura Weldon, the Chief of Juvenile in the State's Attorney's Office for Frederick County. Been doing it in the courtroom for 15 years, run a number of diversion programs. I want to thank the speaker and the chairman for their words starting this out and the words that have been spoken. I couldn't agree more with the purpose and the intention behind this. I believe I do support the passage and the recommendation to pass this bill forward. I believe it gives our community a more meaningful response to some of the crimes committed by those under 13. I would love to, if you ask me, I'll explain why the SINs provisions are just not an adequate response, and why the questions about the Department of Social Services, neglect, those things, they don't have jurisdiction in these situations. So we can pull them in, we can ask for help, but they cannot take action as we would like in these scenarios. Secondly, this bill would allow for the court's probation to be more meaningful. If our youth choose to do nothing on their probation, the current law, it's a technical, our court does nothing. And I'd love to explain how that plays out in everyday world all across our state. This bill builds in accountability to an agency has lost its focus on addressing juvenile crime, lost its focus on protecting our community and accountability of our youth by the placement and the description of the commission that's put in place, and also by the state's attorney's office review put back in place for felonies. I can certainly explain how that is handled by the juvenile prosecutors throughout the state, how we review those and what we would do with those. I believe that this is a good compromise bill to address some of the problems that we have out there in our community. Thank you.
Hey, Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland State's Attorney Session in prosecuting cases for 39 years. And I asked for a favorable report as to HB 814. I want to thank the chair, thank the speaker, thank the vice chair for their hard work in this bill. I want to bring one attention to an amendment that we'd like to see done. If we look at page 6, line C, where it says C, it says, an intake officer shall make an inquiry within 25 days. Now, the amendment is 15 business days as to whether the court has jurisdiction, whether judicial action is in the best interest of the public or the child. The question comes up is, what if that 15 days cannot be completed in time? What happens to the case? And I'm not sure, and I don't want to see litigation about a case being dismissed because we haven't met that 15-day rule. So I think there can be an amendment that can be added that says, for good cause shown, it can be expanded. So I make that amendment. It's just a minor technicality, but I'm afraid about what can happen and what can be argued. But overall, this is an excellent bill. And on behalf of the 614 prosecutors that we represent, we'd ask for a favorable report as to HB 814. Thank you. Happy to answer any questions.
Good afternoon. I'm Russ Hamlin, representing the Maryland Chiefs and Sheriffs today. We support House Bill 814 while respectfully requesting a number of amendments to be considered. First, we want to sincerely thank the Madam Speaker, the Chair, and the Vice Chair, and this entire body for this discussion today. This will undoubtedly help lead to make our community safer for all, not only to live, but to thrive. Juvenile-related crime issues have become a major concern in the communities we serve across our state. We hear it consistently from so many people, community meetings, events, and other gatherings. And when we just meet people and have conversations on the street with them, we often hear expressions of fear and apprehension regarding crime in general, and more specifically, juvenile-related crime, and a lack of accountability for such. Just recently in 2 town hall meetings, this was the main discussion for me and my people with our community. House Bill 814's provisions to expand adult court jurisdiction for more violent offenses, streamline filing processes, expand state's attorneys' review, and bringing parties together to work to improve our juvenile justice system are all well-reasoned and needed in the opinion of the Maryland chiefs and sheriffs. However, we do respectfully request 2 amendments. And Mr. Chair, I think you already took care of one of these, but I'm going to say it anyway when I heard earlier. On page 8, lines 26 to 30, the requirement to complete a written complaint or citation and forward to the DJS if a child is taken into custody may adversely affect many positive, supportive, and successful local diversion programs. We'd like to see that adjusted so those programs can stay in place because they make a positive difference. And we would also respectfully request kind consideration to expand representation of the Commission on Juvenile Justice and Reform and emerging and best practices to include a representative from each of our associations, chiefs and sheriffs, because we represent a wide divergence of communities across the state and have different responsibilities. For these reasons, Maryland chiefs and sheriffs support House Bill 814 with amendments and respectfully request a favorable report. Thank you.
Questions for this panel? Delegate Valentine.
Thank you, Mr. Chair, and thank you, panel. Mr. Chairman, I have 2 questions, actually. Okay. My first question, and I thank the panel for coming in today, is for Assistant State's Attorney Wilt. Could you expand a little more? Some of the last panel talked about SINs and how it's handled from county to county and how it's very different. Could you just expand on how it's handled in Frederick County and some of the successes or failures that you've seen in your career?
Absolutely. And I can answer that question for Frederick County, but I can also indicate I'm part of a group that meets weekly, the chiefs of the juvenile court for state's attorney across the state. And we have asked for data. We've reached out over the last month that this all has been discussed. And we've reached out to our law enforcement across the state and reached out to our juvenile services to ask that question. And I do agree that SINs is not used uniformly and training is needed. Because SINs is a tool that we should use and we should use effectively. However, with that said, no one should be fooling themselves to think that SINs can address the issues that we're hearing in the way the statute's written in our town halls, in what we're talking about here, the most serious offenses or the repeat offenders. Primarily, the reason why it can't be effective in some scenarios is because it is a voluntary process. So it is a recommendation of services. It is a meeting by which, so a citation is written or a referral made by a law enforcement or a civilian. That referral can be sent. My diversion program takes them. Some may not. Or it goes to the Department of Juvenile Services. Department of Juvenile Services sets up an intake. At the intake, they meet with the family and they meet with the youth. During that intake, they hear information, they gather information, they make recommendations. They can refer for services. I do see the department saying we can utilize all our resources. They offer what they can if they have slots, if they have. So we really need to say, not what do you have in one spot, area of a country or state or another, how many slots do you have? So if they have them, they will recommend them. And then what we have to be, I believe where SINs falls short is that if a family looks back at you, a parent or a child, and says, I'm not interested. I realize I just beat up 6 people in my neighborhood or, whatever bad scenario you want. I'm not interested, not doing it. Parent says the same thing. We're done here. SINs is an ineffective tool if you have a lack of interest in being involved. So there is a provision where it allows them to DJS to file it in court. And I know when the secretary was testifying in various scenarios, it made it sound like SINs petitions go to court. I know of one in 15 years in two jurisdictions. And the problem is I don't want these to go to court, because guess what a court can do? Nothing. They can look at them, recommend services, they can temporarily shelter them and then send them back home. I would indicate there's 5 total shelter beds available in the state of Maryland owned by the Department of Juvenile Services. So is that where SIN's kids are going to go and then go right back home? So, thank you.
Second, thank you again. Thank you, Mr. Chair. Again, for Assistant State's Attorney Wilt, can you touch on this bill will extend probation, and I'm looking at violation of probations and technical violations and such. How would that impact by this bill, or in your experience about violation of probations, particularly technical violations?
It's a little akin to the conversation I just had about SINs. So if you're on probation and I would point out, if you have a kid that's before the court and they're adjudicated for, say, a robbery, don't you want your court to say, I'm going to give you a chance on probation and I'm going to put a lot of things in place, but I'm taking a risk here. That's what we want our juvenile court to do. And actually, that's what they do. They say over and over again, we're going to give you a chance on probation. This is what you need to do. Do this therapy, put this in place. But what's happening now is, again, the scenario, the kid's like, I'm not going to the treatment. A parent looked at me last week in Frederick County and said, that therapist is not coming to our house. Nope, no one's coming to our house. And, a good question, why not? Right? But DSS doesn't have jurisdiction to come in and just open up a case. They can't. Unless that kid says they're neglected or abused, they can't. There's no report because mom says no. So that child that says, no, I'm not doing probation, unless they commit a new crime or completely abscond, then the court can only say, please, will you please do it? And so if you ask for data, I know that's been an issue. What's the data? Well, how many violations have been filed and how many times have you not been able to do anything? Well, I mean, I feel like we're all intelligent people here. I'm smart enough to know that if Johnny's on probation and I bring him into court and his public defender says, as they rightfully should, because it's their job to explain the law. The public defender explains the law and says, they can't do anything. Like they can't place you. They can't take you from your home. The court is looking at them and they look at, sometimes the magistrates look at me and why are you bringing this in? Now he understands that he doesn't have to do anything. So unless we give our probation some teeth, we're going to have a real problem with enforcing this.
I'm going to jump in with a quick question, then go to Delegate Grammer. You talked about absconding, and there's part of the bill that talks about technical violations, and that currently under the law, absconding is not a technical violation, but added into the bill says that it is not a technical violation if someone has 2 unexcused absences for a treatment program. And I've said to members of the committee, I've said to the public before, with that section of the law or of the bill is certainly something that we're looking to better define. There's a question that I have related to sort of the middle ground between that position and absconding, and trying to find some place to ensure that juveniles are actually engaged in what they're assigned to do under probation, while at the same time, having some leverage short of having to demonstrate absconding. Can you talk a little bit about the standard that's set with absconding and as opposed to that, and what we'd be looking at?
Well, absconding at this point is leaving the jurisdiction of the court. So having this language in the bill that indicates if they miss 2 unexcused treatment sessions addresses the entire purpose of juvenile court. Juvenile court is every action the court has to take has to be focused on the rehabilitation of the youth. So even if the court finds that they're in violation of their probation by missing appointments, say 2 unexcused absences, and they're in violation of their probation, the court still has to make a finding about what action to take, and if it's in the best interest of the child or the community, whether or not the needs of the youth demand such action. So I do think that a non-technical violation of probation must include, as is addressed here, their lack of response to a rehabilitative program. Otherwise, that's what juvenile court's about. So if the kid's gonna say, well, I'm not doing rehabilitation, we've got to include language about them refusing that treatment. Whether it's 2 unexcused meetings or 4, I think all of that could be discussed. I don't think it matters. The point is, if they're not doing the rehabilitation, they're not doing juvenile probation. I mean, that's what it's about.
Chair. So in Baltimore County, we had joins, and we used to be able to require diversion of some youth for some crimes. But now, without the ability to arrest certain youth, maybe of a certain age, we've actually lost our ability to divert. You want to comment on that?
Yeah, so Chief McCullough's here, and I think he has some suggestions about how the bill needs to change to revamp and be able to continue that program. So you'll hear a little bit more detail from the chief. But I certainly think that we definitely need that diversion program, because Joins works very, very well in Baltimore County. It's one of the really good programs that we've had for a while. And so you'll hear some more from the chief about exactly how he thinks we should fix that.
Thank you.
There you go.
Ask one last question and go to the question of currently the law says that if there's a non-violent felony, that the department has the ability to send the child to a diversion program as opposed to forwarding the charge to the state's attorney. The bill would take that out and say that all felonies go and crimes related to guns go to the state's attorney. In my conversations with state's attorneys, and I made reference to this at the beginning in my testimony, my understanding, the big reason that state's attorneys want to have that access is so that they're aware of what's going on in those cases, so that they can get those cases ready. I know this is verging on a leading question. I'm going to get an objection from the back of the room here in a minute, and that's fine. My broad question, though, is if the state's attorney was actually getting information about those cases, but the child was still going through the DJS diversion program, does that solve the problem from the state's attorney's perspective of being able to address the issue if the child doesn't successfully complete the diversion program?
So if I could put out one answer, and that is that it's my understanding that the department's policy now is that if, say, a victim appeal, if for some reason the case goes to the state's attorney's office, they have already handled their intake. Their policy is to allow that child to continue with the services while the state's attorney makes up their mind about whether to proceed. So let's say at the intake, DJS recommended that they go into a certain therapy, and DJS was providing that. Because it was referred for review to the state's attorney's office, the department has not, and I'm thankful for that, has not said, well, then I'm pulling the kid out while you decide what you're doing. And they don't even pull the kid out if we're pending a court petition. So when they send a case for us to review, we are deciding, 1, if there's probable cause, 2, whether there's a need for a petition, and we make contact with that victim, have a discussion, see whether meanwhile, while they're waiting on our decision, the Department of Juvenile Services is, as they should, continuing to provide services.
So but to go back, so in the law, the specific area talks about nonviolent felonies specifically without victims. So they don't have a victim. is it possible in your mind to allow the information, I guess, to go forward, but still allow DJS the ability to informally adjust the nonviolent felony without, and if the child goes through that informal adjustment and they're successful, that's fine. But if they're not successful, at least the state's attorney has the ability to go forward with the charge.
Well, if you strike that, we wouldn't get the case. If we're not receiving the case from the department, if the department's just because we're notified about a case doesn't mean we can file on it. So just getting us word that this exists and the department's handling it doesn't allow us the legal right to make that choice, whether to file or not. And I would point out that, as you know, the definition of nonviolent felony versus felony, I mean, motor vehicle theft, there's absolutely still victims. There's victims in in most of these cases.
Okay. Are there further questions for this panel? All right, Delegate Embry, then Delegate Sample Hughes.
Thank you very much for being here. Just to return to this question of the two unexcused absences, or what the right language is to capture a child who is really non-compliant, intentionally non-compliant with probation. I'm concerned with an issue you sort of raised by saying a parent didn't want the child to participate. And kids are often totally dependent on their caregivers and guardians. And so what does unexcused mean? How do we determine that? And I'm just very concerned about that language, punishing kids for things that are outside of their control. So if you could comment on that, I appreciate it.
I can certainly comment on the fact that it has to be volitional, right? You cannot have someone found guilty of a non-volitional act. So if it is the parent not bringing them, and that's the testimony is, I couldn't get there because I didn't have a ride, how's the court going to find them guilty of that? But the court is going to have to figure out how can we get the kid to that treatment if it's the parent that's in the way. So you're held accountable for yours. So that's public defenders with them the whole way. If they're alleging that the state is prosecuting them for an involuntary act, that's going to be litigated from start to finish.
Under the law as written, would DJS be determining this whatever we come up with, but is DJS making that determination?
Well, I mean, I'm sure that they will be one factor, but to be fair, the state's attorney's office could file that violation of probation and say that we believe it's 2. In my practice, you'd have to get a letter from the therapy provider. You'd have to get testimony regarding all the detail, and then the court would have to decide.
Thank you, Mr. Chair. I wanted to go back to the SENS conversation, and thank you for raising that, because that was one of the areas that I had referenced earlier. My point in just trying to get clarity from you is you said that don't be naive to think that this is going to be the tool to help and make all of the better things happen in your community. With that being said, do you believe that it should be a tool that's just totally gone away, do away with because there's no need for it?
No.
Or what would be the answer to get to a better place?
I think it's important to address the bad behavior, if we want to call it that, from the beginning. So SINS is a great tool for those youth just making contact with police for the first time, or maybe you have repeated behavior in the community. It gives the police and the community a tool by which you can have a meeting, discuss, and hopefully make an impact for good early. So I absolutely believe early intervention is critical, and we need to do that. So I'm fully in support of SINS. It's just hard to hear people say that that's a solution for really serious things or repeat offenses that they're just not. I mean, we can all tell stories time after time of youth that we just can't get services. We tried voluntary placement by DSS. We tried everything, and it just doesn't work. So just because you're adding a few charges to those kids under the age of 13 doesn't mean those kids are going to court. It just allows a little stronger conversation at the department and more ability to follow through if they say no.
Seeing no further questions for this panel, thank you all very much. Chief McCullough, Jacka McKnight, Jennifer Bevan Dangle, Patty Crankshaw Quimby, and then virtually Jacob Castro de Almeida. We'll take the people who are here first. Okay, no Jakob just yet. So why don't we start from my right and go over? And so, Chief, please.
Good afternoon, Mr. Chair and members of the House Judiciary Committee. Baltimore County appreciates the House Judiciary Committee's focus on issues being raised by local law enforcement service providers and other stakeholders. We support expanded collaboration and additional resources dedicated to providing juvenile offenders the assessment, treatment services, and oversight they may need. I applaud the restoration of juvenile court jurisdiction over ages 10 to 12 years old for several very serious offenses, including crimes involving weapons and firearms, some sexual offenses, and motor vehicle theft. In addition, I would respectfully request the restoration of additional specific offenses to this list, like arson and malicious burning, and the threat of mass violence. When it comes to arson and in the second degree and malicious burning, arson in the first degree is currently included for juvenile court jurisdiction over youth ages 10 to 12. However, arson in the second degree and malicious burning offenses are not included. It is well established that children who light fires frequently have significant issues that need to be addressed with professional assessments and interventions or treatment. The same is true for animal abuse, which has already been added to this bill. In Baltimore County, we've had serious fire starting incidents by youth under the age of 13 that we are unable to address because of the lack of juvenile court jurisdiction. Two examples are, we had one situation with two youth under the age of 13 who lit a fire in the basement of storage room of an apartment building. They were not charged in that case. Had they been, it would have been for malicious burning. And we also had an 11-year-old who set fire to a vehicle, and he would have been charged with arson in the second degree. In terms of threats of mass violence, the list of crimes of violence in section 14-101 of the criminal law article does not include the threat of mass violence. The crime is found in section 3-1001, which expressly incorporates the crimes of violence contained in section 14-101. Baltimore County has had an incident where a 12-year-old student made repeated threats to shoot up his public middle school, prompting extensive investigation by police and school authorities.
Chief, I'm sorry, I have to, if you could be brief.
3 lines from being finished, okay?
Thank you.
The threats were heard by other children. However, the police were unable to refer the 12-year-old youth to the Department of Juvenile Services and Juvenile Court for possible compulsory services or intervention. Once again, I applaud all who support this bill because it's about helping our young people who already have challenging circumstances and challenging lives. Thank you.
Hi, good afternoon, everyone. My name is Jackie McKnight. I am the mother of 13-year-old King Douglas, who was shot and killed by a 12-year-old at the Dave & Buster's in Capitol Heights on April 17, 2021. And I am here to testify with this bill. I do agree with it. The child now 15 who shot my son, he is currently off of detention. He is now on probation, which he is soon to be released in the next couple of months. I am an at-risk advocate as well for juveniles, and I do believe in accountability. I believe in accountability when it comes to the lawmakers. I believe in accountability with parents as well as children. And the children that I mentor a lot of children who do carjackings and things like that. And they feel that because they get let off, they can continue to do these crimes. They have older people who pay them to commit these crimes. And because they're not held accountable, they continuously do it. And I just feel that we do need to hold them accountable. Public safety, we're not safe in our communities, and we shouldn't feel that way. We should not be feeling like we have to stay home because we're afraid of someone, a child putting a gun up to our head or taking our vehicles. I think that the system in itself needs to have structure. And that's where we're lacking here. Support services, not just throwing kids in jail. I think that we need to get to the root of the problem, and it stems from in the households. We can't get in the households a lot of times. So where we need to start is at schools where these kids are going, start creating programs and speaking to the children and finding out really why they are committing these crimes and how we can help them. Again, overall, longer probation sentences for juvenile is not only to punish them, but to rehabilitate them, protect public safety, and promote positive youth development. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the State Director with the Humane Society for the United States. We want to thank the speaker and the chair for including animals in this conversation. We do think it's incredibly important. I do want to stress that our engagement and expertise on the bill is very narrowly within that one sentence of the legislation before you. We applaud this committee for working very diligently to balance two goals that usually align, but very rarely, and in this case, unfortunately, can collide. We believe deeply in a restorative justice system, and we're also very grateful to the work you've done to protect animals against, in particular, violent crimes. As we look at the way that the bill was drafted, we do respectfully recommend that, as grateful as we are to be part of the conversation, that you further narrow the animal crimes that are included in this bill to only those under 10606, because that's the real heart of the cruelty against animals statutes. That's your malicious torture, sexual assault, your death through cruelty, your cruel beating. These are the only real crimes under that statute that show a certain level of intent and the sort of violent crime nature that is where this committee has generally found the balance point when we see these conflicts between restorative and accountability. And my colleague will speak more about why we do need to be able to intervene as an animal control community into these cases. But we do just want to stress these are rare. To this question of, oh, is this on the rise? Is this frequent? We're not here to say that we have an epidemic of youth, beating dogs to death. But when these cases occur, they are very significant. They are very meaningful, not just from the animal perspective, we are the Humane Society, but also from the perspective of what is sort of at risk in that youth's home or that youth's life, where we might need, as you've heard from this conversation, more robust interventions. So again, with that amendment, we respectfully do request that, that be included in whatever final product comes out of this meeting.
Excuse me. Thank you, Mr. Chair and committee. I am Patty Crankshaw Quimby. I'm the Executive Director and Chief Animal Control Officer for Talbot County. And I'm here today as the President of Professional Animal Workers of Maryland. We're the state organization comprised of animal control agencies and humane societies. With my colleague, Jennifer Bevan Dangle, we support the amendment to HB 814. I submitted written testimony. I'm simply here to reinforce the importance of this inclusion. We're speaking of the most heinous acts, those again, which have the intent to harm animals, cruelly beating, torturing, mutilating, sexual contact, unfortunately killing. While these are rare, thankfully, when they do arise, our officers absolutely need the tools to protect not only the animals, but the people in the home and in the community. These are awful acts, yet we also know that children who harm animals are often experiencing some sort of abuse themselves. As the chairman mentioned, these youth need the support that is available through the juvenile justice system. I also wish to close with animals in Maryland are caught in a legal dilemma. Technically, they are property, but they are living creatures that are often severely injured or killed in these cases. And that raises this to the level where we believe very strongly that these crimes should be included in this Juvenile Justice Reform Act. Thank you very much.
Thank you, Mr. Chair. Thanks for everybody for being here today. Chief McCullough, I'm told you might have some comments on how we could fix our diversion loophole, maybe in Baltimore County, maybe everywhere. Can you comment on that?
Well, this bill will go a long ways in helping us by lowering the age to 10. It will help us to make our longstanding award-winning program called Joins effective again. It will allow us to divert those young people who may have gotten in trouble for the first time or maybe the second time for something that's nonviolent in nature or a minor property crime. And even in crimes where you have victims, many times the victims don't want to see these juveniles get in trouble. They just want to see them diverted to a program or have some accountability given to these young people.
Couple specific crimes. Threat of mass violence. Was that a situation at Stemmers and Kenwood?
I don't remember specifically this school, but I'm pretty sure it was.
We've heard frequently adults organizing kids in crime. I've looked at that section of statute. Is that thorough enough to govern what we're trying to get at here? Adults, pointing juveniles to participate in crimes that the adult knows the juvenile can't be prosecuted for. Is that section of code thorough enough to capture it?
I would say we'd have to look at it more carefully. I have to look at it some more to discuss that. Okay.
Vice Chair and Phillips.
Thank you, Mr. Chair, and thank you all for being here. Ms. McKnight, my question is directed to you. Thank you so much for being here.
Thank you.
And I am sorry for your loss.
Thank you.
I wanted to ask you, you mentioned that you are an at-risk advocate.
Yes.
Can you tell me the age group that you work with?
I work from 7 on up. I have a 19-year-old right now. I deal with 20-year-olds as well. I'm in a program where I have to go to court on their behalf. A lot of them are in foster homes. And then I have my own organization under King where they come to me or I come to them and I'm advocating for them because I see that they're in trouble. I just picked up a little boy, he's 15, he carjacked a couple of times, armed carjacking in Upper Marlboro Courthouse. I linked with his mom to connect with her and stay in contact with him.
Leads me to my next question, which was about the parents. Tell me what your experience has been like with parent engagement. How is that, has it been frequent or is it rare? And just what are you finding with the parents?
What I'm finding is a lot of parents don't want to deal with it. They feel that the law is not helping them, so why should they do anything? A lot of them just feel like, I don't want to deal with my child anymore. I'll let the law handle them. Some parents take accountability. They need resources. They need help. A lot of them, they have jobs where they're not able to stay home 24 hours a day and monitor their children. So they need help to be able to help their children. I have both. Some people are accountable. Some people just throw in a towel. They feel like they have no help on the lawmaker's side. So yes, no problem.
Thank you, Mr. Chair. And before I get to my police chief, who I really am very fond of, I want to make a comment to Ms. Jennifer Bevan Dangle. Thank you. One of the things that we're doing, some of what we're doing, I get concerned that we're not evidence-based, research-based. Your comment about the types of crimes associated with animals, I appreciate that. So thank you. And I think we need to look at that. Chief, let me start with SINS first. We've had a lot of conversations about SINS. Does it work? How does it work, et cetera? And we've had an opportunity to discuss it. Have you been able to kind of go back and ascertain from a Baltimore County perspective, why we do or we don't use it? And has there been any conversation about altering the way we leverage SINs from a police department perspective?
I would agree with much of the conversation that's centered around SINs today in terms of the fact that there is a need to further education across all of the parties in terms of, exactly what it is and how to use it. It's been my experience over the past 38 years that if it's going to be effective, it's going to be effective with very young first-time offenders. As you deal with kids that get to the age of 13 years or older, it's not very effective because you need to be able to force them to do what you need to do, and it really has no teeth, no enforcement edge to it.
Fair enough. And then the other kind of a follow-up to that for the 12 and unders. For the 12 and unders, how has this process changed the way you deal with them in terms of joins? And have we been offering joins as an alternative for those persons who you've had encounters with that you could no longer send through a formal process?
I would say, first of all, you and I have had extensive conversations over the past 10 months about this. I would say, first of all, when the age was changed, it drastically impacted our ability to utilize joins. Unfortunately, joins works because when they get in trouble, we're able to offer joins as a diversionary process to them being referred to DJS for charges. It's the threat of being able to be charged by DJS that often forces kids into joins. And there we're able to offer them all kinds of services, all kinds of mentoring, counseling. And like I said, since 1997, that program has been very effective in Baltimore County. We need to be able to continue to do that for our young people.
And I know we've done a really good job, and I appreciate what Baltimore County Police has done. My last question really has to do with the reporting of incidents and engagement with young people. We've seen or we've heard that reporting process has been inconsistent over various police agencies around the state. In this bill, we talk about making sure that we capture that information. Does that present a challenge, do you think, for the police department?
The way that it's currently written, I would say that it needs to be modified. We need to take in consideration programs like joins, where it's not necessary to further everything to DJS. We might be able to deal with these things in a diversionary type of way. We also need to have the latitude to not send reports to DJS in cases where it's been proven that the young people may have not even committed whatever the offense is. And there's plenty of times that juveniles are accused of things that they didn't commit. So, we have to be careful about what we're forwarding, how we forward it, and how we track it.
And so when it comes to making sure that from an overall perspective, we have data on incidents, would you be willing to make some recommendations on how we change this language just to make sure that we, when we go back, the commission that we really have good data that talks about the interaction with law enforcement?
Absolutely. I think part of the problem is law enforcement agencies across the state, all of them use different reporting systems. We need to look at law enforcement across the state and really, if you want to do it right, come up with one way of reporting for everybody. That would go a long ways in terms of even our reporting state numbers to the FBI and things like that. It would go towards effectiveness, efficiency, and cost for all of the law enforcement agencies across the nation. Not the nation, but Maryland. There's a bigger picture there where we could fix a lot of problems with more standardized reporting.
Thank you, Chief. Thank you for the work.
Thank you.
To pile on to Delegate Phillips' question, so Chief, the in your county's police reporting system, do you have a place on a police report where you can check whether the child or juvenile is being diverted to a police diversion program?
We can. We also have a checkoff box, and we also have we can write it into it also. Of course, when things are written in a report, it's kind of hard to go back and check things.
Right.
We try to improve that process all the time. But things come up and things change and processes change.
And further, would it be possible to perhaps, as we consider that language, consider language that would either affirmatively or provide some affirmative or some statement from the police to say, I want this to now go and be reviewed by DJS, as opposed to all of them going. I understand what you're saying about the language. The language is very broad. And I think in my conversations with the department, they're concerned that it's very broad and they'd have to review everything. That's not necessarily our intent or my intent. The intent was to make sure that there were reports being written so that we could look at the data in the long term. Is it possible, would you conceive of a way to, I don't know, to create something that would affirmatively say, I want to go forward with DJS?
It's definitely possible. It's just a matter of, in Baltimore County, we have a large department where I have resources that we can do those things. I can see it being more difficult for smaller departments, and most departments are small in the state, where they don't have the resources or the people to monitor these things. So.
All right. Delegate Tolles turned off. Delegate Tolles.
Thank you, Mr. Chair. And so I wanted to, I'm sorry, the name in the middle. Yes. Could you tell me your name again? I'm sorry. I know.
My name?
Yes, yes, ma'am.
Oh, JK.
JK, yes, I'm
Yes.
sorry, I forgot. I just wanted to also offer my condolences
Thank
as
you.
the shooting did take place in my district.
Thank you.
And I remember it it's way too young for children this to be happening.
Yes.
And so again, my sincere condolences to you.
Thank you.
And just know I stand ready to assist you with any services you need after, because what's important is making sure that those relationships are maintained to hopefully avoid this ever happening to anyone else in our community. So I thank you for the work you're doing with our young people. And my question to you is, did you start that work after your son, after your son?
Yes, I did.
Okay, well,
Yes,
I
did.
thank you for that. And could you just expand on, even though you're grieving, you're willing to put yourself out there to help others, to help other young people.
Absolutely.
Could you expand on, as a parent, what you think needs to be done? I know you talked a little bit about it, but what is needed? Because how did a 12-year-old get a gun? Where did it come from?
Absolutely.
How did that access even happen? Last year we passed, several two gun laws, but obviously one of them dealt with locking up the gun properly to avoid access for children to get that gun. So could you just talk about what you think is needed with the parents? What's missing with the parents? Why is that access even available, and how this bill can help to be able to work more closely with our parents who have these children in the system?
So I would say, again, accountability for the parents. A lot of times these children, from what I'm hearing from certain children that are committing some of these crimes, they're not getting these guns from the homes. They're getting them off the streets. And they're not parents. They're older guys that they look up to, as they call them, OGs in the neighborhood. I feel with my child, I was always on top of my child. A lot of parents are not tracking their children. They allow their children out at all times of the night, and they're not monitoring them. They're not, checking up on them. They're not checking in their rooms. They're not checking in their book bags. They're not going to school to really find out how they're doing, what they're doing. They're not active and involved with their children's friends. you got to know who your kids are around. And they're not, I don't think a lot of parents are concerned about that. I'm not going to say every parent, but a lot of parents these days are trying to be friends with their children. So they allow things to slide more times than none. And again, I feel since we can't get in the households, we should start in the schools. We have sex education that's offered in the schools. Why not offer something for the children, emotional, mental health awareness instead of the sex education, or replace it and, put it in there, make mandatory counseling sessions versus a child, because 9 times out of 10, these kids that are committing the crimes are not going to come to you and talk to you. You have to come to them. So I just, yep.
Talked about, with the state's attorneys with trauma.
Yes.
And how that is really
It's big.
impacting
Yes.
so I thank you for,
Yes.
stamping that, because I
Absolutely.
think it's necessary. And
Absolutely.
hopefully through this bill,
Mhm.
we can really delve into,
The trauma.
dealing with trauma in our
Yes.
kids, because I've said that I've tried to do other
Mhm.
laws, in our state. And I'm
Mhm.
saying, if we teach sex education, we
Yes.
can teach, plug things
Yep.
like swimming lessons,
Yes.
or, so they can get jobs
Mhm.
as lifeguards, but just dealing with, number one, their trauma.
Absolutely.
If we can teach other things in school, we can deal with this. And so I
Absolutely.
thank you again for what
Yes.
you are doing
Thank you.
to try to improve the lives of children in our community. And I
Absolutely.
stand here to support you. Thank you, Mr. Chair.
Thank you.
Thank you, Mr. Chair, and I just want to ditto what was been said, Ms. McKnight. I'm so sorry
Thank you.
for your loss. I had 2 questions for you. The first one, you were talking about the cases that you get. How are the cases that your organization, how are they referred to you, or?
So I'm in a program with one. It's called CASA. So I get that. They get it court appointed. And then the other ones with my organization for King We Stand Foundation, I get the children by word of mouth. I do a lot of advertisements. So the children a lot of times come to me, or I go in neighborhoods and I find the children and advocate them, mentor them. I'm sorry.
No problem. And then a second question, Mr. Chair. Earlier you mentioned that basically you see 2 types of parents. Parents who are trying to figure out what they can do to help their child. But then you also talked about parents who just feel absolutely helpless. And I was wondering if you could expand upon that. And I mean, if you have any ideas on what we can do, or is there anything that we can do to kind of help those parents? Because I think that's also important for us to address as well.
So I had one father, he, not so long ago, I think it was last year, he had a case with his son. His son was 14, 15, and he committed a couple of crimes. He was very frustrated. He was scared to have and usually fathers are not as scared, mothers are. This father was scared to have his son back in, but the judge kept ordering that the son is to stay home on house arrest. And he's literally pleading, can you please keep him incarcerated and offer him some type of rehabilitation? He's trying to tell them that you guys are not offering him any programs, and my son is going to keep committing these crimes if you don't help him and let him know that he's accountable, hold him accountable for these crimes. So I would just say with this bill, holding kids accountable, and I mean, I know they're children, but it takes a village. And we as the community have to now dive in and treat these children as our own, or it's going to be knocking at your door too. It's already knocking at our doors, so. You're welcome.
Thank you, Mr. Chair. Just a very, very quick question. What's your capacity, and are you at capacity?
With
your ability
advocating for the
to
children?
serve? Yeah.
I can take more on. I can take more on. I had just got it started again when King passed, and that was in 2021. Right now I am mentoring, I would say about up to 20 children. These children call me all the time.
Just one, or do you have others?
I have
working with you?
others. I have others, part of the organization, yes.
And you're funded how?
I'm funded through myself right now. Yeah, because we just got everything started for King Foundation. So everything that we do is out of pocket.
Thank you.
Yeah, you're welcome.
Seeing no further questions for this panel, thank you very much. That concludes the panels in favor of the legislation. We'll now hear from the first of 5 panels in opposition: Natasha Dartig from the Public Defender's Office, Keith Lottridge from the Public Defender's Office, Lauren Dollar from the Public Defender's Office, Alicia Capozzello from the Public Defender's Office, and Sarah Wendell from the Public Defender's Office. Ms. Dartig, please.
Good afternoon, Mr. Chair, Madam Co-Chair, distinguished members of the committee. I am Natasha Dartig, Maryland State Public Defender. The Office of the Public Defender opposes House Bill 814 and requests an unfavorable report. This bill guts the Juvenile Justice Reform Act, which was enacted just a short 2 years ago, and it has a disparate impact on communities of color. There is a difference between intent and impact. Proponents of the bill have alluded that the intent is to improve public safety. The impact of the bill is that it will incarcerate more Black children from marginalized communities throughout the state. If the intent is truly to increase public safety, this bill does not do that. We must base our discussions on facts, data, and evidence-based information. Despite the intent of public safety, House Bill 814 raises concerns about the perpetuation of systemic biases and the potential for decisions based on fear rather than evidence. In fiscal year 22, 62% of the state's attorney's referrals were Black children. The majority came from the largest jurisdictions in the state. Anne Arundel County, 62% Black children. Montgomery County, 48% Black children. Baltimore City, 93%. Baltimore County, 71%. Prince George's County, 80%. Fiscal year 22, children that were held pretrial, 86% were children of color. The impact of policies that disproportionately affect Black children cannot be divorced from the historical context of systemic racism and discriminatory practices within the criminal legal system. We have the opportunity to improve communities and ensure public safety. We cannot do it on the backs of our children, especially not Black children from marginalized communities. For these reasons and others, as will be brought forth by my colleagues, we oppose House Bill 814 and urge an unfavorable report.
Going, I guess, in order of precedence, Mr. Lottridge.
Thank you. And good afternoon, Mr. Chair, Madam Vice Chair, delegates. This omnibus bill includes many, let's call them problematic provisions. My role here today is not to talk about the policy, not to talk about the impact. You've heard from Madam Public Defender Natasha Dartig, and you will hear from other teammates, other public defenders, about the fact that this bill is wrong. I'm here to talk about the cost to the Office of the Public Defender, because we want to make very clear what this bill will cost us. But in doing so, in doing our due diligence and explaining that to you, I want to be very clear. The fact that we've priced it out does not mean that I or anyone is supporting this. We are just doing our due diligence. We believe this bill impacts children negatively, it impacts Black children negatively, it impacts poor children negatively. It's unequivocal. But the bottom line as to cost, we project that we will need an additional 30 positions to even attempt to adequately fulfill our obligation under this bill. That's $2.6 million with the positions and other associated costs. This bill seeks to increase the number of juvenile cases through various provisions, such as authorizing the charging of young children ages 10 to 12 years old accused of certain crimes, and requiring complaints to be sent to the state's attorneys rather than be resolved by DJS, increased probation periods, and the use of detention. Each of these provisions will have a substantial fiscal impact on the Office of Public Defender. That cost is 20 attorneys, social workers, and core staff. I cannot emphasize enough. That is a conservative effort. Let me explain this to you in a way you can understand. When you have a 10-year-old who's charged with a crime, that's going to require a lot more effort than it would for a 16 or 17-year-old. They're a fifth grader. The amount of time it takes to explain things to them, to make them understand that they have a right to make a decision, to advocate for them, and to make sure they can advocate for themselves, is enormous. We estimate it would take 260 hours per child.
Thank you. Who would like to go next?
Let me finish with we urge an unfavorable report.
That's fine. Thank you.
And
Who would
please
like to
write
go
down the
next?
$2.6 million. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Alicia Capizzello. I am Deputy Public Defender for Baltimore City, but before I assumed that role, I was a youth defender in Baltimore City representing children in juvenile court for over 20 years. It was a calling for me. I urge you to vote unfavorably for House Bill 814. I will address the provision of the bill that extends juvenile probationary periods. We know from the JJRC's work that youth have better safety outcomes when the juvenile system helps them set rehabilitation goals and accomplish them expeditiously, as opposed to surveilling them through long periods of probation. Members of the General Assembly and the public have repeatedly expressed the desire for children receiving services quickly. House Bill 814 undermines this. Overly lengthy probation periods like the ones proposed allow for systems and the adults who work within them to procrastinate in service delivery, to fail to develop an array of immediately available services for children. Before considering lengthening probation periods, a robust menu of evidence-based, culturally competent, community-based services must be developed. Under the current law, there are already high ceilings for probation, and I urge the members not to look at the initial terms of probation, but the maximum terms of probation allowed under the current law. It is 1 year for misdemeanors, 3 years for a non-violent felony, and the age of 21 for a crime of violence. Many programs like ROCA, which was mentioned earlier this morning, a child can remain in without being under probation. If 3 years of a child's life is not enough time to rehabilitate them for a nonviolent behavior, something is amiss with the adults, not the child. I just like to briefly say that I have represented children who, when their term of probation has expired, they want to continue in the services, but when the shame is lifted, when the pressure and stress is lifted, you can see it on their faces. So we urge an unfavorable report on House Bill 814. Thank you.
We'll start at the end or wherever you'd like.
Sure. Good afternoon, Mr. Chair, Ms. Vice Chair, and members of the committee. My name is Sarah Wendell, and I'm an assistant juvenile public defender here in Anne Arundel County. I want to address specifically the provision that allows courts to detain children on misdemeanors if they are already placed on probation. The Office of the Public Defender opposes this amendment because it disproportionately harms youth of color, youth with disabilities, and poor families. What the proposal suggests is that simply because a youth is already under supervision, if they make a new mistake or are just accused of a new minor offense, they can then be detained. And it's important for the committee to understand that the primary and most common misdemeanors we do see, I think they were mentioned earlier as well, are school-based simple assaults, petty thefts, stolen AirPods, things of that nature. The reforms implemented in 2022 were created with evidence-based principles in mind to address the underlying causes of such delinquent behavior. The reality is that kids are going to mess up, and the way that the juvenile system is currently set up allows kids on probation, if they make a new mistake or are accused of something new, those needs can be addressed immediately by their probation officers, or what we call case managers in the juvenile system. They can implement sanctions, they can implement new services to immediately try to address what's going on in a youth's life if a new minor offense does come up, and then that can also take its process within the court system. This is far more productive because it allows us to continue to address the youth's needs in the community, even if they receive a new charge that comes their way. And the proposed amendments would disrupt that. That's all to say as well, being detained as a child and losing their liberty is a life-changing event for them. That is something that they will always remember. It is not something that just comes in the blink of an eye. It is life-changing. It removes them from their parents, their schools, and their communities. And for those reasons,
Good afternoon, Mr. Chair, Ms. Vice Chair, and ladies and gentlemen of the committee. My name is Lauren Dollar, and I'm a youth defender in Baltimore City, and we urge an unfavorable report on HB 814. Portions of this bill undercut diversion programs, which are sponsored by both the police and DJS throughout the state. We all want kids who are in crisis and at risk to receive support as soon as possible, but this bill actually does the opposite of that. And it will bring more Black children from marginalized communities into formal court proceedings. So what is diversion? Diversion is when a kid gets in trouble and the system requires them to participate in services, but where they're not in formal court. That is why it's also called informal adjustment. So within a few weeks of obtaining a police report, the Department of Juvenile Services meets with the youth and their family, and DJS says to the child, if you do these things, including, for example, a mentoring program, community service, or even intensive after-school programming, we will recommend that you don't have to go to court. But if you don't do what you're supposed to do, you do have to go to court. So it is mandatory. Diversion is what we call an off-ramp for the legal system for kids. The kid still has consequences for their actions and access to the kind of help that we do give kids through the formal court process too, but it doesn't involve the parts of the system that research shows are actually bad for kids long-term. So youth who complete diversion programs lead with an understanding of the impact of their choices. They avoid permanent negative outcomes related to the formal legal system, including labeling, stigma, and having a record. It's actually harmful and traumatic to go to court. I forget this when I'm representing kids, but seeing the emotional reactions of kids before walking through the doors, I'm reminded how traumatic actually formal court really is. So diversion is a good thing, and we see great results, so we avoid bad results, and this short circuits diversion. This bill requires more cases to be forwarded to the state's attorney's office, and the state's attorney will charge those kids because state's attorneys charge kids. That's what they do. Thank you, Mr. Chair.
All right. Questions first from the Vice Chair, then Delegate Erica, and then Delegate Kaufman.
Thank you, Mr. Chair, and thank you all for coming in and testifying. I appreciate the work and I appreciate the zealous. However, I've said this to the state's attorneys and I'll say this to you as well. We as legislators do not represent only one side. We have to look at the victims, we have to look at the perpetrators, the parents, everyone, and figure out the best methods that we can. With that said, when we have situations like what Ms. McKnight was just talking about, or any other children who happen to have a gun, in Ms. McKnight's case, someone had the gun, handed it to the 12-year-old. The 12-year-old ended up shooting the child. My point is that when we have circumstances like that, as legislators, what do we do with all the folks, all of the community that's been harmed by this act of a 12-year-old? And I'm going to direct it to Ms. Officer of the Public Defender, because I don't want everyone to have to answer, because I've got some other questions.
So I will, and thank you, Madam Co-Chair. I will start by saying in that very scenario, what is of great benefit to the entire community is not simply removing that child from the community, but also addressing the underlying circumstances in which that child was in that situation. So you mentioned about the child essentially is engaged with an older child or someone else who gives them that weapon. So
the child who gave the 12-year-old the weapon. We just know based on the report, it just says a child handed the 12-year-old the weapon.
So whatever the circumstances that this 12-year-old finds themselves, that they're engaging with other individuals in that space, those underlying problems must be addressed, because the bottom line, simply removing the child from the community does not address what actually precipitated the reason why the situation occurred in the first place. And unless we do that, it benefits no one. It does not benefit the child. It does not benefit the community in which the child comes from. No one benefits from that situation unless we address the underlying problems.
We have, with respect to, we have ACEs, adverse childhood, whatever, I can't remember the rest of it, but we have that. What data do we have for individuals who witness trauma in school, on the streets, or anything of that sort? Aren't those ACEs as well? Aren't those adverse effects? So now we have children who can witness, or communities who can see these things going on. And while we're helping this one child, which is great, I think that's great that we're helping that one child, what provisions are we making for those other children who are witnessing any form of folks having guns or sexual assault or any other form in school or in the community? What provisions do we have for them?
So in terms of, I will answer that in terms of this bill. So we arrived to where we are with the JJRA as a result of 3 years of a bipartisan group of individuals. And essentially, this is what was the result of what was determined to be best. We are now at a situation less than 2 years later, and essentially we are proposing a bill that is not based on any data, that is not based on any facts, that is not based upon any evidence. So I ask that we essentially step back and perhaps we're putting the cart before the horse, reconvene the commission, reconvene the committee so that they can do the work, so that we're not basing decisions on fear. We're not making decisions based on antidotes, because when we took the time to use the data and the science, the result was the JJRA. And in 2 short years, it is barely getting a footing to really get to work.
What we did have when the JJRC was available was numerous school shootings, numerous. And I don't know the exact focus of the JJRC. I believe I've been told that the focus was perhaps on crimes of violence, but we had numerous shootings. We have numerous data of kids bringing guns to school. I've had someone, a minor, bring a gun to school in my district. Folks want to know, what am I going to do about it? With respect to some specific data, I'll speak to the World Health Organization that says, and I have to take my glasses off, says that youth violence results in death, injuries, disability, and long-term health consequences. My point is that while I understand your zealous effort for your clients, and I think that is absolutely what you have to do. But can you understand that those individuals who may today commit a small infraction, if we don't reach them early enough, they may very well go on to something more serious? Have you had that ever happen with any of your clients? Any of you can answer this question. With any of your clients, have they ever been repeat offenders? Have they ever committed a small act and then we didn't do anything and they went on and did more?
Well, thank you. Thank you for the questions. I mean, the first point that I think is crucial to make is that this is not a violent crime bill. I've heard it described that way over the past few weeks. Under the current law, there is nothing to hem in the ability to fully prosecute, with the state's attorney's office having full discretion to fully prosecute, detain, place a child on probation up until the age of 21 and commit a child for a crime of violence. So that's very important to note. There is already jurisdiction for 10 to 12-year-olds who are alleged to have committed a crime of violence. This bill is about placing the failings of adults on very young children and children accused of committing minor offenses. And that's one of our primary objections to the bill.
And Mr. Chair, I just need to continue this, if you don't mind, just for two more questions. I can respect that. However, I cannot say that suffocating, strangling, disfiguring someone while you're committing a sexual act is not a crime of violence. Now, while that may not be a crime of violence by definition, it's a crime of violence in my heart, in my mind. While carrying a gun may not be a crime of violence, when we look at children having a gun and I can see someone next to me has a gun out in their backpack, it is not a crime of violence in the term of the general, but the impact that it gives to the community and to the other children there, while it may not fall under the heading of crime of violence, it is a problem for sure. So, I mean, just can you square that up? I understand what you're saying about not being a crime of violence, but mutilating, killing, cruelty to animals. I mean, I know those animals are not victims, but I don't know that crime of violence is the only thing we need to focus on. I think we need to use our knowledge and our data, because we do have data, to realize that there can be things that we can do proactively as opposed to getting to a crime of violence as it's defined in the statute. Does anyone have any response to that? There is a question there, isn't that so?
Thank you. I will begin, and Ms. Capizella will complete. But a great part of your statement and the question that keeps coming to the surface is, where is the data or the science or the evidence that there is a surge in ages 10 to 12? We have heard antidotes, we have heard fears, but there has been the ask repeatedly for the actual data and the numbers that reflect that there is a surge, especially from the age of 10 to 12. And it has not been presented. And that is some of the concerns, simply moving forward based upon anecdote, based upon fears, without actual evidence and data. Okay.
I would simply add that we need to ground the conversation in the fact that these are little boys of color who historically have been adultified. We need a robust SINs mechanism to handle the important concerns that you, Madam Vice Chair, are raising.
My last point, I promise, Mr. Chair. This is my last point, and I won't ask any questions on the next panel. I appreciate what you're saying about these are little boys of color. But Mrs. McKnight's child was a little boy of color. All communities deserve justice, and Black communities deserve justice. So I just have to say to you, when you're looking at the perpetrator by saying that the majority of folks who get caught up in the system, let's remember that the victims are often are often people of color and children, our 10-year-olds, our 11-year-olds, our 12-year-olds. We want that violence to stop as well. And our laws are here to create a level of public safety that looks at everyone, not just a few. So thank you for indulging me. Thank you, Mr. Chair.
Thank you.
Delegate Eric, please.
I don't know if I can follow up those beautiful words. So I appreciate all the work you guys do. It's obvious that this is a passion for all of you. So first I want to lead with that. That being said, there's 5 of you here today. Do you guys have a legislative affairs department?
We have a director of legislative affairs, but it is a small but mighty team.
Earlier it was mentioned that you're going to need 30 new pins, $2.6 million to do that. So I appreciate the fiscal responsibility. Just for the record, are any of you using your PTO today?
I'm sorry, I didn't hear the question.
PTO, are you using PTO today to come here to test out all 5 of you? Or is this going to be, is this state paid?
So I guess I would answer that in that our role as public defenders, including advocacy, both in the courtroom and in the community. So part of our advocacy for our clients outside the community, especially since we handle 90% of the criminal cases in the state of Maryland, requires us to engage in the conversations that directly impact the clients that we serve.
I would agree, certainly, but I'm just wondering, again, if we're gonna need 30 new positions, we have 5 people here out of work today because we need you to do the jobs that the community desperately needs. I mean, you guys are clearly overworked, you're underpaid, but 5 of you here today, it just feels, and to come and ask for 30 new pins, it just feels like I'm missing something. So that's all I wanted to say.
So if I may address,
I'm good, actually.
Delegate Kaufman.
Yes, thank you. And I will try to be briefer than some of the previous speakers, but I do have a couple questions, if that's okay, Mr. Chair. First of all, I mean, there were a lot of references to children of color in the testimony, and I really appreciate it. But having had the honor and privilege of working under her for the past 2 years and serving, admiring her from afar for the many years before that. Please rest assured that the lead sponsor of this bill, Speaker Adrian Jones, is very concerned about children of color and the unique disparities that they face. My question is, I'm going to frankly probably have a nightmare this evening because my friend, the vice chair, has described the third-degree sex offense about 3 or 4 times, and I didn't know what it was before. But the thing is that my question is, you know, to me, that seems like a heinous, difficult crime, and also auto thefts are not a victimless crime because often people have to walk to work for 2 weeks while their car is trying to be recovered. In fact, Mr. Bates told me a specific story like that. And you asked about facts, Miss Natasha, but the thing is, Mr. McCarthy already articulated that car thefts in my county are way up. So my question is, I can see why you don't like the consequences in the chairman and Senator Smith's bill, and Speaker Jones's bill, but I think it's pretty clear with the kind of stats that the state's attorneys were citing today that diversion's great, but in some cases it isn't working. So do you have alternative consequences that you would propose? Because I'm convinced that after listening to Principal Pastor, who was a principal for 30 years, that children need significant consequences.
So if so I would say that that the data does actually show that diversion for the vast majority of cases does work. So according to the Department of Juvenile Services resource guide, 92.4% of children whose cases were diverted in fiscal year 2021 had no new sustained offense within a year. And 80% of the young people who participated in diversion successfully completed it. Now, that is also part of the point. If a young person does not complete the services that they are ordered to complete, then they are still referred to the state's attorney's office for formal prosecution in court. And so you do end up in the same place that you would have from the beginning if the child does not actually do what they're actually ordered to do. And so I would say that what we're doing does work the vast majority of the time. And if they get, there's nobody has a crystal ball. No one, if we knew the answer of how to stop kids from ever getting in trouble again, we would be doing it. But we know it does work most of the time. And for the times that it doesn't work, then the kids ultimately get charged. I believe that prior arrests are taken into consideration by DJS in their recommendations for how to resolve cases. Does that make sense?
Yes, I mean, I am not, I'm not sure I entirely agree because again, to go back to my friend, the vice chair's example, I don't have, to be honest with you, after learning what it is, I don't have much sympathy for kids who commit the third-degree sexual assault, but I understand that you're here to serve a purpose, just like Mr. Kroll serves a purpose for the MSAA, and we're glad to have you here and serving that purpose.
If I can just address the third-degree sex offenses about jurisdiction for really young kids, the cutbacks on diversion are for a very wide variety of crimes, including a lot of nonviolent offenses. So that's what I would say to
that. Thank you for coming and thank you for sharing your perspective, the Office of the Public Defender. One of the things that we realize is that as I said earlier, we've heard from a number of stakeholders, OPD, state's attorneys, police, advocates, and everybody is coming from their individual perspective on your roles. And I get really concerned that we're not getting the whole picture in any of these conversations. Now, having said that, this idea of disparate treatment and disparate impact, it concerns me. But Black on Black crime concerns me, right? So I appreciate the Vice Chair's comments. I'm just not sure that defaulting to the criminal justice system to address our young kids is the right way to do this. You talked about improving the SINS process. Could someone speak to that, number one? And then number two, what your recommendations would be? And then number two, some of this is going to happen in my mind, whether we all like it or not. What are the things that in your mind are the most egregious that perhaps we should reconsider and really be adamant that this should not be in?
So I will defer to one of my colleagues in terms of SINS specifically, but I do want to emphasize that we are talking about children. And when we're discussing children, the term justice and regarding all parties that are involved looks, sounds, and should be different because we're talking about children. And especially when we're diving even younger to 10 to 12 year olds. We also must be cautious in that however we move forward, that it is in fact evidence-based and scientifically sound, that we are moving in those spaces, that we are not reverting back to the time where we think about the 1994 crime bill, when we were speaking of you do the offense, you do the crime, you do the time, and there was this fierce belief that incarceration was the solution. 30 years later, we know that it is not. So we must be very careful as we move in these spaces here today. And I would really emphasize that in these discussions, that we keep that in mind, that we're talking about small age children and that we must do so based upon facts and evidence. And I will defer to one of my colleagues about sins.
Well, thank you for the question. We do have colleagues who will be testifying specifically about minimum age of jurisdiction. And I think that they would be in the best position to answer that. I can say very generally, you know, that there's right now, the system for sins is virtually non-existent. So in terms of the array of services that are offered under it, streamlining the referral process, tracking the use of it, I don't believe any of that's been done since the JJRA and certainly should be. But if you'll indulge us, I think we'll be able to answer more specifically in later testimony. You're welcome.
Thank you, Chairman. So you spoke about courtrooms, I think being did you say traumatic experience?
Yes.
Juveniles? Okay. So I just want to share this, and I do have a question here. So as a young adult, not as a juvenile, I was extremely reckless and I got in a lot of trouble. I was on probation. I got arrested multiple times, multiple nights, one night off, sleepover, jail sleepovers. And the last time I got in trouble, I was standing in a courtroom before a judge, and the judge said to me, he said, if you had not completed X, I was going to send you to jail. And not a one night sleepover, but sentence me to jail for multiple weeks, months, whatever it was. And it was at that very moment, I stopped getting in trouble because I was terrified of the thought of actually going away and being in jail for multiple days, multiple weeks. And to me, that is what got me to straighten out my life and become a better person, was the fear and the terror and the thought of going away. So please explain to me how being in a courtroom is a bad thing for a juvenile, because for me, that's the only thing that got me to straighten up.
So as the data suggests, diversion does work. And you know, I think it's incredibly scary for young people. And we're talking about people who are eligible for diversion. So this isn't crimes of violence. This is low-level offending and kids who are coming in at the very beginning of getting in trouble, right? So we can try to keep them out of the formal court system. And because it works, we know that it doesn't take being terrified in a courtroom to prevent most of these kids from getting in trouble again. In fact, they have to have a consequence. Obviously, the diversion isn't just, okay, we're just going to dismiss this case. They actually have to participate in programs. So for example, the evening reporting center, I've had clients who, you know, have had to participate in the evening reporting center for their informal adjustments. Participating in a mentoring program. And those are actually interventions that can put kids on the right path after getting in trouble for their first time getting in trouble and for low-level offending. So I just wanted to put that into context and to take those kids and to put them in a situation where where the law actually says that they can't be detained, but they think they're going to be detained, just like you said, the scary part, that can last, it can impact somebody's own self-image, the way that they see themselves. It can expose them to other kids in the system who are in deeper trouble than them. So the less we can pull them into the formal court system, I think the better. I don't think most kids, given the data, actually need to be traumatized in that particular way to get them to stop getting in trouble, if that makes sense. I mean, that's what the data supports. But I understand what you're saying. I just don't think it's necessary for the vast majority of kids.
Mr. Chairman, thank you, panel, for coming in to testify. Ms. Natasha, I don't know if I pronounced your last name correctly, so I'll just leave it at Ms. Natasha. How often do you think the juveniles in question know the consequences of the low-level offenses that they might be ready to engage in before they commit their acts?
As clearly the least senior public defender on the panel, I would say almost never do they understand the consequences before.
Think that this is a lack of education problem for the 10, 11, 12 years old? I mean, they don't know what these low-level offenses are?
again, we're talking about 10, 11, 12-year-olds who physically, mentally are not fully developed. We're talking about middle school children.
Have they been taught, do you think, that the offenses that they might commit or what they might do might have criminal consequences?
I would venture to guess no.
Mr. Artigue, would a 12-year-old know that holding a gun was dangerous?
It depends on the mental capacity of that 12-year-old. The child may be physically 12, but may be functioning at the level mentally of, it may have a physical age, but a much younger mental age.
So your argument is that a 10, 11, or 12-year-old in possession of a gun wouldn't understand the dangerousness of a gun?
I will give you an example. As a young public defender, I started out in juvenile, and one of my first clients was charged with the offense of murder. And the circumstances were that, in fact, he was 12 years old, and he and a friend were playing swords, but they made the decision to play swords with actual knives. So essentially they were playing swords and inadvertently jabbed, and that one jab ended the life of another child. When my client was evaluated, it was determined that he was actually functioning on the level of a 6-year-old. So though he was of a physical age, he was essentially a 6-year-old who was playing with a knife. That is not a rare circumstance where we have a child, especially when you think about a child who comes from a marginalized community that has faced various trauma, be it economic, be it educational, be it lack of health care. We must also consider that just because a child is of a physical age, that is not necessarily the mental age in which the child is functioning.
But your position is that a 10 through 12-year-old doesn't understand. I understand what the case that you dealt with knives that were being treated as swords. They don't understand what a gun can do? Is that your position?
There are some that do, and there are some that don't. My position is that we cannot make a global assumption on all the children. It's like we can't make an assumption, especially when we are devising a law that is now going to widen the net and sweep in a greater number of children.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, panel, for coming in to testify today. I just had one question regarding diversion cases and the recidivism rate. I forget which one on the panel to discuss that. My question is, with new offenses for recidivism, is it only counted against cases that are sent to court? And if Department of Juvenile Services makes that determination of what gets sent to court, do they in essence kind of control the recidivism rate in essence? That's my question.
So because of the way that that particular statistic is written, it's true that the only cases that would have been part of that statistic would have been cases that do eventually get sent to court. Yes.
Seeing no further questions for this panel, we're going to move along. And Kimberly Watts, Lucy Forterra, Jeremy Zacher, Marguerite Leno, all from the Office of the Public Defender.
Thank you, everyone. My name is. Good morning, everyone, or good afternoon. My name is Jeremy Zacher. I'm an assistant public defender. I work exclusively in the juvenile system in Baltimore City, where I've been working for 10 years. We are asking for an unfavorable report on House Bill 814. I'm here to talk exclusively about 10 to 12-year-olds. being charged, or the expanding of the types of charges that 10 to 12-year-olds could be charged with. It's a little confusing to me. We've heard testimony today about the lack of services in the juvenile justice system, how there are waiting lists. And this bill adds to the number of children who would be placed into the juvenile justice system where there is a lack of services. To me, that doesn't make much sense to add to the burden until the burden is actually solved. The types of kids we're adding to the system, 10, 11, and 12-year-olds. These are kids in the 4th, 5th, and 6th grades. These are kids who, when they sit with me at council table, their feet don't hit the floor. These are very young children. And the types of offenses we are talking about, adding motor vehicle theft, adding firearms, I do not think everyone fully understands what that means. So I want to tell you a little bit about how these types of offenses are charged. Motor vehicle theft, it's difficult right now, but understand if you are a 10-year-old in the back seat or the back seat of a vehicle that has been reported stolen, you could be charged with motor vehicle theft, even though you had nothing to do with it and were just taking a ride with someone who was much older. The weapons charges that can be charged. I'm not talking about firearms, I'm talking about the dangerous weapon charges. If a kid picks up a stick at a park and starts swinging it around like a sword and accidentally hits someone, that 10-year-old can be charged with dangerous weapons. Firearms. You do not need to be in physical possession of a firearm to be charged. I have dozens and dozens of cases where a child was found near a firearm in a home or in a car, and they were wrapped up in some charge and put through a very difficult, arduous, adversarial system. We're asking for an unfavorable report on 814.
Thank you. Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the panel. Children belong with their families. Parenting is the hardest job around. The stress a family takes on when their child is system involved is indescribable. Speaking just about the portion of the bill that looks to extend probation and allow for detention on a violation of probation after 2 or more unexcused failures to complete treatment. OPD, as you've heard, represents about 90% of juvenile cases. An overwhelming majority of these kids, as you heard, come from families with limited means. Missed appointments are often the result of financial and environmental deficits and stress. When a child is detained for missed appointments without a new contact with the system, it doesn't address the root issue because in detention, it is highly unlikely that they will receive substance abuse treatment. Speaking about a child detained specifically in Baltimore City at BCJJC, where I work, they may receive Suboxone treatment, but they are not receiving or participating in rehabilitative treatment programs in detention. Many of the state's attorneys reference that the delay in getting to programs, that the problem with this, as Mr. Zacher shared, is that the adults in the room are not making the programs available. The solution isn't to address the issue by further extending or involving the children. No data has been presented to establish that children are failing to attend treatment. Certainly no data has connected that failing to attend treatment has led to further court involvement. If this is the actual issue versus the perceived problem, removal from the home is surely not a holistic path to address the reasons for this problem. Data and studies have been presented on the harms of detention and the out-of-home placement and their overuse, especially for Black children. I would refer you to the final report of the JJRC from January 2021. Detention for failure to attend treatment will not provide access to treatment while detained. Consistently, the youth defenders expressed a lack of any inpatient treatment. For these reasons, I am asking for an unfavorable report on House Bill 814.
Thank you. My name is Kimber Watts. I am currently the supervising attorney for the Forensic Mental Health Division for the Office of the Public Defender. Before that, for approximately 20 years, I practiced in juvenile court. In my spare time, I also am the co-chair for the Children, Youth, and Families Committee of the Behavioral Health Advisory Commission, as in my capacity as parent of a child with mental illness. And to answer the question, yes, I use my PTO for that. That being said, I'm here to talk to you about how children are incompetent very frequently when they are under 13 years old. Obviously, this is an area where I have some expertise. And what I can tell you is that according to the Office of Forensic Services, approximately 60-something% of the kids that they evaluated under the age of 13 were incompetent to stand trial. What happens in those situations, and this goes directly to Delegate Clippinger's concern about the 9-year-old who shot a 15-year-old with his aunt's gun, what happens in that situation is that that child's case is put on hold while they attain competency. I'm happy to answer any questions about what that means, but suffice to say that the case is delayed and the court has no jurisdiction to order services during that time. That being said, if that case instead were diverted to a SINS petition or a SINA petition, or even just handled informally by the Department of Juvenile Services, all of those services could be immediately gotten. So for these very young children, in approximately 60% of those cases, we will be delaying rather than attaining those services. That being said, I think it's also important to answer the question of how is it scary for a child who's in court to be in court? Little brains are different than young adult brains. I think we can all remember a time when our parents were yelling at us and all we could hear was like, think about the age group here is what I'm asking. Thank you.
Delegate Kaufman, then Conaway.
Yes, thank you. I do want to just briefly say, I've read the bill several times, and one of the witnesses was talking about how sometimes people can't get a transportation to the treatment or for some other reason cannot go. But the way I read the chairman and the speaker's bill, it is they would not get in trouble for that, only if they just were indifferent to coming. But my question actually is for Ms. Watts, and I wrote it down.
Sure.
My question is, can you tell me, I care very much about mental health. So what does competency really mean for a kid? Educate me. And I understand that there's a problem getting services while they are waiting, competency determinations. Can you tell me if that really is a problem or if it's hyperbole and what the consequences are as they're awaiting services? And thank you for sharing your personal story. It's not easy.
Thank you. So first question, what is competency? Competency to stand trial is a constitutional construct. It means that in order for anyone, a child or an adult, to stand trial and have a fair trial, they have to be able to understand the nature of the proceedings against them and the roles of all the parties, and to be able to do that rationally and to work with their attorneys. So for children, part of it is education, of course. We educate them as juvenile defenders every day about what the court system does, who the judge is, who the prosecutor is, what my job is. I can share one anecdote recently where I was working with a 13-year-old, and I kid you not, it took me an hour to explain to this young man who was very anxious and very nervous and very scared what an attorney is. Not what a judge is, not what a prosecutor is, what my job is. Why was I the one talking to him? An hour. Because he's young and he doesn't know. Fair enough. That being said, for some kids, it's not just a matter of not knowing, it's not being able to retain that information. Particularly for kids under 12, they engage in magical thinking and they often don't know what questions to ask. And so they just sort of shut down, which is what I was getting to when my time ran out, that emotional shutdown when you get scared and anxious. So some of them are really struggle to see the long-term consequences of their actions, be that action going to school on a Monday, taking a guilty plea, or picking up a firearm. They may understand that a firearm is dangerous. Some of them may not, though. But to understand that and the consequences of picking up that firearm, then what happens next are different things. So competency means being able to participate in your trial and understand it. And a good number of children are simply not able to do that, partly due to just their young age, and partly due to the fact that many of our clients coming from disadvantaged neighborhoods have a great need for services that they aren't getting before they come to court. Mental health services, educational services. A lot of my clients have suffered from lead poisoning, particularly when I worked in Baltimore City. And so that's competency. Your next question was about not getting services when they are incompetent. And I can tell you that that is not at all hyperbole. If you were to ask the director of forensic services for Maryland, his name is Dr. Gilbalt, you're welcome to give him a call. he would tell you that when a child, well, there are a number of different circumstances under which a child gets competency attainment services. For kids who are in the community, someone is sent to their house or they go to see somebody and that person basically does the education piece that I was talking about. But that does not affect their decision-making capacity. For kids who are in a facility for children, however, they get that. And obviously they're only in a facility for children if they're dangerous. And typically that's because of some other mental illness or the very nature of their charge. Those kids only, the Department of Health will tell you that when someone is committed for competency, they can only provide the services necessary to attain competency. So if that is education about the legal system, if that is medication, sometimes that is the case. If that is whatever is the problem, that's what they get. That being said, if what the child also needs is intensive therapy because of a trauma, for example, I can speak to Delegate Bartlett's point of kids being the victim of crimes. Very often those same kids then become my clients because it becomes an ugly cycle when they don't get the treatment that they need after becoming the victims of crimes or witnessing violence in the communities. They won't get that while they're waiting for competency. They will get education and they will get medication, and that's it. Does that answer your question, or did you have any thoughts?
I have a 30-second follow-up, and that is, it's just a yes or no. Is this, when people come to see you and they get evaluated, is this the first time that mom or dad or grandma or Charlie, the kid, has often heard that they have bipolar disorder or they have anxiety disorder or oppositional defiant disorder? Or do they come in and tell you? Like, I'm just trying to figure out,
Sure.
Are you on the front lines of mental health diagnoses, basically?
Sometimes yes and sometimes no. I mean, a lot of our clients do have individualized educational programs, IEPs at school. They do a comprehensive psychological evaluation to get those. So those parents will know. I have also represented kids where it was only because we were doing an evaluation that they discovered their child had learning disabilities. Sometimes parents know that they are frustrated. What I can also speak to in my experience as a parent is that right now we don't have enough resources for our kids. And it breaks my heart because I spend hours every month trying to get a therapist for my own daughter. And I can't find an in-person therapist with availability. And we don't have the resources that these kids need, and we need to build those in.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. To the gentleman at the end, I would like to ask this question. Do you think the average child or juvenile under 10 years old that's outside playing with a ball and they kick their ball into a bush and they find something, an object that could be described as a water gun, super soaker, disc shooter, Nerf gun, soft pellet gun, etc., do you think they might pick that up and play with that?
Absolutely, and I've
Okay.
had cases just like that.
Thank you. So do you think that that child could tell the difference between a toy gun, an imitation gun, or a 9mm or something like a real weapon?
Not necessarily. Many of them look exactly alike.
Thank you so very much.
Thank you, Mr. Chair. I feel you. I have a son who I've been looking for someone to see him in person, and that's almost been impossible.
Yep.
They're all online now, and that it's not as effective. So, but for my question is, this is the second or third panel of public defenders that we've heard from, and you make it seem like we have the answers now in the laws that currently exist. Yet the police department, one of the police departments in my district, he's saying every day, look, my hands are tied. I can't detain these kids. They're just repeating, and it's the same kid over and over again. So, from your perspective, does this legislation address those gaps?
I don't think it does. And here's the thing, police are a wonderful tool, but well, I guess they're a wonderful toolbox. They've only got the one tool though, and it's arrest. If you see what I'm saying, like not every problem can be solved with an arrest. There is the possibility, like the joins program, for example, I don't understand why they can't just refer that kids to that program without arresting them first. It's not my program. There may be something that really does legitimately prevent them from doing that. I don't know. But it seems to me that that would be the better solution than arresting a 10, 11, or 12-year-old, just to then divert them. It sends kind of a confusing message to those kids. So I would say in terms of the laws that exists now, we need I would say we need more robust systems. You know, the laws, if you want to think of them as sort of the skeleton, you know, they kind of are the structure for things. We need the musculature. We need a robust SIN system. We need therapists in person. We have so many needs, but this doesn't address those needs. And, you know, it comes to my mind that somebody, I think Delegate Clippinger, was talking about silos. I don't mean to offend anyone here, but I think you guys are kind of a silo too. One of the things that Delegate Clippinger said that I found interesting was that every committee touches on these issues. I think perhaps what we need is for all of the committees to then work together, because our communities, our families, our children are too important not to. Thank you. Does that answer your questions?
Further questions for this panel? Seeing none, thank you all very much. Melissa Goman, Yannette Emanuel, Alice Wilkerson, Kobe Little, Marlon Tillman, and on virtually Zainab Chowdhury. Okay. Whoever would like to go first.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. For the record, my name is Yannette Emanuel, Public Policy Director for the ACLU of Maryland, and we're here in opposition to HB 814, which as drafted is eerily reminiscent of the kinds of legislation that were influenced by the super predator myth and media propaganda, which perpetrated the harmful stereotypes that Black people, especially Black children, are inherently criminal and warrant excessive punishment. HB 814 does not increase support or services for kids, nor does it provide real solutions to the majority of the concerns raised during the last year, such as carjackings, which is already covered under our crimes of violence statute. What this bill is primarily focused on is expanding the net of incarceration by increasing the list of offenses that children aged 10 to 12 can be arrested for, reducing DJS's ability to divert nonviolent offenses, and creating new technical violations for parole, and increasing consequences for alleged misdemeanors, which, as you've heard today, will lock up more Black and brown children for minor issues. Truly improving public safety must include the safety and well-being of Black children who need and deserve comprehensive support during the most challenging periods of their lives. The fact is that crime rates are the lowest overall in the last 50 years, no matter what the sensationalism we're increasingly seeing from the media outlets. We must correct past mistakes and say no to policies that exacerbate racial disparities, ignore evidence-based best practices for improving public safety, and do not provide policy solutions or services to help our children succeed. We must recognize that children are still developing and may not fully understand or comprehend the consequences of their actions in the same way as adults. When young people make mistakes or break the law, it's crucial to treat them with the understanding that they are still growing and learning. While addressing violent crime in our community is important, attributing it to the wrong causes can lead us astray to the effective solutions. For the foregoing reasons, the ACLU of Maryland urges an unfavorable report on HB 814. Thank you.
Good afternoon. I'm Alice Wilkerson, testifying on behalf of the Maryland Youth Justice Coalition in opposition to HB 814. The coalition is not naive to the crime perception problem, but we know, based on over 20 years of experience, data, and research, that when it comes to public safety, what's best for kids is best for everyone. Our recent report explaining what that research shows is available on our website. We are your allies. Yes, we oppose this legislation as it is currently written, but we want the same thing:
safe communities, age-appropriate accountability for kids, and accountability for the systems that serve our kids and communities. When it comes to kids, accountability means teaching them to take responsibility, to change their behavior, and to make amends. When it comes to the system, we want accountability for DJS, law enforcement, prosecutors, public defenders, and all of our child-serving agencies. This bill will exacerbate racial disparities. It does not follow evidence-based best practices for improving public safety, and it does not provide policy solutions or services that will change youth behavior. As the committee contemplates this bill, we ask that you examine each provision and ask yourself, how will this improve safety? Is this an evidence-based solution? What is the racial impact? Will this lead to positive behavioral change? My JC is especially concerned that this legislation will grow the juvenile justice system, placing further personnel and budget strains on DJS that will lead to more cuts to services and programs such as the new Thrive program. We support the creation of an oversight commission and believe that this is the right step forward. Continual oversight and data collection are the best way to ensure the system is working as intended and to identify and solve problems as they arise. We know a version of this bill will pass. We do have suggestions for amendments, and we respectfully request that the committee hold public work group sessions. Thank you.
I'll go ahead. Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. I'm testifying on behalf of the National Youth Justice Network. My name is Melissa Goman. I'd like to focus our remarks on the bill's inappropriate expansion of the prosecution of 10 to 12-year-olds. I urge you not to return to criminalizing more young children in Maryland. Let us ground ourselves in what 10, 11, and 12-year-olds are like. These are children still reading Captain Underpants. They are too young to understand complex court proceedings or to participate meaningfully in their own defense, which is why, as you heard, many of these young children will be found incompetent to stand trial. But that's only after lengthy and costly competency proceedings. Also, as we heard, they will not be getting anything but restoration services. They won't be getting services that address their underlying needs during that time period. Additionally, incarcerated young children are at the highest risk of becoming victims of physical and sexual abuse. Even if they're not locked up, merely experiencing arrest, handcuffing, and prosecution at such a young age is a very traumatic experience that leads to a lot of trauma for young children. We also have the collateral consequences of a juvenile arrest record for these children. And that could be why the younger the age a child is prosecuted, actually the higher their recidivism rate is. We also know that this is not a consequence that will be inflicted on all kids equally. The juvenile justice system in Maryland and nationally is used overwhelmingly for disciplining children of color. There is no data to indicate a marked increase in offending in Maryland by 10 to 12-year-old children. Rather, we have fear that's been whipped up by some of the media outlets. A commission to help further successfully implement the JJRA and adequate service provision outside of the juvenile justice system would be quite welcome. I urge you not to drag Maryland backwards and urge an unfavorable report. Thank you.
Reverend Dr. Marlon Tillman with Bridge Maryland Incorporated. We are an interfaith organization that uses intentional relationship building, organizing, and intensive leadership development to strengthen congregations and faith leaders to demonstrate and advance justice in Maryland. So what have I been hearing? I've been hearing fear of children. I've been hearing empathy for children. These are all emotions. I'm also hearing facts which are impartial about children. What we're wrestling with is how to balance them both. And so when we think about how we balance them both, we have to do what scripture reminds me. And let's not have a spirit of fear, but of power, love, and self-discipline. And so we're asking you to still have the faith in the bill that you all passed just 2 years ago, twice. We're asking you that you use your power, the love in your hearts, and the self-discipline to convene a work group to get this bill right. Because we all know that there are challenges in our communities. The question is, how do we do it together? Delegate Pastor lifted up a quote earlier that I'd like to lift up another one. If you want to go fast, go alone. But if you want to go far, go together. Take all of these collective minds, bring us back together again, and let's do this right. Because if we do anything else, it's a recipe for recidivism and the trauma to the kids who we failed in our legal system and its processes. Let's move a little bit slower. Let's get it right. Because at the end of the day, we want to make sure we take care of our children and that we are letting our faith outrun our fears with facts that heal and support our children.
Good afternoon, Mr. Chairman. I'm the Reverend Kobe Little. I'm president of the Maryland NAACP. Madam Vice Chair, it is a delight to see you. It is good to see Delegate Embry, who represents my neighborhood. And it's also great to see all of my friends in the Black Caucus. You have heard many of the problems associated with this bill. My task today is to tell you that given all of these problems, passing this bill is the wrong thing to do. It is the wrong thing morally, and it is the wrong thing for people who believe in democracy to do. Democracy, one of the great values in democracy, is protecting the vulnerable. There are no more vulnerable people in our state than children. And please allow me to say, children are children. Children are children. Black children are children. Latino children are children. Poor children are children. And the state's responsibility is to protect children. I heard conversation in this hearing about 12-year-olds with guns. The question is not why do 12-year-olds have guns or whether or not they understand how dangerous the guns are. The question is, how come for generations we have allowed 12-year-olds to live in neighborhoods and in communities and to attend schools that are not safe? Why is it that the state has failed to provide economic security? Why is it that the state has failed to provide physical security? Why is it that the state has identified a problem, but has come with the wrong answer? The answer is to help the most vulnerable, not penalize. We urge an unfavorable report. Thank you, Mr. Chairman.
Ms. Chaudhry, please.
Thank you so much, Chair Clippinger, Vice Chair, members of the Judiciary Committee. It's really hard to go after Reverend Kobe Little. I feel like he just mic dropped it all, and he basically said everything that really matters in this moment. On behalf of CARE, I'm here to provide testimony opposing House Bill 814. I do want to just say that I deeply appreciate the very nuanced discussion and the in-depth explanation on the mechanics of this legislation. And I also acknowledge the complexity of this issue. And I understand that these decisions are very difficult to make sometimes, especially when you analyze on a case-by-case basis how children are affected and how our communities are affected by our broken systems. As an organization that's dedicated to protecting the humanity and rights of Maryland's diverse communities who disproportionately suffer the consequences of excessively punitive measures, we also recognize how hard-fought reforms to our system have been. It wasn't that long ago that our state ranked amongst the lowest in our country on the issue of juvenile justice. And this bill, we feel, moves us backwards, not forwards. We understand that there are very real conversations that need to be had. I love the idea that I think it was Allison who proposed of having work groups to discuss how we can address the deeper rooted issues. But we actually firmly believe that our juvenile justice system should be rehabilitative rather than punitive. Our key concern with this bill is the extension of the probationary period for children. There's research that proves that extending probationary periods prioritizes punishment and it subjects minors to scrutiny rather than addressing the underlying contributing factors and providing opportunities for growth. And we believe believe that this would be detrimental for children. It's really important to also look at evidence-based research, and research shows that extending probationary periods actually leads to more harmful consequences and to more crime. So we encourage that that also be taken into consideration. And even as we move forward this conversation, that we just explore ways to really bridge that divide and center children at the bottom of at the end of the day. Thank you so much.
Thank you once again, Mr. Chair, and thank you to the distinguished panel. I can tell you this has been an overwhelming day of emotions, listening to such compelling testimony when it comes to what's taking place with our young people. I am a single parent father. I have a 13-year-old son and a 16-year-old daughter. And every day I come to work, I think about their safety. I think about what is taking place in the educational space that they're occupying, and I wonder, am I going to get a call? You know, it's very challenging. My daughter may get it a little bit more than my son, who is 13. My question to you, with all of the different testimony that is taking place and all the needs for services and youth programs and all that, what do y'all feel is the path we need to be on to save lives? Because this is what we're talking about, saving lives and building families, right? It comes down to the family structure and saving our juveniles' lives, these 10-year-old, 11-year-olds, 12-year-olds, right? So we can't put everyone in jail. So what should we be doing with them?
Thank you, Delegate Simmons, for that question. Let me start by saying that policymakers should be talking to all stakeholders. I know the chairman. We actually live in the same city. We've never had a conversation about this. I know these district attorneys, these state's attorneys that testified here. They never asked me, what does the NAACP think? It is telling that power, the governor, the speaker, the chairman, elected officials from across the jurisdictions in this state can come together for a punitive package, but won't come together and say, what can we do to prevent the environment that breeds violence? None of this legislation that we're discussing today will stop the violence. At best, it will penalize people who do it. But even if you remove the individuals who commit acts of violence or who participate in crimes from their neighborhoods and incarcerate them and put them at the mercy of adults, the environment, the conditions will lead other children to the same outcomes. It's a setup. It's a setup. And I wish, Mr. Chairman, you had just talked to me and I could have said this to you privately. And then we could have collaboratively come up with a package that addresses the needs of children. If children fail, do you know it is not children's fault?
That's right.
Children don't have any rights. Not really. They can't even hardly figure out how to put their tennis shoes on. And yet, the most powerful place the burden for society's problems on the most vulnerable. It's shameful. And we can start anew. We can start afresh. We can do something different. But it starts with a conversation that is inclusive. And in Maryland, progressive Maryland, in Maryland, the home of Frederick Douglass and Harriet Tubman, we expect inclusive conversations that promote democracy and that regard security for all, not just some, as a value and a priority. Thank you for the question.
Vice Chair. I ask, and with all due respect, have you, Reverend Kobe Little, reached out to any of us?
Have I expected them to?
Have you reached out?
Have I checked with them?
Yeah.
I haven't. This legislation was a surprise.
No, my point is that we said all over the past 8 to 9 months, actually even before we left, we were getting calls, emails from various members of the community. And I did not receive any email from anyone in the community that said, well, put it this way, I'll go back to my question. This was not a surprise that a juvenile justice tweak to the JJRA was going to happen. So my question is, have you reached out to us, members of the Judiciary Committee?
Madam Vice Chair, I'm reaching out now when I became aware of this legislation. Typically, you and I have a relationship where if there's something that should be on my radar, you'll let me know. Listen, I became aware that these bills had been dropped and would have hearings this week and have waited every single day, checked every single day to see when the sign-up was. Do you know that in the Senate, the sign-up bit for this bill is today for a hearing tomorrow? That's outrageous. That's not designed to be inclusive. And the burden, there's one NAACP, there are almost 200 of you all. Somebody ought to let me know what's going on. But when I find out what's going on, I'm going to show up. So I'm here today.
That you're here because this is a very important conversation to have. This is not the end of the conversation. We're not putting a period on this particular issue. But I have to ask you, what do we say to the Black and brown children who are witnessing crime on a regular basis? What do we say to Ms. McKnight? Who lost her child to a 12-year-old? And I might have my numbers wrong, but my point is that they were children.
We say sorry. We have failed you. But now we're going to do everything in our power to address the issues that lead to the violence. Listen, the violence that was visited upon African people and indigenous people in this country, it feeds the violence today. And until we address the inequity and the iniquity and the hate that has driven that violence and infected this entire country with violence, we will continue to have violence. So what ought to happen is adults ought to own up and take responsibility for the situation. Adults ought to make sure that there are no children who are hungry, that there are, listen, I'm going to tell you a very personal story so you can know how this state criminalizes Black children. I was subjected to domestic violence as a child. And the person who abused me would abuse me and then call the police and say that they felt threatened. And when the police showed up, the police would try to bully me and scare me, and I didn't back down. And then they would arrive at this point. Well, son, we don't have any facilities to take somebody like you to. So either you stay here and suck it up, or we have to take you to juvenile detention. The choice is yours. And every day, this state, this government, forces children to make those kinds of choices. And then when they make choices in no-win situations, all of a sudden the state shows back up and blames the children.
I don't want. Okay, there we are. I was saying, Reverend Little, that I acknowledge and I am sorry for that incident happening to you. So I want to make sure I acknowledge that. I also want to acknowledge the fact that you and I have had conversations. Didn't catch you on this one, but I definitely talked to members of my community in Anne Arundel County. Truth be told, I missed meetings so I can make sure I talk to members of my community. And I'm sure that other folks here did too, because one thing that was sure that we heard over the interim was from the community. 100% we heard from the community. So with that said, that's not the question, the real question that I have. But I wanted to acknowledge what you said. My concern is the balance. And I believe Ms. Chaudhry put it, and I'm going to direct my question directly to you. You said that this is a difficult job. You said that it is a balancing. What I continue to say is I must support the victims. I also must support any means to rehabilitate a perpetrator. My question to you is there nothing in this bill that strikes any level of addressing the questions that have been presented with respect to concerns?
Love transcends violence. And so we need policies. We need policies that are love-oriented and not hate or punitive-oriented. And the reason I say this is because when I was a teenager, there was gun violence. In Baltimore, they had 300. In fact, the year that I was born, there were 300 plus murders in Baltimore. Violence is not a new thing. And incarcerating people who commit violent crimes does not stop violence. It only makes room for the next crop of people who are subjected to violent conditions. I'm just being informed that the question was not for me. So.
And that's okay.
My apologies, Madam Chair.
And I was about to cut you off, but you were going, so it's fine. If you want to wrap up, we'll then direct the question.
Let me just offer this one observation, and it's actually not on this legislation. On the exterior monitors, there is captioning available. I'm hearing impaired.
Right.
So I'm doing my very best with my 50 plus eyes to read your lips. It would be helpful if that same captioning that is on the exterior monitors was available on these interior monitors. And Mr. Chairman, I would be grateful if you would pass it on to the leadership that change might be effectuated. And to my sister, my apologies. Zainab.
No apologies necessary, Reverend. You are a mentor and somebody who I have learned from, so I appreciate your thoughts and input. And I'm very sorry to hear about your ordeal and your experience, but obviously you grew from it and you became a stronger person and a leader for all of us. To your question, Madam Vice Chair, I think that what we really need to do is look at what the factors are that are contributing to the violence. And I think a lot of times in our society, we're so quick to punish the crime and the act that we don't look at what the underlying factors are. And I think Reverend Little mentioned this like very eloquently, that we don't look at what the contributing factors are that are leading to that crime. And oftentimes children who themselves are traumatized or who themselves have experienced violence or oppression or suffering in some way, they haven't received an opportunity to really understand what it's like to have a life outside of crime sometimes. And I think that our system needs to approach this issue from a place of compassion and empathy. And I think what Reverend Little said about approaching this issue from a place of love and understanding that all of these children are our children. And if there is a 12-year-old who commits a crime of violence, it is an indictment and a failure of our society and of our collective inability to prevent the circumstances that led that child to commit that act of crime. And I think that work group that Allison mentioned would be a good place to start. Maybe bringing together community stakeholders who are involved in working with children or advocating for juvenile justice reforms and getting suggestions and feedback from them on how we can maybe conduct studies and tabulate reports and assess what are these factors that are contributing to this crime rate or to these incidents that are happening, and what we can collectively do to address the actual root cause of the problem instead of continuing to exacerbate the issue.
Thank you. And
Madam,
I guess the answer is nothing.
Could I ask?
Nothing.
I wanted to answer
Well, the work
the
group.
actual question too. Do you want to go?
Just really quickly, earlier you mentioned, what are we doing about individuals, especially kids who are witnessing and experiencing trauma? I don't see that in this bill. The other thing is that you talked about what can we do? Obviously, there are things that are working. Murder rate is down in Baltimore City. What we're really talking about is carjackings that are up, which is happening nationwide, which we should be discussing. But this bill doesn't address that either. And so I think a good place to start is expanding what is already working. And I think there's other legislation that's been introduced that's aiming to do that, such as expanding community violence interruption programs and such like that. That's a good place to start. So let's look at what's working and expand on that.
And
carjacking is not in this bill because it was in the Juvenile Justice Reform Act. So it's already we've conflated the two today. But I think you were talking about car thefts, and so that's
no, I was talking about carjackings because
okay.
but even when we're talking about car thefts, I think I heard one of the state's attorneys mention earlier, their goal in including this in this bill is so that they'll have more time to investigate and eventually elevate that to a carjacking charge, which is not, I think, what the aim of this bill should be doing.
No,
That's a
that's,
most
I can.
investigative issue, not a justice system issue.
Right, right. So Reverend Tillman, were you going to answer my question?
I'm going to ask you,
Thank
your
you.
actual question. You
Thank
said,
you.
what do we say to Mrs. McKnight? And I would say to Mrs. McKnight, you're going to be a part of the work group because you gave us an excellent example of how to solve this challenge. You said instead of teaching things that may not be necessary, how about teaching them things like civics? How about teaching them about what it means to do these specific acts? And I want to give you an actual live example. 3 years ago, I started a mentoring program at Edgewood Elementary School called Civics and Chess. I taught the kids what it means to go through the legislative process. What is the bill? They even watched the old video, I'm Just a Bill, all of those good things. Literally, I walked them through this. And so now in an elementary school, so now here we fast forward 3 years later, they're in an actual meeting preparing for advocacy day that's coming up on the 19th, and they were talking about a bill. And I stopped the video and I asked them, what is a bill? And all of them shouted out, it's an idea. If we begin to use those types of tactics, taking community leaders and bring them to this conversation, I believe we can get to the solution that we're all trying to achieve. And that's making sure that we're no longer fearing our children, but having empathy for our children sincerely.
Thank you, Mr. Chair. So I want to take a moment to talk about, talked about listening. I want to talk about what the members of this committee hear. Here, let me give you an email that I received that's very indicative of the nature of the problems, frankly, in Baltimore County right now. This is from Randallstown NAACP. The 2023 Randallstown NAACP poll found 90% of the respondents believe we need stricter juvenile crime laws. 93% of respondents believe we need stricter laws on repeat violent offenders. 83% of respondents believe we need stricter laws for thefts from stores. It's a whole slew of things. And this is why I'm reluctant to talk about one crime, because it's not one crime. It's a slew of crimes. When the Baltimore County chief talked about threat of mass violence, a child came into Kenwood High School and he said, I'm going to shoot everybody up. Baltimore County sent in a SWAT team, 20 guys, fully automatic machine guns, kids running everywhere. You want to talk about trauma? That's trauma. And these are one-off situations that we have to deal with every week now. So a proper juvenile system is about boundaries. It's not about sending kids away. And nobody's arguing we do that. I haven't heard that argument from one person on this committee, and I don't know if this bill does that. I do believe that is in part what this bill tries to do in several ways. But I got to be honest with you, there's not much accountability in the bill. It's small tweaks that try and address some of the problems we're dealing with. It does not send juveniles to the adult system. What I want to ask is, seeing this frankly very small bill, what are your specific problems with the bill?
Specifically, sir, this bill blames children. The issue, a child with a gun is an outcome of the issue. A child who is inclined to violence is an outcome of an issue. A child who is afraid, that is an outcome of the issue. The problem is that this society, this state, has failed our children. How do children get guns? Children don't make guns. Children don't buy guns. So the question is, why are we placing the burden on children? Moreover, why are we making it a punitive burden on children? When children are taught and raised and supported, financed by adults. And so if adults have not done the proper teaching, if adults have not done the proper financing, if adults have not provided safe environments, why are we blaming the most vulnerable? That, sir, is my problem specifically with this bill.
If I could add on to what Reverend Little mentioned, I think something that would make this bill more palatable from Kiera's standpoint is the component that extends probationary periods for youth be removed, just based off of evidence-based research. The fact that children whose probationary periods are extended leads to more adverse outcomes is something that I think that it gives us pause. We believe that if there's a way to tackle this issue without including elements that would exacerbate the risk of children being caught up in the criminal justice system, especially at such a young age, then there are other aspects of this bill, especially like listening through the testimonies, which definitely helped illuminate me more in terms of what the nuance of the bill is. I think if we were to remove that component, like that would make this bill more amenable.
So the bill does not send youth to the adult system. It doesn't even enhance detention. What we're arguing about is an expanded probationary period. And we're ignoring the fact that on the other side of every one of these crimes, there's a victim, they're likely youth, and a large majority of them are minorities. So herein lies my problem. There's a youth lives 60 seconds up the street from me. He's stolen cars over 10 times in a row. In the Dundalk precinct, the officers tell us when a youth steals a car, they will say, "See you tomorrow." Like they tell that to the law enforcement officers. And that's the reality of it. They can't do anything. We had this program. We had joins. That was our diversion program. You have taken that from us. So we're now teaching juveniles that there's no consequence for their actions. And, you know, I was a young man once. I understand that is necessary. We need to have boundaries here. Aren't we not teaching them that there are no consequences?
Sir, where are the youth workers that are paid by the state? For every dollar that the state spends on law enforcement and corrections for adults or juveniles, how many dollars is the state spending on youth workers? So we know that auto theft is an issue. We know that violence is an issue. Where are the social workers and the community leaders that the state contracts to go and intervene and engage? If you want a solution to the violence, that's the solution. Talking to young people, building rapport and relationship, and teaching them and showing them that there is a reason to feel hopeful, that the government doesn't hate them. But as long as you have a state seal that is two invaders, a farmer and a fisher, young Black children, Latino children are always going to feel like the state hates them. And then when you pass legislation like this, you confirm that hate. So the truth is that this legislation is just yet another example of a policy that perpetuates structural racism and inequity.
Thank you, Mr. Chair.
Delegate Grammer, if I could just quickly add, I think the point that you made about the victim, if I think about a 10 or 12-year-old child who is perpetrating these crimes, they also in and of themselves are victims as well. I think that the consistent dehumanization of especially Black and Brown communities leads to a lesser sense of empathy for those children. And I think that earlier intervention programs could be maybe one alternative to discuss. Again, I know this is a very complex and very nuanced discussion, and I really appreciate all the thought that's gone into this bill.
Delegate Tolles.
Thank you, Mr. Chair. Sir, which NAACP branch are you with? Are you next? He's the state. Oh, okay.
So I'm president of the Baltimore NAACP.
Okay.
I'm also president of the Maryland NAACP.
Okay. I haven't had a conversation with you. I would love to talk with you offline. I've never had a conversation with anyone from Prince George's County as well. In fact, since our beloved Father Ross passed on, I don't know who is involved with Prince George's County. And being a member of the judiciary, we just not the first time we hear issues like this. This is my third session. We've had issues all of this time, and I haven't heard from anyone. So I think that speaks to Madam Vice Chair point. But I would love to begin to have that conversation because I want to find a way that we could come to understanding because as I talked about, that our kids do experience trauma. So I want to be able to do what I can while I'm, you know, I'm a public servant. So my role is to do what I can to help the people. But I also want to make sure that we find a middle ground because I do have people in I represent a lot of older Black people in the community. Let me just keep it real with you, who have an issue with crime in our community, but also understand the need for our children. So I don't know who the representatives are in Prince George's County.
Well,
So
I'll
I
just.
would just close by saying, because it's been 4 hours, so and I, out of all due respect, I just want to say that I would love to just start that conversation. Isn't that so?
All right.
Thank you.
Thank you. Seeing Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel. Very quickly, to the First Lady to testified, would you say that the term that you use, super predator, could that be considered an alpha person? But more specifically to Mr. Alpha person is real. So to Mr. Little, would you say that we're talking about ignorance is no excuse for the law when it comes to these juveniles? I mean, how is a person supposed to know the consequences for their action when they haven't been taught these things? Thank you. Any response to you?
I didn't hear the first question you asked.
First question is, you use the term super predator.
Mhm.
And I'm asking you, could that currently be categorized as an alpha person? I'm using alpha person instead of alpha male. As I understand it, alpha males act differently in their environment than the regular males.
No, I wouldn't say that those are just two of the same things.
Okay, thank you.
Seeing no further questions for this panel, thank you all very much. I'm going to go now to Emily Virgin, Daniel
Thank you.
Berg, Josh Rovner, Ann Geddes, and then virtually Robert Melvin and Logan Seacrest. You have Logan? Okay. Whoever would like to begin, please.
Thank you. I'm Josh Rovner. I'm a District 18 resident and the Director of Youth Justice for the Sentencing Project. I'm going to focus on the probation changes, not because it's the worst part of the bill, but because it reflects the bill's mistaken approach. We've heard that youth on probation occasionally time out of supervision without completing their services, often due to delays in finding appropriate services or available providers. But the JJRA addressed that specific concern. Courts can already extend probation if there's good cause to do so, and the purpose of the extension is to ensure program completion. If there are real problems here, then let's solve those. If there's not enough providers, find them. If it's taking too long to connect kids to services, then hurry up. Longer terms of probation will not reduce crime, but they will catch more kids violating the terms of their probation. Now, for all of the attention on those youth who reoffend, the majority of youth, 63% who are referred to juvenile courts, will not return. At the moment of their referral, we can't predict which is which, but 6 months later, we can breathe a little easier that the ones who were referred on a misdemeanor and have yet to be rearrested, that's an excellent chance, that's an excellent indicator that we're looking at that 63% who are what we call one and done. The legislature now wants to more closely monitor those at the lowest risk of reoffending. And if it were in effect last year, this one provision alone would probably have cost about $16 to $22 million, way more than the fiscal note says. I'll be happy to walk through the math. Now, combined with provisions that reduce diversion, arrest more young children, add more probation violations, they'll probably even be worse than that. Leaders should make sure appropriate programs exist and ensure speedy placement of children and adolescents. The proposal on the table is actually an escape hatch for public sector incompetence that punishes teenagers instead of holding the right people accountable.
Mr. Chair, Madam Vice Chair, any delegates who still have blood sugar left. My name is Rabbi Daniel Berg of Beth Am Synagogue in Baltimore City. I'm testifying against HB 814 on behalf of Jews United for Justice today. At the press conference last week, President Ferguson said, while youth offenders account for less than 10% of the crimes committed, unfortunately, it is clear that they have become the largest part of the crime perception challenge in Maryland. I have no doubt the leadership's heart is in the right place, but doesn't this beg the question, if the problem is perception, wouldn't it be more productive to challenge the false assumptions? In his State of the State address yesterday, Governor Moore said, we must build stronger pathways for success for our young people, no matter what road they choose. I fear this legislation is far from the best rehabilitative pathway for our young people, especially children of color who will disproportionately, we've heard, suffer the most severe consequences. The governor spoke about the previous executive picking fights in the media instead of working with the State House. But let's be careful that the State House does not allow the drumbeat of an alarmist media to drown out our search for best practices. I get it. People are worried about public safety, and your constituents are demanding that you do something to address it. But doing something only works if it's the right thing. I'll close with this. I have the great good fortune of sitting on the board of the Elijah Cummings Youth Program. The late congressman, who was my congressman, used to say, our children are the living messengers we send to a future we will never see. We all know the quote. We will rob them of their destiny, he asks, will we rob them of their destiny? Will we rob them of their dreams? I implore you as a father, I encourage you as a faith leader, I ask you as a teacher, have we learned the lessons of bad policies from decades past? Policies built on targeting instead of investing in our youth, policies that underestimated the impulsivity of our young people and the plasticity of their young brains. Are there big challenges before us? No doubt, but we know from research and experience this bill in its current form does not contain the best solutions. To quote Elijah Cummings one last time, friends, we're better than this.
Thank you.
Mr. Chair and members, thank you for the opportunity to address you today. My name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. Of specific concern to us from a human rights lens is the new language on page 7, which would negate the minimum age of prosecution that was set in Maryland less than 2 years ago and seems to allow the prosecution of children younger than 10. Some of you may remember that just last year, our state ratings report honored Maryland as the most improved state after your passage of important reform measures, including the JJRA. But if this bill becomes law, the state would take a step backwards and lose credit because of the rollback of protections against prosecuting very young children. As we're rooted in international human rights standards, I must stress that one of the central pillars of human rights protections for children in the justice system is the establishment of a minimum age of culpability without exceptions. This committee is well aware of the brain science, but it bears repeating here because we're talking about very young children whose brains are very far from being fully developed. In 2018, ALEC passed a resolution encouraging states to set a minimum age of prosecution of at least 10, and several states across the country, red and blue, have set that minimum age of 10 with no exceptions, including Kansas, Louisiana, Mississippi, Nebraska, North Dakota, South Dakota, and Texas. When children under the age of 10 commit serious crimes, a response is needed. But because children this young cannot form criminal intent, responses from the state should be rooted in developmentally appropriate, trauma-informed measures. Children under the age of 10 simply cannot understand the consequences of their actions, cannot assist in their own defense, and would not be well served by a punitive system that was not built to serve children who are young enough to still believe. Thank you.
Yeah, thank you, Mr. Chair and committee members. I'm Ann Geddes with Mental Health Association of Maryland. MHAMD is a nonprofit mental health education and advocacy organization, and I appreciate this opportunity to testify in opposition to House Bill 814. We recognize that the proposed changes in HB 14 are a response to youth crime that has harmed communities and created a climate of fear. We urge you to address these concerns by implementing solutions that are most likely to have a positive impact. Detaining more and younger youth will not have a positive impact on juvenile crime. Numerous studies have shown that the best way to address juvenile crime and reduce recidivism is through diversion and through the provision of services. Behavioral health services are particularly necessary since over 2/3 of the youth involved with the juvenile justice system have a diagnosable mental health disorder, and over half of those also have a substance use disorder. Most of these youth have experienced trauma, which disproportionately impacts children living in poverty and Black and brown youth. Diversion in the provision of behavioral health services is all the more important since in the last decade, Maryland has failed youth with behavioral health needs, leading many to come into contact with the juvenile justice system. The system of care for youth with behavioral health conditions was dismantled during the last administration. Programs delivering intensive community-based services were terminated, and there was a dramatic reduction in the number of therapeutic residential placements, including residential substance use treatment. This has led to numerous crises, including the overuse of the emergency departments and lengthy hospital inpatient stays. But we cannot ignore the impact that this has had on juvenile criminal behavior. Youth who have experienced trauma often develop oppositional defiant disorder and conduct disorder, which can lead to criminal activity. These youth need services. For this reason, MHAMD opposes House Bill 814 and urges an unfavorable report.
Good afternoon, Mr. Chairman, members of the
Oh, I'm
committee.
sorry, Mr. Seacrest, correct. Go ahead.
Oh, yeah, thanks. Yeah, my name is Logan Seacrest. I'm a fellow on the Criminal Justice and Civil Liberties team at the R Street Institute based in Washington, D.C. R Street's been working on criminal justice policy in Maryland for a number of years. We were supportive when this committee raised the minimum age for juveniles in 2022, but we also appreciate that no reform is perfect. There's always room for improvement. However, believe HB 814 may have some unintended side effects. Our primary concern is a section on page 8 that could require police to file a formal complaint with DJS after every arrest. This has the potential to impact Maryland's many police-led diversion programs intended to keep kids out of DJS in the first place. Law enforcement agencies across Maryland are currently doing a great job providing alternatives to arrest. According to an R Street policy paper from 2021, these diversion programs prevent thousands of kids a year from entering the justice system. So requiring officers to forward a written complaint to DJS as specified in the bill could threaten these efforts. This would likely increase the number of low-level referrals in Maryland, which is already quite high compared to some other states. In addition, HB 814 would make unexcused absences from court-ordered programming a probation violation. 2 absences is a pretty low bar for minors who are often, not in charge of their own transportation and can be absent due to circumstances beyond their control. In fact, one of R Street's primary recommendations for states is usually to remove technical violations like this. And just this morning, I was looking over the fiscal note for this bill. I was surprised to see it would increase spending by $10 million next year, mostly to add DJS personnel. At R Street, we think this is a large expansion in the size and scope of government that requires additional scrutiny. Thank you very much for your time.
Delegate Embry.
Is it Ms. Virgin? Is it Human Rights for Kids? So one of the sort of contextual challenges we've had is the issue of the SINS process being so inadequate, and that frustration, because I think a lot of us were hoping that that would step in for young kids and do the job that we, when we raise the age of arrest. So I just wonder if you can point us to states that have successful SINS or the equivalent programs and the statutes that govern them, because I think we're interested in why, how that could work.
Yeah, I think that is sort of the crux of the issue, right? That that children who commit serious crimes who are that young, as I said, a response is clearly needed. But the delinquency process, we believe, is not the right process for them. But in hearing the many concerns about the SINS process in Maryland, it's become clear that that needs to be strengthened. And so I think that there are numerous states across the country. Utah is one that their minimum age law is different, but they have a really strong pre-involvement diversion process. They provide some really intense services that have proven over 90% effective at preventing children from ever interacting with the justice system. So that's one state that I would direct you to. Virginia is currently considering a minimum age bill of 11 without exceptions and using their existing SINS process. So I'd be happy to follow up with you to provide some more information, but you know, for children under 10 especially, those treatment and services are the things that are going to be most effective, but improving that system seems to be really the answer to the issue.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Mr. Crest, I believe it is. I have a question in reference to page 8. Do you think that the part that's being added in page 8 might help it be recorded equally where officers are having contact with these juveniles? In other words, in some areas, it's possible that the officer has contact with the juvenile and just takes the juvenile home, versus in another area, the officer might have contact with the juvenile and move the case forward. Do you think this will help with transparency?
Yeah, I think so. I think you know, just addressing that section would go a long way to clear up some of our concerns with the bill. You know, I was happy to hear the chairman touch on that diversion piece in his opening. You know, so we hope some of the changes, like you mentioned, Delegate Conway, are implemented before you decide to advance this bill.
Thank you very much.
Seeing no further questions for this panel, move on. William Rowell, Bernard Parks, Gordon Pack, Donyette McCray, Daniel Jarvis, and then virtually Nikki Owens and Kenneth Starks. Neither one. Okay. One more time. William, okay. One person coming up. Mr. Rowell, Raynard Parks, Gordon Pack, Donyette McCray, Daniel Jarvis. Go ahead.
First off, my name is Gordon Pack, and I thank everyone for being here and everyone who came before me. I'm hungry and I'm tired. I gotta say that. I have to. I'm not gonna be long, getting straight to the point. I'm really not in support of this bill at this time. And the rationale for me is simply that I think it's too premature. As someone who was adjudicated as a 15-year-old in the adult system, I know things a little differently from what you all may be familiar with. I'm one of the juvenile releasees. I did 42 years, almost 43 years in prison before I came out. And I'm involved in parole advocacy and information. I'm also involved in reentry, and I engage in juvenile justice forums. What I believe is that we need to slow the train up, as Chairman Clippinger used earlier. I think my concern is that the juvenile justice system may not be ready for an influx of people, and this bill opens the net for more younger and more people to get involved in the Department of Juvenile Services and also in the adult criminal justice system. I think this is very important that we need to look at this and see if we are ready. I think that we need to look at preventive measures before children get in this particular situation. I think that's very important, and we need to invest time and effort and energy in trying to make things better so children won't wind up in situations like I was in, where they won't have to waste their life. I think that the children are the future. They are who we should be concerned about. So I appreciate your time. Keeping it short, I want to eat.
Questions? Delegate Simmons.
Okay, how you doing, sir? Thank you and appreciate you being here today. Obviously, you said it's been a long day and it's been a lot of testimony. When we look at not getting into your case, but talking about what was missing during that time. So we're trying to look for resources. What can you tell me about resources that can help today's youth mitigate what's taking place in their space and keep them out of the penal system?
Well, first of all, I think that we need to recognize that children are children. We tend to think that children recognize harm, recognize consequences, and interpret those things like we do as adults, and they don't. As children, we can't see past 6 months from that, let alone a year. We don't even understand what detention is, what imprisonment is. We don't understand the full consequences of what we do. We should, but we don't. So because of that, we have to connect with children on a different level. I'm not one who feels like children shouldn't be detained. I don't have that opinion. I don't, because I believe I deserve to go do time. I don't believe I should have went straight to the adult system, but I do believe I should have done time. And I think this applies to other children as well. It's just a matter of understanding and deciding what's the best thing for these particular children, as opposed to worrying about how people feel about crime. I think we're reacting to the youth crime as opposed to thinking about what can we do to make things better for these kids. And this is my mission. I know what I went through, so I'm trying to do what I can to help.
Two people have come to the table. Would you give me your names and then you are?
Yes, I'm sorry. I heard my name was missed outside. It's been a long process. Boloon Zahir Shiamaru. Boloon.
Are you signed up?
Yes, sir. I have my confirmation.
Okay, and you're?
And Donyat McCray.
All right, we'll hear from the two of you for 2 minutes each, please. Whoever'd like to go first.
My name is Donyat McCray. I'm the aunt, the guardian, and the mother, auntie mommy of Kayla. Now Kayla was killed in 2022 to gun violence by another kid. We oppose of the HB 814 in its current form because the bill includes provisions of the Nakayla Strada Memorial Act. Last year, this was Senate Bill 15, and it passed the Senate unanimously, but failed to receive a full hearing or a vote in the House Judiciary Committee. This year in the Senate Bill 2, we are requiring that Nakayla bill be extracted from HB 814. HB 814 is a broad bill that contains many provisions that are not related to Nakayla or to the 9-year-old child that killed her. There are also some provisions of HB 814 with which we do not agree. No one spoke to our family or to Senator Carter when the decision was made to throw our bill in with HB 814. Chairman Clippinger, we ask that you show some concern for our tragedy and our grief, as well as our protective steps to pass legislation that might prevent another family from suffering the same indignity we have. We simply ask that mandatory intervention, treatment, and services for the child that killed Al Nakayla, we should have had to guess, help, or leave to anyone's discretion. We ask the dignity and respect for our tragedies, loss, and our desire to ensure children in Maryland receive the services, mental health services, and treatment they need to find remorse and repair the damage to their brains, heart, and spirits that caused them to commit such a violent act, and that they are rehabilitated to ensure that they are able to overcome their trauma, become fully functional, well-developed individuals. We ask that the same compassion this body has shown for Jayla's family and passing Jayla's law to memorialize that child. We believe mandatory child in need of supervision petition in these cases are necessary and productive steps in that direction. We are in favor of proper care and services for children rather than cages, when we know cages without care will make them worse, not better. Regarding the overall bill, HB 814, we don't support any provisions of the bill that are not evidence-based and seek only to look up Black children. We say Black children because of the disparate treatments most kids locked up are in Class K. We know there are little differences between way many members of the legislative body see Nakayla, her perpetrator, and all Black children. Many do not see any of them as having value equal or to that of white children, their value or their humanity. We ask that you pass Nakayla's Act as a stand-alone bill and not use it to soften or justify any arbitrary provisions of the HB 814. We are pleading today for not only for justice for Kayla, but for all children and particularly Black children in Maryland.
All right. Again, my name is Balloon. I was Nakayla's big cousin. I come to you today as not just a citizen of Maryland, but as a big cousin, as a son of someone, as her nephew. She took care of all of us in this family, and she was Nakayla's guardian, like a mother to her. I want to speak to two quick things really quickly. First, my family has taken everything from classes called the block captain class. We have started 2 organizations. Kayla's Way, I have an organization called Team Acorn, where we specifically work with kids from 9 to 15. What's my point? There's programs like this all around the city in Baltimore City, who we are all fighting and begging and scratching to get money for prevention and rehabilitation, and we don't get it, and we don't get heard. The second thing is that between this time since Nakayla has passed, I myself has served as my family's representative, because most people that look like me in my area don't know how to navigate Annapolis. You've seen me leave this place multiple times because we're having trouble just learning how to park in this situation, correct? So how many families do you think I've run into, and women specifically, who have lost sons, lost daughters, and they hug me and they say, Baltimore City Police can't figure out my crime, and I didn't even know how to start the process like you are. And they're pushing for us. They're really pushing for us to do this because we have done the civilized thing. We have started prevention programs and rehabilitation programs. We're not waiting for anyone. I'm here today asking for your partnership, because what has happened, as Brother Kobe talked about, is the power structures have coming down on me and my family. And that's the most hurtful portion. Really quickly, Mr. Clippinger, I'm glad to see you today. My family has been calling your office for about 18 months now, nonstop, and we've been begging to speak with you. One reporter since then was carrying this story that we were trying to get done. Her name is Nordea Lewis. I want you all to look it up. She's a young Black woman. She lost her job trying to get answers from Mr. Clippinger that he refused to give my family on multiple occasions. This is what was said from Mr. Clippinger just 2 months ago, in April of last year. I'm not going to take anyone else's time, but it's just important for you all to understand how the power structure works. When you contact and you call, and people say, we're not going to answer to this because we don't want to answer. And then when things change, you get answers. This is what Mr. Clippinger's statement was. In the last statement, we passed laws that increased the penalties for improperly storing a gun. That was the Jalen's law. They asked us to work with them so that they can pass that. A year later, Nakayla is now a young Black woman who has a bill. That bill was taken and put into this bill, and she was scratched out of it. And that's really disheartening. He said, after this tragic, avoidable death, the Baltimore Police Department should have identified the child involved in Nakayla's death as a child in need of assistance, since in the first place, as they can under the law. The Department of Juvenile Services has provided information to law enforcement regarding the process to do so. The committee will take up this issue in the session of 2024 should law enforcement fail to do so. This was April 2023. He still has yet to talk to my family. We are victims. I heard you all talked about victims this whole day. I had to wait 6 hours just to say what I have to say now, but we call. We take classes, we start programs, we talk to the news. The news reporter got fired for this message that I had. She no longer has a job. So while you all are here talking about justice, I'm going to leave it here, and I'm sorry for taking too much time, brother. But I think it's important for you all to understand that we are here not just to continue to say accountability, 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 but we all together have to be accountable. The police, the House, the Senate, everybody at the table has to be accountable because adults are the only people that can save children. That's my time.
Seeing none, thank you very much. That concludes the testimony on House Bill 814. We'll go now to House Bill 313. I'm sorry, we've spent 5.5 hours.
An email saying I can testify.
I don't have your name. What's your name?
Reverend Linda Boyd.
No.
Just 2 minutes.
All right.
I'll be short.
You have 2 minutes.
Thank you, Mr. Chair, Madam Chair. Thank you, Mr. Chair, Madam Vice Chair. I echo what so many people have said today. Look, I'm here on behalf of the Episcopal Church. No one wants violence in our community. We all agree that that's a problem that needs to be addressed. However, our take on it echoes a lot of what Reverend Little said. The National Church, Episcopal Church, has taken a lead on reparations. So has the Maryland Episcopal Diocese. Reparations is a form of repair for decades and decades of the effects of slavery, Jim Crow, redlining, the pathway to prison, pipeline to prison. We've seen the effects of institutional racism. We believe that this bill is well-intentioned, but we've seen over the years repeated attempts to reorganize, to do the right thing, and we all want to do the right thing. My father served on a juvenile commission back in the late 50s and to the late 60s for 10 or 15 years. They were talking about the same things back then. I think that what we need to do and what our church advocates is to look at the structural problems in our society. Yes, crime needs to be addressed. Absolutely. None of us wants to be terrorized or traumatized by crime. But we believe in loving our neighbor as ourselves, that every child of God deserves equal justice and equal protection in our society. Children aren't committing these crimes because they're bad people. I thank you for the time.
Thank you. You started off by talking about reparations, and I appreciate that.
Yes.
Can you talk to me about how would reparations be used in what capacity to mitigate juvenile crime?
Oh my gosh. Well, as a mother and grandmother, I can probably go on for about more than you want to hear right now. But yes, we need to support families. Families are stressed. They're working 2 and 3 jobs, trying to use mass transit that is woefully inadequate. Have you ever taken mass transit? I grew up taking mass transit. It takes at least 2 hours to get anywhere you want to go if the bus shows up. We need daycare. We need healthcare. We need families who know that they are welcome and supported in our society. Families don't want their children to act out. Families love their children. We all love our children and grandchildren, right? We want the best for them. But if you're dealing with problems with healthcare bills, trying to manage 2 and 3 jobs, and no daycare to support you, these are real problems that people need, much less job training. We need job training. We need, someone suggested we need people in the community to support these many organizations that are trying to do something. That's where we need our money to go, because if you support children and show them love, they would not want to do these violent things. People who are loved don't do violent things. Generally, people who are not loved or who feel traumatized or have been traumatized commit crimes of violence. And happy people, we want our children to be part of society. We want them to be productive members of society. We can only do this by showing them love and support.
Thank you, Mr. Chairman. Thank you for coming in to testify. I do have some thoughts about what your testimony was, but in specific, I'm in favor of education before rehabilitation. So would you say that knowledge is the same thing as education?
That what?
Would you say that knowledge could be equal to education?
Well,
What I'm referring to Hosea 4:6. My people are destroyed for a lack of knowledge.
well,
That's biblical. Thank you.
it is, no, but let me just say that education is very important and contributes to knowledge. So that if you don't have a good educational system that teaches someone how to cope in our society, they aren't going to have that knowledge. What they'll gain is street knowledge, or they'll gain knowledge from other children, but they won't gain the knowledge that we want them to gain.
Seeing no other questions?
Thank you, Mr.
very
Chair.
much.
Chairman, I also received an email to speak.
I'm sorry. No.
If I
That
got you
concludes
done.
the hearing on House Bill 814. I'm sorry. We've called everyone on the list. House Bill 814 is concluded. If you'd like to come on up, that's fine. We'll take it. Go ahead. 2 minutes. Is there anyone else in the room who was on the list? What's your name?
My name is Fred Chavis.
I'm sorry?
My name is Fred Chavis. I'm chairman of Liberation Inc., a nonprofit based here in Maryland.
Go ahead.
Thank you. Peace of love to the house. Been waiting here a long time. I have a 3-month-old daughter, so I'm really just trying to get back to my kid. But while I'm here, I will make sure to use my time. I've noticed that with especially Black youth, they have a negative self-image of their self. And a lot of that is perpetrated in our schools and is perpetrated in our government. And bills like this reinforce the fact that a lot of our Black youth are indeed bad, and that is not the case. I've seen this in education as a teacher. I taught middle school, and it was precisely with the ages that we're talking about right now. And many times I saw Black youth especially that received behavioral intervention plans when in reality they needed an IEP. There was kids that couldn't read, but instead they was punished for it. And what we see with this bill is I see a lot more punishment, but not addressing the root cause of what is going on in our communities. There's a hypocrisy of the youth that we care about in this country. And many times we tried this tough on crime approach, but it didn't work the first time when you was locking up our Black fathers. So now we're trying to do it again, and we're trying to force our kids into the system. Probation doesn't work for adults. Many times adults can't fulfill the needs of probation because it's set up as a broken cycle and a trap. So how can we expect our kids to fulfill the needs of probation? That makes no sense. And so as we begin to do our work with our nonprofit, we focus on redefining the self-image of our youth. We take our kids outside of their communities and show them different opportunities while bringing them back into their communities to be leaders. We work with people on the streets. We work with everybody in a coalition. We have a ceasefire in Western Maryland amongst all the gangs that's in Maryland because we know what it takes to really get this going with working with our community. Instead of funding government, we need to be funding community organizations and programs that actually have access to the kids. I've learned that our youth need consistency and they need trust. If they don't trust you or they don't see you, it's not going to work. And it's already a mistrust now with our government and our children in our Black communities. So what I'm looking at is for us to address the root cause. Let's talk about poverty. Let's talk about food deserts. Let's talk about the fact that some communities don't even have clean water. Our schools are run down. Our houses are run down. Let's talk about capitalism in this country because these bills do nothing but reinforce that notion, and you punish the victim when you should be looking at the oppressor. Thank you.
Thank you.
I'm assuming there's no questions.
Are there questions? Thank you. You
Thank
were
you.
signed up. Appreciate it. That concludes the testimony now for House Bill 814. Going to House Bill 313, Delegate Attar.
Thank you, Mr. Chair, Madam Vice Chair, and members. For the record, I'm Delegate Dahlia Attar, here presenting House Bill 313. I just want to tell you all that the next 6 bills, a lot of it is going to be repetitive, so I'm going to keep it short. I just want to say briefly that there have been many people here in the committee doing great work for years to strengthen our juvenile justice system. However, although we may want to believe so, we are not miracle workers, and therefore, we may need to tweak the policies we've set in place after seeing how they work in reality. I spent countless days as a prosecutor in the Baltimore City Juvenile Justice Center, leaving work in tears, countless days thinking about my own children who are now 10 and 11 while standing in the courtrooms. countless days hearing mothers begging me to help their children so they stop ending up in the system. And I still remember an 11-year-old crying to me because he didn't want to be detained, and his grandmother crying to me that she needed him to be detained because of how violent he is becoming. And in that courtroom, I remember where I was standing and which courtroom it was. I had tears coming down my eyes because all I could think about was my children. This is why we're here today. We're here because we have to do right by our children. We have to make sure that treatment is in place, and we have to make sure that accountability is in place to keep our citizens safe. So very quickly, House Bill 313 authorizes a court to place a child on probation for a term that the court determines is appropriate to ensure that the child is able to complete any necessary services and treatment. So the goal of this is we want the term to be the length of the treatment, because that is the goal. That is the way we are going to keep children out of the system. And with that, I ask for a favorable report. Thank you.
Thank you. My name is Ivan Bates. I was here most of this morning talking. So I have presented letters. I will rely on my letters. I think you've heard enough from me. However, I do have the head of juvenile here is with us, as well as the deputy. I'll go ahead and let them go ahead and speak. And if you have questions, you can probably direct it to them. If you need me, I'll talk, but I'm not trying to.
I will try to speak quickly. My name is Pam Chung. I'm the Division Chief for the Juvenile Division of the Baltimore City State's Attorney's Office. I've been a prosecutor for 22 years. We are supporting Delegate Attar's House Bill 313 because in essence, what it does is it moves away from the arbitrary timelines based solely on the type of offense a juvenile is charged with. The juvenile system is about rehabilitation. It is not a penal system. So we should not be putting strict timelines on the rehabilitative needs of a juvenile offender. It can't be based on an objective standard. The juvenile system is and should be geared toward each individual juvenile. We cannot treat each of them the same because services rendered will be based on the needs of the particular youth. It should be individualized. There are many factors that are taken into consideration when a decision is made regarding the supervision level and services needed for any juvenile offender, such as a youth's history, any prior contacts, family background, educational background, mental health issues, any trauma issues, and much more. The court should be afforded the discretion to make an informative decision when determining what is in the best interest of a youth. The state should also be afforded the opportunity to contemplate a probationary period that accurately reflects the full rehabilitative needs of a juvenile offender. It cannot be one size fits all. We are asking this committee to issue a favorable report on the bill. Thank you.
Good afternoon. My name is Catherine Rosenblatt. I am also a prosecutor in the Baltimore City State's Attorney's Office in the Juvenile Division. I am the deputy, and I will just say ditto to everything that my chief just said.
Great. Well, we've got questions. Yep. Delegate Crutchfield and then Delegate Simmons.
Okay, thank you very much. Madam Chair, just a quick question for you. Don't courts already have discretion to increase probationary periods if necessary for, issues such as, such as diversionary programs, and make sure that the child gets through the diversionary program?
So they do, but my understanding from the experts that I've spoken with and my colleagues sitting next to me is that it's not enough what it is right now. The extent is not enough. So the 1 year for misdemeanors, the up to 3 years for the felonies currently is not enough.
Right, but I'm saying don't the courts still have discretion beyond that to put in place a longer period of time? And I see heads shaking, but go ahead.
No, they actually don't. The way the laws are currently set are that for a misdemeanor, if committed by an adult, a misdemeanor would be 6 months maximum. Then you'd have to go back to court to decide whether or not you want to ask the court to try to extend that. And these are in 3-month extensions.
Gotcha.
So every time you ask for an extension because services or the youth is not, is not complying, or there's some type of issue, then you have to keep coming back to court for those 3-month extensions. And on a misdemeanor, it's a 1 year maximum.
Okay.
So their hands are tied. Felonies, it's a 1 year max. And then again, there are 3-month extensions for those, again, if the services
But
are
up to a year for the misdemeanors. and up to
Misdemeanors up
years.
to a year, the felonies up to 2
Okay.
years.
Gotcha.
Delegate Simmons.
Thank you, Madam Vice Chair. So thank y'all for coming out once again, and I understand it has been a long day. Can you talk to me about the process and penalties associated with probation? So for example, are there any fees assessed to individuals that are on probation and juvenile?
No, there are no fees assessed.
Okay, thank you.
Delegate Grammer.
Chair, I appreciate the bill because I'm all about boundaries in the juvenile system. And I think that's something we should strive for. What does probation mean in terms of the bill and the way it would work?
So with regards to the probation period, the reason we're asking for the courts to have the discretion is because, let me give you an example. If you have two juveniles, juvenile A, juvenile B. Juvenile A has no record, has no contact with the juvenile system. Juvenile B has had several contacts with the juvenile system, has been under supervision in the past, has had services through the Department of Juvenile Services. It's just the type of offense, say they're all misdemeanors. And so, we're at a level where 6 months of probation is what this youth is apparently going to be seeing based on the current law. But if you allow the courts to have the discretion to determine the probationary period, that way you're not treating juvenile A and juvenile B the same way. What you're seeing is juvenile B, the one who's been through the stiff system, who's received services in the past, and maybe, through an investigation with the Department of Juvenile Services, we learned that they were non-compliant at times during the time of their probationary period. At least the courts can then say, hey, juvenile B probably needs more time, needs more probation, needs more services, needs more intensive supervision than juvenile A. But unfortunately, the way the laws are written now, they're both treated the same way.
What it means for the juvenile is access to services, a little bit of supervision. What does it mean for the juvenile?
Well, it really depends again. It depends on what the youth's needs are. Usually in these types of cases, when they've been through the system a couple of times, we have what's called a disposition. The Department of Juvenile Services will do an investigation and report. And that's when they go in, they investigate the family, they'll talk to the parents, see what the home life is like. What is the child's educational background? What are the mental health? Are there any mental health issues? What types of services does this youth need? Then the department will put a package together for that youth. And then depending on the amount of probationary time the court orders, those services will be put in place for that youth. And it could be therapy, it could be mentors, substance abuse, if that's an issue. So it could run the gamut depending on the child's needs.
Finally, can you give me an example of what can happen if you don't have sufficient time to provide probation for a youth that you believe needs it?
What I've seen currently is, and it's been said before, it really depends. It depends on if the services were never put in place or they were put in too late. A lot of the courts will say at that point, it wasn't their fault. And so they won't receive services, and then the probation will end naturally. And then you've got a youth who you knew there were issues there and you could have helped that youth, but because the probationary period was so short and the court didn't want to, I guess you could say, penalize the juvenile because of the lack of services, then you've got a youth who just went out who needed services.
Okay, thank you so much.
Delegate Conaway. I'm sorry, Delegate Williams was first. Thank you for the chivalry, Delegate Conaway. All right.
Appreciate it.
Delegate Williams.
Thank you, Delegate Conway. Appreciate it. So with this bill, it basically allows the courts to make the decision about when the period should end. I guess I have two questions. You mentioned having to go back every 3 months. Is that something, because I didn't see it specified here in the bill, is that something that you are anticipating would occur indefinitely, having to go back to the court every 3 months?
That's the way the statute's actually written.
Okay.
So if it's a misdemeanor and you have a 1 year max on that, it's a 6 month minimum,
right?
6 month maximum. And then at that point, you have to go back to court for those 3 month extensions. You have to show good cause as to why you need those extensions.
Okay.
Excuse me, I'm sorry. I think your question, if I'm not mistaken, Delegate Williams, is that with this particular bill, would we still be asking for the 3 months increments?
Yes.
That the answer to that would be no. What we're really saying is that when the youth completes their probation successfully, it should be able to end. But the court must have the opportunity to make sure that the youth is completing their probation successfully. We're not trying to go back every 3 months because you bring the mother, the father, the family, the youth, everybody. But if you know from the very beginning that you're on probation until you complete this program, then everybody kind of understands what they signed up for and what's going to happen.
Okay. And I guess, I mean, one of my concerns is just, and I think this is one of the reasons why we passed the legislation previously we passed, is that we didn't want to see people on probation indefinitely. And so I guess what guardrails are there if we were to pass this bill that would not happen again?
Well, I think the first thing would be that, it ends when they successfully complete their program. So it's more or less focusing, the way I'm looking at it, on the program itself. Now, in terms of the youth, if they do not successfully complete the program, then I think at that moment in time, the court and DJS are going to have to come up with a plan in terms of what they do. But I mean, I think that's also why to me, when you look at the previous bill, why you do have a quote unquote arbitrary time period, because then it kind of ends. But to me, the whole focus and purpose is for the youth to be rehabilitated. So I think when you look at the law, what is DJS's recommendation if this youth has decided they do not wish to be rehabilitated? And that's why I think if you tie it to a program, then it's almost sort of like, hey, when you finish this program, then it's over.
Right, Madam Chair, I had a follow-up question, which actually led me to my second question, which is the previous bill and the timeframes that are being proposed in the previous bill. Do you feel as though those timeframes are not sufficient, or, I mean, just
hypothetically, I feel those timeframes are sufficient. However, I do feel that, what if you have a youth and it's a 2-year time period, but the program is 14 months and the youth completes the program of 14 months, then I think there's a reward for the youth to say, okay, you completed your program of 14 months, you're finished probation. Because some youth are able to be rehabilitated based on the program because they've taken it very, very seriously. This is what they want to do. And some youth are going to say, I'm not going to do it, but then they shouldn't be rewarded because, the program, your probation ended in 6 months, but then DJS would be able to say, okay, we have 2 years to get this young person straight. So I kind of look at it from a hybrid point of view. When Delegate Attar put this in, we were looking at it from one point of view, but I think you kind of look to see what would make the best plan moving forward. So I think, looking at it, if you have the time period to say this is what it'll be, but if the youth can complete the program separately, and if you base on the program itself, it gives the youth an opportunity to want to finish as quickly as possible.
Okay. All right. Thank you.
Sorry about that.
Delegate Conaway.
Thank you, Vice Chair. Thank you, panel, for coming in to testify. Thank you, Delegate, for speaking to me about the bill earlier. I had a question for the state's attorney Bates. I was wondering, how do you avoid the disparity of treatment in different jurisdictions around Maryland if you don't have a guideline?
I think, to me, that's always, when you look at disparity of treatment, it's always going to be a particular issue. But I think one of the things that you do understand is, under the previous bill, you have a commission. The commission is going to look at data, and the data is going to sit down and look at what's going on. I think that'll help you understand what's going on in terms of managing and understanding what every particular jurisdiction is doing. But right now, we don't have a quote unquote commission like, I think it's Bill 814. I'm terrible with numbers. That's why I'm a lawyer.
814.
I believe Bill 814, you have that commission. That's what the commission would do. They would look at the data, and the data would be what it is. And you'd be able to understand the age, the race, the sex. You take the data, and then based off that, you'd have a better understanding what you're able to look at and see and do. We recently had a citation docket in Baltimore City where we were able to look at the data to understand something we thought was particularly going to happen. We looked at the data, the racial data, it didn't happen. So I think the commission would be very helpful to get that data.
Well, respectfully speaking, I disagree with you. I don't like that variable that you're talking about, but I want to know, what's the difference between completing one of these juvenile programs versus we're having problem with our young people completing high school? What's the difference between those two things?
Well, I mean,
Can I jump in very
Jump
quickly?
on in.
Our next bill actually
I'm
addresses,
on this bill. I'm on this bill.
so
See, I tried to take it easy on you, but I'm on this bill.
I will say I have another bill that addresses if a child is not completing their treatment. And I wasn't as smart as Madam Speaker and your chair for making one big bill.
Well, I don't know about that because sometimes bills are taken without their sponsor saying it's okay. So go ahead.
So, so like I said, the next bill I can.
Thank
that
you.
would
I'll wait
address it.
for you. Thank you.
Thank you.
Okay, State's Attorney Bates, don't feel bad. Many of us became lawyers because we're bad with numbers.
yes, all right, we're good company.
All of us. Delegate Taylor?
Thank you. Thank you, Madam Chair. Do we have precedent in any other state maybe that gives judges the authority to continue to extend probation based upon successful completion of a diversionary program?
I don't know the answer to that, but I can follow up afterwards with that.
Thank you.
Sure.
All right, seeing no further questions for this panel, we're gonna move on to unfavorable. And I'll call up Jeremy Zacher from the Office of Public Defender and Marguerite Leno from Office of Public Defender.
Ready when you are. Good afternoon, everybody. My name is Jeremy Zacher. I'm an assistant public defender and I work in Baltimore City in our juvenile division. This is an indefinite probation bill. Indefinite probation does not work for children. It's been proven not to work for children. There are studies that show that longer periods of probation are not associated with lower rates of recidivism, but they're really associated with those high rates of incarceration. The JJRA and the JJRC together came to a conclusion based on studies what the appropriate time of probation would be. It is not rigid. 6 months to a year for a misdemeanor is completely appropriate. And if DJS can't provide the services for a whole year, that is punishing the child because probation doesn't just come with a requirement to do a program. It comes with restrictions. You must go to school. You must be home on time for your curfew. You must make all appointments with your DJS case manager. You must make it to court. And frequently children do well with the programs, but children are not very punctual. Children do not always make their appointments. Sometimes children are late to school. And before the JJRA, these excuses were used to keep kids on probation longer and longer. Kids were languishing on probation for years. And so the JJRA cured this by providing the guidelines. It's 6 months to a year for misdemeanors. It's 1 year to 3 years for felonies. That is more than sufficient to determine what a child needs, to give them the services, and then to free them from the restrictions of probation if they're not reoffending, if they're doing well. The judges and prosecutors, when they were given a free hand, abused it. I've had many children back in the day kept on probation for 4 years, 5 years. They would come to court. Mom would say they're disrespectful. Well, I'm keeping you on probation for another 3 months. They'd come into court and they missed some school. Well, I'm going to put you on probation and put you on house arrest and put you on a GPS monitor. That's what happens to kids on probation. Probation begets more probation. These restrictions you all placed in were very important. They are working because kids have a goal in mind and they know when they're getting off. And DJS knows when this is going to end. And so there is a fire lit under them in order for them to provide the services that the court orders. And the court pays attention to the time frames. So the court has been pushing DJS to provide the services in a timely manner. And we've also asked that DJS be held in contempt when they don't provide the services in a timely manner. The current system is working. It does not need to be extended. It does not need to be changed. We do not need to go outside best practices. And so we are asking for an unfavorable report on House Bill 313.
Thank you. Leno.
Thank you. Good evening, Madam Vice Chair, members of the panel. Again, my name is Marguerite Leno. I'm the District Public Defender for Baltimore City Office of Public Defender. Kids need to have an understanding of the start and end of probation. And I would just give a comparison of, if you've ever seen a child sitting in church where they have no idea when the service is going to end, their ability to sit still is unremarkable. Kids are not good when they don't know when something starts and when something finishes. Probation is not a diversionary program. Having discretionary periods of probation is not the measure needed to decrease crime. This would be a total rollback of the JJRA and JJRC. Again, there's already a measure in place, which Mr. Zacher has spoken to, that allows for extensions of probations. The maximum for a misdemeanor is 1 year. I won't go through all of it because he's recited again. The idea that we need to extend probation terms as a mechanism to end probation early when a treatment program is ended early understates the fact that probation can be terminated early for a child who is successful already. Extending probation from the onset extends system involvement before it is necessary. Speaking to the realities of having practiced in Prince George's County in youth defense and working with the youth defenders in Baltimore City, the reality is that judges are bringing kids in at least monthly for status hearings. This means it should be clear when something isn't working on probation early on in the probation. The JJRA and JJRC are less than 2 years old. It's clear that the community is looking for something to be done. The job of public service is not easy. It is a job of public servants to engage in tough conversations with the community members and deliver the message that change takes time. Change takes time. It will take more than just 18 months to see the fruits of the JJRA and JJRC. Do not rest in the comfort that extending probation by any means is going to have some miraculous change to what is going on. These reasons we're asking for an unfavorable report on House Bill 313.
Thank you. I see questions and I happen to look this way first. So I'm going to go with Delegate Boucher. Oh, is that Delegate Simmons? I'm sorry, is that your light?
Delegate Simmons Boucher.
We're
a team. Thank you.
Delegate Simmons Simpson Boucher.
Thank you. Appreciate it. Thank you all once again for coming out. I have two short questions. The first one is that juveniles that are placed on probation, are they required to take a drug test during the extent of their probation?
That can be a condition of probation,
That
yes.
can be a condition of probation. Okay. Do you find that with that being a probable condition of probation, would you say that there's a likely chance that they will extend out their time based on those failures in the notes that are sent back to the judges from their probation officers?
Yes, testing positive for an illegal substance, including marijuana, because youth are not allowed to smoke marijuana, could result in a violation of probation and an extension of probation.
Thank you.
Delegate Grammer and then Delegate Phillips.
Thank you, Madam Chair. Thanks for being here today. Do you find that sometimes in state law that crime that is a misdemeanor and a crime that is a felony can be arbitrary? Maybe there's a penalty associated that can be arbitrary. Do you find that ever?
I think that we could have arbitrary in any, yes, it can be arbitrary.
With that in mind, do you think basing periods of probation on crimes with arbitrary classifications may result in a period of probation that in itself could be a little arbitrary?
No, because I believe that when there was a body that was convened to determine what was best and what should be in the JJRA, there were people who did research and studies and evidence-based and science-based on what the periods of probation should be. And so based upon that, I don't think that we could call it arbitrary. It's actually based on science, it's based on research, and it's based on what's best for children, their children.
I participated in the juvenile fatality review team. We got to look at children who had perished or were involved in a killing while in the prerogative of the juvenile system, and we got to see their entire record. And it always seemed like everything had been provided 100% properly. The Department of Juvenile Services had never done anything wrong, but we continue to hear examples of we're failing to provide services, kids falling through the cracks. Doesn't it make a little bit of sense to say, we have officer discretion and discretion at, intake at the Department of Juvenile Services and discretion in the courts, maybe we should have a little bit of discretion here as opposed to saying, well, this group picked these timeframes and they're perfect. Don't you think we should have a little bit of flexibility to ensure that we're not just saying, well, this kid's going to get 6 months and bon voyage?
I'll let Mr. Zacher speak to part of your question, but again, we're not just picking this and pulling this out of the sky. I like to believe that there are people who are much smarter than I am who came together based on science and evidence and came up with what is the best practice. To answer your question, you just said that, there are the children who were engaged, and it comes back that they didn't have the resources, they didn't have the programs, they didn't have the supervision that was necessary. And so if there were more discretion, they would be less likely. If it takes longer than 3 years for a nonviolent felony, which probation can be extended for a nonviolent felony up to 3 years. If it takes more than to the age of 21 for a crime of violence, because probation can be expended up to the age of 21 for a crime of violence. And if it takes more than a year for a misdemeanor, I would say it's not the kid that we need to look at, it's the programming and what program are we offering and what treatment are we offering that we cannot see the sufficient results within that time. So again, let's not hold the kids as the problem. Let's, as the adults, look at what we are giving the kids and make changes to the programming and not to what the children are being held accountable for.
It's a little bit of a rigid answer, but I appreciate it. Thank you.
Thank you. And Madam Chair, thank you for allowing us to continue. I know it's been a long day. I'm trying to understand this issue of programming, and is it improving access to programming? Is it improving? Has it gotten worse since JJRA? And what can we do to address that issue so that we don't have to extend probationary periods? Because my sense is everybody is saying we need to extend the probationary periods because these children need the services. They're not getting the services in time, or the programs are taking longer than a year in the case of a misdemeanor, or 3 years in the case of a felony. So am I missing that?
No, I think there's a couple of things we can talk about as public defenders, but that's kind of a question that should be directed to the Secretary of Juvenile Services, Mr. Schiraldi. What I can say is we could make greater use of our diversion programs, which are almost immediately available, rather than going through an adversarial process in the courtroom and working it out that way. Certainly funding and resources and personnel is always something that could be improved, and we would want to see more of that as well. But how the services are being delivered, what providers are DJS accessing to provide to the children, that's a question that needs to be put to DJS.
In your advocacy role, hopefully potentially even before adjudication, are you in those discussions with DJS as to looking at diversionary options for the young people that you represent?
No, when the child is going through the DJS intake process and DJS recommends the diversion, the Public Defender's Office is not there because the child has not been formally charged. And our role only comes into being when the child is charged and applies to the Public Defender's Office for representation.
I'm wondering, and I've asked this question, and I don't want to create an adversarial process before there needs to be an adversarial process. But there are a lot of people that touch these children, and OJP touches these children in a significant way, as you say, after they've been adjudicated. State's Attorney's Office touches these young people before they've been adjudicated, but before you get involved, right? Potentially. Yes. I'm just trying to figure out, how do we get people to the table to have conversations about what might be best for a child in a given situation before everybody gets into an adversarial situation. There may not be a process that we can do that with, but it bothers me that we can't. Isn't that so?
Yes, and I think the way to solve that is something like what we did before the JJRA, which is the JJRC, the council that got together and listened to people's complaints and issues and things we saw wrong with the system, and they brought in experts and they discussed it. And if a council like that was formed again and that task was put to them, I'm sure they would come out with some potential solutions that this body could consider. It's hard to answer that kind of question on the fly. Please.
I have just two questions. I was looking at the final report of the JJRC, and didn't the JJRC allow for children under 13 to be charged with misdemeanors if they are charged with a crime of violence?
Yes, if the misdemeanor is involved in a larger crime of violence, yes, they can charge.
Right, and didn't JJRC also allow attempts to commit any of the crimes under 14-101?
I'm not sure about that one. I'd have to look.
Ms. Leno, do you know?
I would have to defer to one of my colleagues. I'm not sure without.
Okay, well, it is listed on the final report that I'm looking at, where they list all the crimes. So I will refer you to the final report. And if you could just confirm with me when you talk to your colleagues, I'd appreciate it.
Yes.
Okay, great. Thank you. Seeing no further questions, and given that Jacob Castro is not available online. Okay, and it looks like okay, great. It looks like I omitted Laura Wilt in the favorable panel. Thank you very much, you all, for testifying. So Ms. Laura Wilt is testifying favorable.
Hi, thank you very much. Laura Wilt, I will be brief. Again, I'm with the Frederick County State's Attorney's Office, Juvenile Division. Happy to be here. Thankful to the delegate for sponsoring this bill. I certainly, as you heard me say before, I believe every probation should be tailored to the needs of the particular youth. And this legislation gets at that need. Rather than a mandated number of months, the language goes to the need. I think some of the questions that were posed earlier is that this language is sufficient to allow attorneys to argue that it shouldn't, the question was, this could go on forever, way too long. Probations in the past attorneys can ask for review hearings, request that these probations be closed, happens all the time. And I believe this language is sufficiently defined to allow closure at the right time and not have probation go on forever. I would say in my personal experience, those reviews every 3 months are arduous. They are hard on the families. We are mandated to come in. I've had the attorneys arguing to close the case, and the juvenile stand up, happened yesterday, stand up and say, I understand both sides. I need this treatment. I'm not asking the case be closed. I mean, it's a frustrating scenario to have court hearings that have to be set in when we have a judicial system that absolutely allows our defense counsel to file, request a review hearing, and be heard to get those cases closed if that's what's appropriate. So thank you.
Thank you. And again, my apologies. I see no questions. Oh, do you have a question? Okay, Delegate Conaway.
All right. Thank you so very much. I'm in disagreement with your opinion. I guess you know that, because I like to know what it is I'm facing and how much time that would be. So do you think that this could open up the door for a disparity of treatment around the state? In other words, I don't feel, if I have to be cold-blooded honest, I don't feel that I would get the same treatment as someone someplace else in another jurisdiction who their uncle might be very influential or cousin might be very influential. So that I'd rather know exactly what number I'm facing.
I think you can get that number. This legislation doesn't prohibit the court from saying, I'm putting you on 12 months supervision. It also can say 6 months, it can say 18. It
Yeah,
can,
yes, but I understand that. So person A could get 6 months, person B could get 12 months.
right.
Is that right?
and-
Is that correct?
Absolutely.
Okay, I'm just saying on the record, I don't like that. Thank you very much.
I understand. And I have more faith
I
in
have
our
that faith.
advocates and our judicial
No,
system.
I don't have that faith. In God we trust. All others pay cash.
I do that as well.
Right.
Thank
All
you.
right, thank you, Ms. Wilt. So Delegate Attar, you're up again on House Bill 314.
Thank you. Thank you, Madam Chair. Colleagues, House Bill 314 authorizes the juvenile court, when it finds a child's committed a technical violation of probation, to order community detention for a first violation and for subsequent technical violations, detain or commit the child. Now, when this idea was first brought to me, I was like, what? A technical violation? We would do all that? And then I realized after doing research, technical violation could be treatment, and treatment may be the only way to rehabilitate our children. So that is why I said, yes, this is a good piece of legislation, and I put it in and I asked for a favorable report.
You have my, already my testimony written, and my team is here to answer your questions.
I'm here to answer your questions. So basically, with regards to Bill 314, it is supporting one of the fundamental pillars of the juvenile justice system, which is accountability. Currently, there is nothing prescribed in the law if a youth is found to have committed a technical violation. He or she cannot be detained. There are no sanctions in place to try and curb those behaviors. And when I say technical violation, it can be not attending school, not obeying the rules of the home, not meeting with your case manager, not participating in the services that were ordered by the court. These are not acts that should be taken lightly. Basically, the message that's being sent is there are no consequences for the types of violations, and it sends a message that it's acceptable behavior. So we are asking for a favorable report on the bill. Thank you.
I am also here to answer your questions, and to just say that sometimes this is, or rather that this is a response, or we're asking for a favorable response, because sometimes we have parents who call us and say, I don't know what to do. He's not listening, and our hands are tied because we don't have any response other than to set yet another hearing where the child is told by the magistrate or the judge, yet again, you have to follow the rules of probation, and the child has no response.
Delegate Simmons?
Yeah, thank you, once again. So right back to one of my earlier questions. When someone is violating these orders, is there an escalation of penalties handed down by the court, or can there be as a result of?
Well, in this bill, that's what that does.
Right,
Yeah,
so it would escalate it. So we talked about the extension of probation, whether it's 1 year or 2 years or 3 years. So with that escalation, it could work its way into multiple years based on violation of the current status of the individual.
Yeah. Not currently, not with technical violation.
Okay.
The probation can only be extended at 3-month intervals.
Okay, so with this, it would allow for the extensions prior to 3 years, 3-month intervals.
This bill allows for a escalated response to the continued violations of probation that is independent from the period of probation. So it's a response to situations that we get where the youth has not been compliant with probation and continues to not be compliant with probation because they've become aware perhaps that they can just sit out the clock and wait.
Delegate Conaway?
Chair, thank you panel for coming in to testify. In reference to these 3-month intervals, how many 3-month intervals can a person receive, let's say in a year? Could they receive 4 in a year?
Well,
For
currently.
the violations, yeah.
Well, but this doesn't have that.
Well,
That's not this.
Well, I
bill.
was just asking, following up on what the good delegate asked you, you used a 3-month interval, and I thought that's what I heard, so I figured I could ask you about it.
Currently, under the bill, if you are on probation for a misdemeanor, you're on probation for 6 months. And that probation can be extended by 3 months twice.
What happens in the third month? I mean, the third period, your third violation.
You can only be on probation for a year. The
Okay.
probation ends.
Well, my main question was in reference to the technical violation. So you could get 6 months, 2-3 month technical violations for not attending school. Is that right?
Do you mean currently or under this
I'm
bill?
seeing a nod, yes, and so am I not asking the
So-
question right?
Under this bill, if you don't attend school the first time, the judge can order community detention for a first violation. If you continue to not attend school, a second violation or subsequent one, the judge can detain or commit the child.
For how long?
It would be for whatever the current law is for the period of probation. So if this passes as well as the other probation bill, it could be for however the judge determines. But if it's with the current law, it'll be in the 3-month intervals up until the maximum of what you could be on probation
So the
for.
maximum would be the 2 penalties periods of 3 months each, and then your probation time. Is that right?
I'm not following, I'm sorry.
I think with the maximum, for instance, under the current law, the maximum is for misdemeanor is 6 months, so 2-3 month periods. And then when it's over, it's over. Like when they say sometime the juveniles, they'll wait and do nothing until probation ends and there's nothing you can do. What this bill seeks to do is when we have the technical violation, that the court has something to hold them accountable from the very beginning to say, look, you know, you have to do A, B, C, you have to go to school, you have to do this, you have to go your drug treatment, you have to complete this program. So what this does, it gives, i.e. the judge, something that they can say that the youth must do, and if not, there's a consequence.
I think there's a confusion. A technical violation and a different type of violation, they are different. Technical violations, things like not going to school, not obeying the rules of the home, there are no sanctions for that. So basically, the kid would come to court and the court would reprimand them. With regards to the 3-month extensions, that's for a regular violation of probation other than a technical violation.
Technical or an other violation?
That would be an other violation.
And, okay, thank you very much.
Delegate Grammer?
One brief question. Why is community detention the appropriate action to take for a technical violation?
I think it gives a sense of what we're asking for is they're still in the, they're still in the community. But it also puts a safeguard in saying that, you know, you haven't been abiding by the rules of your home, you haven't been going to school. And so you're kind of putting, it is a sanction. You're putting a sanction on the youth for non-compliant behavior, a technical violation. And then it gives them the incentive, and it's actually an incentive for them to do better and maybe go to school or listen to your parents in the home, so that when you come back for a review of court order, we do come back if the child is on CD, every 14 days, or they were required to have a review hearing on detention every 14 days by law. At that time, if the youth has been doing very well, then the CD comes off.
And may I also explain, community detention is electronic home detention.
Mhm.
We're not, community detention is not, we're putting them in a detention center. We're just saying, you're going to be on electronic home detention, and this way DJS can track to ensure that you're going to school. That's all this is saying. So I don't want people saying, oh, you want to just detain these kids and lock them up. We're saying there's got to be a consequence, because right now the kids are like, I'm doing what I want. There's absolutely no consequence. So the consequence here is you have an electronic monitor on your ankle, and now DGS can track you, and we can ensure, you know what, GPS shows that you're not in school. GPS shows you the Towson Town Center, and you go to school over there in Woodlawn, you know, for the Baltimore County reference.
Thank you. You got it.
Delegate Conway, are you, okay.
Thank you. In reference to your last response, State's Attorney, so what would be the consequences of a person that has the ankle monitor on, but it comes outside the house and goes to the mall or something? Is that the small technical violation, or is that the big technical violation?
I mean, that's just a technical violation. If you're placed on CD, then it's just considered a technical violation. That's not an original violation of probation.
Subject to what?
You'd have to come to court and we'd have to decide if you're on CD, obviously you've already had one violation,
Yeah.
so you would get stepped down to the next sanction, which would be either the, sorry,
Detain or commit the child.
detain or commit the child.
Thank you very much.
Delegate Crutchfield.
Madam Chair, just a really quick question. So we're saying for kids that suffer from truancy repeatedly or absenteeism from school, they possibly could be detained, is what you're saying. If they are doing this, this is their second or their third technical violation.
It would start with the detention in the community, which is really just a higher level of supervision, either GPS or what's called CDEM, community detention, electronic monitoring. They actually have different anklets and monitor different ways. So if there is repeated truancy or repeated absenteeism, what the response is, it's an escalated supervision. Any detention outside of the community would be entirely dependent on the severity of the underlying fact sustained count.
But the point is, it's detention because you were absent and you were truant. Correct?
It is, but I don't
Thank
want
you.
this
That's
committee.
all I wanted to know. Appreciate it.
Can we say something very brief? Because I think there's some confusion. It's just not. So if you do something relatively small, then no, it's not going to get to that point. It has to be something of note, if I'm not mistaken, before it rises to the level of being able to be detained in a facility. It's just not going to happen. 99% of the time, the only thing that's going to ever happen is the electronic home detention, and you're going to have the agents DJS coming to your house more often. Now, for instance, a misdemeanor is also a handgun. So if the juvenile has a handgun and they refuse to go to school, they refuse to do anything, and they have this handgun, then yes, that young person with that handgun could eventually maybe be detained in that regard. But once again, it's the handgun, and that's a misdemeanor, but it would be that type of misdemeanor in reference to doing that.
But State's Attorney Bates, I don't believe you can guarantee that a child who is a truant, right? Truancy habitual will not be detained in some kind of way, right? I mean, you're talking about escalations, you're talking about the types of detention, but there's no guarantee of that, right? This is just an estimate, or this is just some guidance that you believe might occur. But I mean, I'm just saying, clearly they're going to be detained some kind of way, right? After that second time. And that's all I wanted to point out.
Even
Correct?
if I agree. I think the purpose of this bill for us is there no consequences for technical violations. So even if you say, hey, I'm going to take out the part where they can be committed, then we're saying at least give us the CDEM in reference to that. You know, for me, there's got to be some consequences other than the kids just saying, you know what, I'm never going to go to school. I'm never going to do anything. I'm never going to go see my agent. I'm just going to sit here and do whatever I want to. And then the mom or the father comes to us and say, I need help. Because by that time they come to say they need help, unfortunately, the next time I see them is when something terrible has happened to that child. And so we're trying to say, with these technical violations, give us a tool so we can hold them accountable. But if you're like, hey, I don't ever want them to be incarcerated or detained because of these technical violations, okay, I'm not here to argue with that. But what I'm here to say is give us something, electronic home detention. To me, if you feel that is the least restrictive means that for young people, then that's something better than we have now.
Okay, like I said, I'm just concerned about the habitual truants who now are detained. So but we can talk further offline.
I totally understand it.
Appreciate it.
Thank you. Thank you.
You don't let it go? Oh, great. You get 2 points for letting it go. Okay, thank you. Thank you, panel. All right, and you get one. Ms. Wilt, Ms. Laura Wilt, would you come on up? And I'm going to have you come on up now, but on the next panel, I'm gonna make sure you're up there at the
All
beginning.
right, fair enough.
Okay, so Ms. Wilt is here for favorable.
All right, yes, thank you, Laura. Well, Frederick County State's Attorney's Office, and I am here testifying favorably on behalf of this bill. I do see the benefit of having a statute that allows for progressive sanctions. So as you've already heard it from everyone else that right now we have no ability to respond to technical violations. And that is a message that has resounded with our youth. They know they don't have to comply with the court order. So what are we going to do about that? Progressive sanctions seems to be a very reasonable way to address this issue. I am certain that if anybody signed up to oppose this, they're going to tell you horror stories about the kids who have been locked up for minor technicals. Oh, I had a kid, he didn't go to school one day and they were locked up forever. There is the rest of the story. Or there's a judge or a magistrate that should not be on the bench anymore, and a public defender that was sleeping on the job, and a Department of Juvenile Service worker who didn't report into supervisors. I mean, there are a lot of people accountable for that. If some youth is going to detention for not going to school for a day, and then you go to get committed for being truant, and that's the only issue, either somebody's not telling you the whole story, or there's a lot of people who should lose their jobs. That's the truth. I mean, we're trying to sit here and say, oh, we're going to lock up kids for not going to school. Maybe the answer is, if we look at this, that this sentence will allow it. But the whole rest of the juvenile laws that are in place don't allow that. Because you have 38802, 03 that state the purpose of our juvenile court and why it's set up and why it's there. Juvenile public defenders have a job to do. We all have a job to do. So I just think it's the big picture. Ask for your support of a progressive sanction.
Thank you. Are there any questions? Seeing none, that concludes the favorable panels. Now we're going to move to unfavorable. Mr. Jeremy Zacher and Ms. Marguerite Linnell.
I'll go first. Thank you. Thank you. Thank you. Good afternoon, everyone. This bill is designed to lock up as many kids in detention as is humanly possible. I don't know why anyone would say it's the public defenders not doing their jobs. It would be the prosecutors asking for detention, and they absolutely would do that for missing school. First, let's start with the community detention. If a child is on probation, the judges have full authority to put them on community detention with or without a violation. They constantly do it. And community detention is not just a monitor or house arrest. Community detention could be any program monitored by DJS, such as an after-school program. Community detention has a much broader definition in statute than what was mentioned earlier. But judges have full authority to use community detention options while a child is on probation without a technical violation. The problem is giving them the ability to detain for technical violations. Every probation order tells a child to go to school on time every day, every single order. So if a child is late to school on their first day of probation and late to school on their 100th day of probation, that's 2 violations. That child can be locked in a cage, removed from their home, sent to a remote placement. This bill will explode our juvenile jail population. It will overwhelm our placements. And if school is really the concern, putting a kid in detention lowers the likelihood that child will finish high school. Putting a kid in detention increases the likelihood of recidivism. Even for these minor technical violations, I guarantee prosecutors will be asking for detention for minor violations. I've seen it time and time again. My office was relieved when the JJRA passed because we no longer had to worry about kids going off to placement for these minor technical violations. We are asking for
Good evening again. I'm Marguerite Leno, the District Public Defender for Baltimore City, and this bill is disguising the desire for treatment under a cloak or an avenue for further incarcerating children. Extending a probation of a child doesn't require a violation of probation. You can extend to complete services as it stands currently. Being able to violate kids on technical violations means that there's an easier path to take children out of the home. This is punitive. It is not rehabilitative. When the kid is not, who is not attending school or the ordered treatment or abiding by the conditions of probations, you can look to section 388A8A-1, and I'll read it here for you. Community detention means a program monitored by the Department of Juvenile Services in which a delinquent child or a child alleged to be delinquent placed in the home of a parent, guardian, custodian, or other fit person or in shelter care as a condition of probation or as an alternate to detention. Community detention includes electronic monitoring. So if treatment is the goal, and the concern based upon this bill is mistreatments, we haven't yet heard anything to address why is the child missing treatment? What is the reason that the child is not going to treatment? All we've heard is there has to be a graduated sanction when the child is not going to treatment to punish them. We still don't get to the root cause or to what the goal is supposed to be, which is to give them the treatment that they're not receiving by not going. This bill is going to have a disproportionate impact on families who are of limited means. It will further separate families of colors, families who are struggling with all the things that we know that families are currently enduring as a result of many different factors. For all of these reasons, we ask for an unfavorable report on this bill.
Delegate Grammer.
Madam Chair, thanks again for being here. So when I was on the juvenile fatality review team, every single one of those cases of youths who had died shared two things. Every one of them shared these two qualities. They were all from Baltimore City, and they had all gone truant at least once, if not indefinitely. And I suspect that's why you see the Baltimore City folks here today. The problem with truancy, and if you stick around and watch the juvenile issues long enough, you learn that the schools hate the Department of Juvenile Services, and the Department of Juvenile Services hate the schools. And they both blame each other, and neither one has a fix. And the parents go, I don't know what to do. So if this bill is not crafted perfectly for this problem, the need is there clearly. And if we go, we have to address the why, we have to address the root cause, that is weird. Nobody's capable of fixing the root cause, but we need a boundary. So if the bill's not perfect, in your opinion, how do we properly create the boundary? Because you can't do nothing. Because these are kids that have died. Remember those kids.
Truancy is a problem in Baltimore City.
It is
what we call chronic absenteeism. The court system is not the way to solve it. The court system has no authority to order the school to do anything. And many of my clients, they have individual educational plans. They're in special ed. They're low functioning. They have all kinds of educational problems, and the schools are not serving their needs. And as they grow older and figure out that the school, number one, isn't educating them, and number two, isn't going to care if they show up, then they don't show up. It's not a delinquency problem. It's a school problem. Last year, there was an article saying that I think 13 public schools in Baltimore City didn't have a single child who was proficient in math. Where are the bills on that? Where's the accountability on that? Right.
They're all different.
And I have tried with the schools. My office does sometimes represent children in their IEP meetings, if any of you know what that is, or their due process meetings with the school. And the school puts up barriers. They put up a fight. They make the kids fight for their free and appropriate public education. Truancy is a school problem. It is not a delinquency problem, and the judges and the courts and the prosecutors should not be involved in it.
Now, if I could just add one thing, you don't fix a problem by creating another problem. You don't fix the problem of truancy by saying, well, detain the kids, put them in detention, and they still don't get the education. So after you've taken them, they're not going to school, right? We're taking them out of the home. We're putting them in detention. They're gonna come back into the community. So at that point that they're coming back into the community, what benefit have you served by putting them in detention.
I would say first and foremost, if you said the schools don't serve the kids, they don't care about the kids, I know a lot of teachers and principals and superintendents would have a real problem with that statement. And what you're doing is the same thing everybody's done, like nobody's listening. Nobody's listening because nobody's got a solution. And what they're asking for here, what you do, your question is, what do? You create a boundary. Where's the boundary? And what they're saying is a 14-day reviewable community, like we've talked about this exact issue so many times. Community detention. Everybody loves community detention until somebody suggests 14-day community detention. Then it's like, well, now, heaven forbid. So we're kind of doing the same thing we've done for years here. If they're asking for something simple to address, truancy is like the key sign that a youth is coming off the rails. It's the sign. It is the sign. So I'd love to hear a suggestion, maybe later, if you want to send me an email, follow up. I'd love to hear a suggestion from you how we make this bill work. Thanks so much.
But let me just say, judges still can place kids on community detention if they're missing school. They can do that without this bill. Community detention does not get kids to go to school.
Okay, Delegate Conway, this will be, and Delegate Simmons.
Vice Chair, thank you panel again for coming in. I've been hearing the truancy issue being described as a sort of a behavior problem. So, and as I see it, in some people's cases, the juveniles are making decisions not to go to school, but they might be making decisions not to go to school to do a side job, which we would call a side hustle. They need food. They need their BG&E cut on. They have to help their parents out. They might have to get Pampers for their little sister or little brother, so they need a little change. Unfortunately, they might be squeegeeing, which is annoying, but they're trying to make it. So how do you deal with that situation?
Well, again, I think that goes back to that this bill that's before us, before you right now, is not addressing any of those things, because again, you graduated sanctions. We're still not getting to the why. We're still not addressing the needs that we know that are there. And we're also overlooking that some of these measures already exist. We do not need to take away or just have this unlimited, unfeathered access to take kids out of their home, to place them on community detention, to not address the why. And again, if we're truly concerned with treatment and education, then nothing in this bill to treatment or education. It just gets to detaining and punishing children.
And you didn't say anything about the potential consequences to the parents. Thank you very much.
Okay, Delegate Simmons, if you could make it as quickly as possible.
Sure, I'm just trying to get clarity. So when we talk about community detention, obviously, can you tell me a little bit about when it comes to the courts and the final decision of extending community detention, who is the courts?
So the courts are either the magistrates or the judges who are reviewing the case.
So it's not the state attorney, it's not the public defender. So at the end of the day, the bottom line relies on the judge in that courtroom.
Yes, and the state's attorneys, public defenders, DJS, and parents and child, of course, can all make their own recommendation to the judge.
But the judge has the final say.
Correct.
Thank you.
Okay, that concludes the testimony for House Bill 314. And now, Delegate Attar, I'm going to ask you a favor, please. We'll let Delegate Cardin go next with House Bill 31. His daughter's birthday is today. So we need to make sure.
Yeah. 12 years old. You don't know how much clapping I need. It's getting started. It's getting started.
All right, so this is House Bill 31. Delegate
Thank you for your
Cardin.
indulgence. House Bill 31, Delegate John Cardin, asking for a favorable report. Let me just preface this with this bill, which is not drafted properly, and I'm going to need maybe some help with the juvenile subcommittee on this. The intent of it is very simple. That when a young person, a juvenile, is being bullied and threatened, particularly online, which is happening more and more these days through social media, through emails, and through other virtual communications, and they are being threatened and harassed and tormented to the point where they are in a very vulnerable state, they should be able to get a peace order to ask the person who's doing this, another juvenile, to stop and to make it required that they stop doing this. That's it. That's what the bill is intended to do, is to allow this person to be able to get a peace order. And as the law stands right now, because they are both juveniles, the court does not have jurisdiction over them. The Department of Juvenile Services does. So the request for a peace order has to go through the Department of Juvenile Services. And with all due respect to the Department of Juvenile Services, which came in opposed to this legislation, the fact is that this is not a priority for them. They have other issues that they are dealing with. And cyberbullying between two people who have no interaction with the Department of Juvenile Services is not on their priority list. So when these issues come into them, they are, for all intents and purposes, ignored. And I say that, again, with all due respect to the department. I don't hope, maybe they're here, hopefully to testify, maybe not. But I have tried to reach out to the department now at least 4 times. And the only way I can get them to talk to me, because I have not gotten a call back or an email, is to put in a bill and have them come to testify. And I'm not saying that they don't want to solve this problem. I'm just saying that this is not a priority. So I'm asking the committee and the chairman of the subcommittee to help us figure out a way to protect these young kids who are really being harmed. That's it.
Okay, great. Thank you. Now is Matthew Markhorn, is he?
Matthew's most of you know Matthew. Matthew just put in the legislation, but he did work on this and he's in the gallery
Behind you. I just wanted to make sure he wasn't going to testify. He didn't want to testify. Okay.
I don't think so.
Okay. Well, great. Do we have any questions for Delegate Cardin on his daughter's 12th birthday? Delegate Arakan.
Thank you, Madam Chair. I actually just got a text message of a suicide of a youth in my area, literally while I was sitting here. What happens when the youth violates the protective order? What does that look like?
It's not it wouldn't be a protective order, it'd be a peace order.
Okay, so what happens?
If there is one that it's actually.
Yeah, let's say we put this into effect, the child continues to bully, what happens next?
So then the Department of Juvenile Services would have the jurisdiction over them to require them to do, and we've spoken about programs and other, whether it's a diversion program or whether it's some sort of penal, type of determination, but the department could actually impose that, and that can actually happen. But the problem is that neither of these individuals have any involvement with the department yet. There's been no violations. There's been no problem. They have no history. So the department doesn't see this as a priority. That's the issue, is getting this started, getting the process started.
Right.
As far as I'm concerned, the department is far better at knowing the type of program or the type of response that needs to be had to a violation of the peace order. But as far as I'm concerned, we need to allow these parents to empower their children to have this stopping.
Yeah.
And for those of you who remember, I had Christine McComas was going to be here. She was supposed to be here, but they ran late. But she's the mother of Grace McComas, whose daughter took her own life because of cyberbullying.
Yep.
That's what it was about. So, and these, by the way, and I get these calls all the time from parents all over, usually in central Maryland, but all over the state, saying, what can I do? Howard County is the best county in terms of dealing with cyberbullying, but
that's good.
We need to get our other counties better at realizing this is a serious issue.
Well, thank you. And please tell your daughter happy birthday from us.
Thank you.
Delegate Conaway.
Vice Chair, thank you, Delegate, for putting the bill in. I just want to be clear on something. Since this is a juvenile case that we'd be talking about, would this be on the case search on computer?
No.
Thank you very much.
Delegate Grammer.
Madam Chair, this is an important bill on juvenile crime days. Department of Juvenile Services, are they testifying today? I haven't seen them.
No.
Okay, thank you.
Oh, it was a question for me. Okay.
Good question. Thank you.
All righty. Thank you. Thank you, Delegate. And
I think that the
happy birthday to your daughter.
Are you testifying? Yeah.
Oh, my apologies. My apologies. I am moving things along a little too quickly here. My apologies, Jeremy. So we have unfavorable Lauren Dollar, Jeremy Zacher. And that is all that I have on my list. So whoever would like to go first,
Sure.
please go first.
Hi, good evening, everyone. Lauren Dollar, Office of the Public Defender. I represent young people in Baltimore City. So the reason I signed up to talk about this bill is that the way it's currently drafted is not how Delegate Cardin was actually describing what his goal is. So the way this currently drafted falls into the bucket of changes that are being sought to end around diversion. So you heard me talking about diversion earlier. And so this would require, the way it's currently drafted is that it would require all cases referred to the state's attorney's office for possible petitioning. And so that's why I signed up. If it's a peace order process, that it gets amended to be a peace order process, I have not much to say about that myself. So I think that the main point is that currently under the way that forwarding to the state's attorney's office, well, the way that it works with informalization right now, when that's on the table, is that a letter would go out to the person who's being bullied, who could then appeal the informalization if that's how DJS chose to address the behavior of the child, if that makes sense. And then the appeal would then send it to the state's attorney's office. That would still be on the table the way that the law is right now. And this law seeks to take away the opportunity for diversion to happen without the state's attorney's office then overriding that decision, probably because that's the way that they approach cases, is to prosecute them. So I have no issue. I think peace orders are a good way to solve problems. Thank you.
Thank you. I'm going to ask for an unfavorable, again, because of the way it's worded, it incorporates both peace orders and petitions. I have to say, DJS not returning your 4 phone calls is wildly unacceptable. And I feel for you. Sometimes I don't get phone calls from them, but I always know the right people to call, and they have my cell phone. But I also feel like fixing this through legislative action is too big of an approach. This sounds like a personnel problem. It sounds like somebody in DJS or even the DJS higher ups are not being responsive to your concerns. And just as a general matter, I do worry about changing an entire statute over what may be just someone needs to be fired. So based on the way it's worded and based on what the motivation for this is, on behalf of the Office of the Public Defender, I'm going to ask for an unfavorable. That's all I have to say, Delegate Bartlett.
Thank you. Thank you very much for your well-stated opinions and your testimony. My issue is that do you believe that if 2 children who are not engaged with the Department of Juvenile Services, who seek a peace, one seeks a peace order against another, simply because of their age, they have to go through the department instead of just getting this action to take place? I'm only talking about, forget about petitions. I'm talking about peace orders. It seems to me as if we maybe have things, the way the law is written right now, you can't seek that type of relief without going through the department. And it seems to me as if you guys would help us figure out a way to do this, I would be ecstatic.
Isn't that so? Okay, Delegate Phillips.
No, I think my colleague, Delegate Cardin, has raised a real issue about process. And I think I was kind of aware of this. I think we had talked about it briefly. So the same thing that's afforded an adult is not afforded to our children, right? Because I can go get a peace order and the court's going to listen to me, and perhaps it will or it won't. I don't know. I'm sorry, Madam Chair, but this is bothersome to me because we need to figure out how to address it. And like Delegate Cardin, I'm not sure that forcing them into the juvenile justice system is the right answer.
And let me just say that the way that the bill is written right now is that it will be forcing those children into the system. And so that's why I'm asking for an unfavorable report. But if it gets changed to address the problem articulated by Delegate Cardin, that's a different story. Because right now it's an override of informalization to force the possibility of a petition, which would bring young people into the system more, even if both sides don't want involvement in the system.
And you all are not aware of any other states that have addressed this issue then?
I have not done research.
Okay, thank you.
Delegate Conaway.
Thank you, Vice Chair. Thank you, panel, for testifying. Who under this bill, who would file this petition?
Usually it's if the victim is a child, it's usually their parent filing for them.
So what is the parent's involvement? The one parent would go and file on behalf of their child, and the other parent of the juvenile child would receive the paperwork, is that right?
They would receive paperwork for a hearing. Both families would need to show up before a judge. There's no public defender in that room.
What happens if the parents don't show up?
Then the request for peace order gets dismissed and no peace order is issued.
Thank you.
Thank you. That concludes our hearing on House Bill 31. Now we're going to move on to House Bill 483, Delegate Attar. And I don't see State's Attorney McCarthy. Laura Wilt, thank you for coming on up. And you may begin whenever you're ready.
Thank you, Madam Chair and members. House Bill 483 would provide jurisdiction to juvenile courts for additional offenses for a child committed, for a crime committed by a child over the age of 10. I will say that a lot of this overlaps with the previous bill. This would include, in addition to that, possession with intent to distribute, sex offense, 4th degree and 2nd degree assault. I did hear the concerns that were discussed all day with the current crimes that were in there. I could just tell you the reasons why originally I was okay with putting these other offenses in was, for example, possession with intent to distribute. Many times I worked in narcotics for a long time, and that's how we're getting children killed, because of the drug distribution. So that was my original concern. But again, I did hear everyone's concerns, and it gave me a lot to talk about. Sex offense, 4th degree, my concern with that was if a 10-year-old is committing an unlawful sexual touching on another person, many times there's something going on to that 10-year-old who's doing it, and we need to find a way to intervene. There may be other ways, but to find out what's going on with that child and what help they need. And then 2nd degree assault, I've seen many times that those can be stabbings or things like that. But again, it gave me a lot to think about today, and I'll stop there.
Okay, thank you, Laura Wildham, Frederick County State's Attorney's Office. I am testifying in support of this legislation. One issue I know that has been discussed when contemplating all of these bills. I've heard that there's been a request for data requesting the number of youth who are between the ages of 10 and 13 who commit these type of crimes. Like, how big is the need here? And I would just point out that we have been searching to try to figure out how do we come up with that data. We're requesting data for something that is a non-event. Our police have not been able to charge these crimes, and therefore, so when we've gone to them and asked for the data, they don't have it. So we've asked our SROs, the officers with the best memory. We had one local small agency that did give us some numbers, but it's a teeny little town. And so we don't have data because we didn't allow our police officers to file those charges. So I wish we could have had those. What I did hear back from the agencies was that they saw 3rd degree sex offenses and animal cruelty as charges that they recall not being the serious offenses, that they were not able to charge those under 13. The most common charges or incidents that the officers ran into with the kids under 13 involved second-degree assault, destruction of property, kind of what you might anticipate, and their frustration level high that they didn't have an appropriate response for those. So I do think that this list is an appropriate list for what we see young kids doing, that we need an appropriate action. Again, this list does not require that kids come to court. This requires that the police can write a report, that report can go to diversion or it can go to DJS, that action can be taken, and we need to do something. So thank you.
Thank you. Oh, Delegate Kaufman.
Yes, and I apologize, the hour is late, but I do need to ask this. Delegate Attar, my friend, you have 6 juvenile justice bills on the docket today. And so my question is, what was your motivation for all these bills? Was it a lot of stories you're hearing in the 41st district? Was it from your time working at the Baltimore City State's Attorney's Office? I'm just curious because we hear a lot, we either hear a very dystopian point of view from the state's attorneys and a very utopian point of view from the public defenders and advocates for children. So I'm just wondering, what drove you to do this, and where you did you do all this because you see holes in the juvenile law, or what's? I believe you, but the advocates are so good at what they do that it's a little hard to tell. Truth is probably somewhere in between. So I wanted to ask you.
Thank you, Delegate Kaufman, for that question. I do apologize. I did say in the beginning of all the bills, I gave a little bit of reasoning why I did this, and I can talk to you offline as well, but it's a mixture of what you said. It's hearing from constituents, it's seeing what's happening, it's from my experience as a prosecutor, it's speaking to the experts, it's a mixture of everything. And I can give you, tell you exactly what I said earlier. I just don't want to be repetitive at this late hour.
Okay, I thought I was here. I must have been, but okay, I got enough of the gist and I know how to reach you for more. Okay, thank you.
All right, we have Delegate Grammer next.
Thank you, Madam Chair. Question to the state's attorney. So in Baltimore County, they actually tracked that data, even though they didn't arrest because they couldn't arrest, they still tracked the crime, I believe. There's a big discussion about data here. So what you're telling me is your jurisdiction doesn't even have the data for youth who cannot be arrested, is that?
When I inquired of all our local law enforcement, only a small agency could respond with actual data rather than just recollection. And we sent out information requests among all our state's attorney's office, and I don't remember if I got a response from Baltimore County, to be honest.
Yeah, I'd be really interested, maybe if you could ask around and get back to me, because I
have an email with a lot of responses.
There are likely different answers, and I think that'd be very formative if we could know that. Thank you.
I know the officers absolutely can track the offenses, but whether or not, if the offender isn't listed because they didn't charge them, it may not pop up in their automatic population of the data. So we need to find out.
Thank you.
All right, thank you. And Delegate Conaway? No? Okay. All right, so that will conclude the panel here, and we're going to go to our unfavorables, and that will be Keith Lottridge and Kimberly Watts, if you can come forward. Okay, I don't see you on the list. Oh, yes, I do. Wait a minute.
Jeremy, please.
Yep, come on up.
Want to jump because it's.
Yeah, come on up with the unfavorables. We'll do one panel.
Yes, the first. Yeah, I'll go last.
Okay. All right, you can get started.
Thank you. And now, good evening. I'm sure everyone's happy to see me again because I'll be talking about numbers. I have written down good afternoon, but that's not going to be applicable. Good evening, Madam Chair, and thank you for hearings and delegates. I am Keith Lottridge. Once again, I am the Deputy Public Defender for the state of Maryland. I will again be focusing on the fiscal impact on the Office of the Public Defender. And I bring this up because I didn't have the opportunity in the last one because there was so much to talk about. But quite frankly, the Office of Public Defender is beyond capacity. We have too many cases for the number of attorneys we have. And each one of these bills is adding more cases. This bill in particular, I'll give you the details that we know of. This bill included offenses that as of 2022, data represented the number of children charged in 2022 was about, under the age of 13, was about 1,081. 46% of those charged would have been under this bill. That's 37% for misdemeanor assault, 6.1% for sex offenses, 2.8% for handgun and deadly weapon charges, and 0.9% for drug offenses. Even if we project that only a fraction of these complaints will result in petitions, that will still result in an estimated 124 new matters for the Office of the Public Defender. Again, these are the most resource-intensive cases in the juvenile system. As previously stated, representing 10, 11, 12-year-olds takes many more hours. You're talking about competency. You're talking about all kinds of things. 260 hours is what the best estimate is per case. We're beyond capacity now. We're asking for an unfavorable for the reasons they're going to state, because quite frankly, this bill is inappropriate for children. But we're also asking for an unfavorable because quite frankly, we cannot staff this. You're asking us to do what we cannot. And it's just wrong. Thank you.
All right, and next.
Again, I'm Kimber Watts, also from the Public Defender's Office. I'm in the Forensic Mental Health Division, but practiced in juvenile for about 20 years before doing that. I think you all heard what I had to say about kids who are incompetent to stand trial. So good news, I'm not going to repeat that. What I can add now, however, is that when I looked at the data from 21 to 23 fiscal years, between 46 and 62% of the cases where kids under 12, or 12 and under rather, were forwarded to court were all dismissed, withdrawn, or not charged. So that's roughly half of those cases. In terms of the dismissal, I should have said before, but didn't, that if a child is not found competent at some point in time, the Constitution requires that we dismiss the case. And in those cases, those children never get the services that they clearly need. That is particularly true, frankly, with the kids who've been alleged to have committed sex offenses. I think somebody mentioned that oftentimes those kids are being abused, and this will not serve those children. Given that I already said everything I needed to say before, I can be brief and I'll cede my time to my colleague.
Thank you very much. Go ahead.
Thank you. My name is Jeremy Zacher. I'm Assistant Public Defender in Baltimore City. I just wanted to go over some of the practical implications of what this bill is attempting to do. First, this bill, combined with what we saw from the larger bill, we eliminated a lot of charges for 10 to 12-year-olds, and it seems like we're just adding them all back in one at a time, with a certain amount of randomness as to what people are choosing. One of the prior speakers said that this doesn't necessarily mean the child will come to court. It just allows us to. The child will be charged if this bill becomes law. It involves 3 different forms of firearms possession. In Baltimore City, they charge all firearms cases, no matter how strong or weak the case is. Possession with intent to distribute, that's a felony. In Baltimore City, they're going to charge a felony no matter how strong or weak the case is. One of my concerns about this bill is it includes assault in the 2nd degree. Assault in the 2nd degree is not just stabbing. It's any unwanted touching or even a threat without an actual touching. And you know how kids like to push each other around and put their hands on each other. Many years ago, when I was a fresh new public defender, I once represented an 11-year-old girl who was pulling on the pigtails of the girl in front of her in class, and the mother of that girl got mad, and she filed charges and made a big stink about it. And so I have this very nice, sweet 11-year-old girl who herself had these long pigtails, and she just didn't understand what she was doing there. And this is what really happens in court with these very young kids when you create such a broad method of charging them. they do get charged. And it's not good for them, as has already been explained. It's expensive. And it doesn't really create better outcomes for anybody. So we're asking for an unfavorable report on this bill.
Thank you very much. Oh, question, we have, I believe Delegate Conaway first.
Thank you, panel, for coming in to testify. My question is, can a parent bring the 4th-degree sex charge against a juvenile that touched their child?
It depends on where they touched the child. I mean, honestly, for a sex offense, it has to be an intimate area. But yeah,
Okay,
they can
that's
absolutely
the
call the
answer-
police.
That's the answer I wanted.
Yeah.
Thank you so very much.
Okay, and Delegate Tomlinson?
We good? Okay. Yeah, so my question's for gentleman closest to me. Sorry, I forgot. What was your name again?
Keith Lotridge.
Keith, thank you.
Just Keith works, yeah.
So you were talking about how at a fiscal level, you guys, well, at a staffing level, you guys cannot, if this bill was to pass, that you guys would be over capacity. You're already at capacity, you'd be over capacity.
We are over capacity now.
Yeah. So my question is, how did the Child Interrogation Protection Act, which I'm looking here, back in 2022, you advocated for, you wrote a letter, not you personally,
No,
the Public Defender's Office submitted a favorable testimony. I would imagine that involved you also taking on more of a workload because you've got folks picking up, you've got this 24-hour hotline.
Yes.
So you're here now saying that we can't pass this because you don't have the ability to take on any more work. But just 2 years ago, you advocated for a bill that did give you more work. Am I right?
Are you right? Yes and no. I didn't advocate for it. I would have actually asked
Yeah.
for money because I'm here doing it now. Because quite frankly, one of the reasons we're beyond capacity is because we don't get funded for things, whether we support them or don't. And we are now at a place where in 2008, we had more attorneys than we do right now. The criminal practice has changed dramatically. Every type of case is much more complicated. Our attorneys are working many, many hours. And quite frankly, we're trading on their passion and their dedication to their clients, not on what we're paying them. So I understand your point. Yes, my office came in and advocated for something that is beneficial to children. I think we'll probably always do that. But one of the reasons I'm here today is because quite frankly, we can't do more with what we have. I think I dodged your question a little bit, but I also think I got to the substance.
Yeah. All right, thank you.
All right, Delegate Valentine.
Thank you, Madam Chair, and thank you, panel, for coming in to testify. My question is also a follow-up to Mr. Lottridge.
Yes.
And my question is this: if these reforms were put into place 2 years ago, so this group of children from age 10 to 12 would have been able to be charged with a lot of these offenses pre the reform, correct? Correct?
I'm gonna make sure I understand what you're saying. If you're saying if this law had been enacted in 2022, these children would have been, this whole time they would have been charged.
Yes, what I'm getting at is you would have had, that would have been your caseload pre 2022.
Yeah.
So that then the numbers would have decreased, so your caseload would have gone down. So you would only be going back up to the possibly the caseload you had prior to the reforms.
So
is what I'm kind of getting at.
Yeah, no, I
It would
get
be a return to the cases that you would have had before.
I get where you're at on this. So I don't know if you remember, but there was something, I'm actually making a joke here and I apologize. I don't mean to be flippant. We had COVID. Our juvenile numbers went down dramatically during COVID. And one of the reasons we were able to get through 2020, 2021 and early 2022 is because numbers had dropped dramatically. And they kind of stayed down for a little bit. We're still dealing with the backlog. Actually, the last 2 years have been very difficult because of that backlog. But now, if you look, we actually have numbers that were higher than in 2022, even before this bill. The number of juvenile petitions we had this year is higher than we had last year. So we're already going up. So the reason we were able to kind of get through without major crisis was because the petitions were down. Our attorneys were still working much more than our attorneys are, I want to compliment our attorneys in this opportunity right now. Our attorneys are dedicated. They are putting in more time than you can imagine. They are the best of public servants. And they have been doing so much by themselves, essentially. So I understand your point. My pushback essentially is 2022 and before we had COVID, the last 3 years. Before that, we were also at a breaking point. Now we're past that breaking point. Does that
So
make
to be
sense?
clear, you were tasked quite a bit, say 2019 and before?
Yes.
Just so, okay.
And yeah, we could have a month, if you'd like, I can come and we can talk about where our staffing is and where we've gone. But yes, if you look, you could also look at how our staffing has increased and decreased over the last 15 years. And how we've had to shift it based on changes in law. And quite frankly, we no longer have the ability to shift and adjust because we're just stretched everywhere. Does that make sense?
Yes, you explained. Thank you. Thank you, Madam Chair.
Conclude our testimony on, oh, sorry. Go ahead.
I would say this, that any of us that know the great work that the Public Defender's Office know that y'all do on a daily basis all over the state of Maryland, appreciate the work that's taking place in that office. I think one of the key factors here is that although we have strong advocacy, it's up to us to try to weed out the best path forward when it comes to the young people of the state of Maryland, whether it's Baltimore City, Baltimore County, or Cecil County. You know, so I want to thank y'all for coming and testifying and want you to know that we do hear you. So don't think that we disregard the testimony that's taking place here. We do value the experience and the professionalism and all the years of service that all of y'all have offered to the state of Maryland. So thank you.
Thank you.
And isn't that so? Thank you very much. That ends the testimony for HB 483. And come on up again, Delegate Attar. You're up with HB 322.
Thank you, Madam Chair.
All right.
And members, House Bill 322 requires DJS to forward complaints to the state's attorney for all felonies in violation of 4203, which is where carry, transport, and 4204, use of a firearm in the commission of a crime. The reason for this is our agencies should be working together. We shouldn't just have one agency making decisions without it going to our law enforcement agency to review and see what to do with it at that point. So I ask for a favorable report. Thank you.
I will go ahead and rely on my letter, but what I do want to say very briefly is that DJS is the gatekeeper, but DJS, they're not the lawyers. Sometimes they do not understand or know the elements of the crimes that we have to prove in court beyond a reasonable doubt, and that ties our hands as prosecutors, and I will yield the rest of my time to my team.
All right, who's next? Who would like to go next?
Thank you. I think Delegate Attar really just spoke to what Bill 322 is, but what our office has seen is lately with regards to motor vehicle theft related cases, we've seen a 220% increase in the year of 2023. And these are the types of cases where obviously there are victims involved. And these are cases that are not required to be forwarded to the state's attorney's office currently under the law. And it becomes a very lengthy process because currently under courts and judicial proceedings, the Department of Juvenile Services will look at the case. They have 25 days to decide what they want to do, whether they want to divert it, they want to send it to the state's attorney's office, or do they want to just dismiss the case outright. And so that 25 days is not an actual like requirement because under the law, it says unless there are other factors for them to take into consideration, such as the best interest of the child. And so if they forward the case to us, it could be a couple of months before we see it. And at that point, when we get it, we have 30 days to review it and decide whether we want to charge it at that point. So a good 2 or 3 months has already passed by the time the case comes to the state's attorney's office. If it comes to the state's attorney's office, then we have to do our initial investigation because really what DJS does is they have an intake officer who will look at the cases and they're just reading a police report. What we're doing is we're contacting the victims, we're contacting the police officers, we're making sure there's actually evidence there to to charge the case properly. And so with regards to this bill, it actually allows us to get the cases so that the department doesn't hold the case kind of like in limbo, waiting to determine what to do with the case.
Go ahead.
Okay, thank you. I am also with the Baltimore City State's Attorney's Office, and I think what is key to sort of to take in consideration when being asked to favor this bill is just sort of to pick up where Chief Chung left off, is that the limbo and the effect that this has on the victims and the witnesses during that period where they don't know what's happening to their case. They haven't necessarily received a letter from DJS yet advising them that their case has been informaled or that the case has been sent to diversion. And they simply don't know. And we don't know the case even exists. So it gets a very frustrating experience for the victims and a confusing one for the witness. It's isolating and they feel powerless, which adds to the powerlessness that many victims already feel. When diversion programs work, that's wonderful. When they don't work, that's where our office comes in. Because motor vehicle thefts are felonies that are not required to be forwarded to our office. Unfortunately, when we do see them, it's often the case of a repeat offender. We're getting them on their third or fourth car theft. By that point, you've also missed the opportunity to intervene earlier with that youth and to find out what's going on, what's their home life, what's their school life, what's the circumstances under which are they hanging out with the wrong kids. And it's that delay also that makes it harder to steer them in the right direction sometimes because it's not forwarded in a quick fashion. There's also that lag while it moves its way through the clerk's office and the court system. So we may not be able to intervene until months later.
Great. Ms. Wilt.
Okay, thank you. Laura Wilt, Frederick County. I am testifying in support of this Bill 322. I would point out that I know we're all extremely tired. I do feel that this is a critical element of legislation for this year for our victims and our communities. We all know that a quick disposition, a quick resolution, a quick answer for both victims, witnesses, and juveniles. That goes all to the juvenile brain, handling a matter in an efficient manner and getting these decisions made, getting people talked to. This all is an important bill to pass, and I would urge a favorable report.
Thank you. Delegate Grammer.
Thank you, Madam Chair. Just to be clear, so if there's a felony, it may take as long as 2 or 3 months to get to you for an alleged felony and a victim is just hanging out with nothing.
Yes.
Okay. And in that case, what, if they were to get the information to you, what would you be empowered to do there?
It is the practice in our office for our ASAs when they get the file to immediately reach out to the victim.
Okay.
That immediate contact and conversation with the victim, even if it's as little as, I just want to know what court dates you're available for, or to just introduce themselves, can start the support that our office can lend, but also reassures them sort of in the entire justice system in general.
So it's primarily about victim services.
Exactly. Let me also say very quickly. So what happens, let's say the car case, unauthorized use, I mentioned, misdemeanor, car theft, felony. So what happens here is they may look very similar, but they're different. So the night the police officer makes the arrest, the officer may just charge everybody with car theft. And how do you prove that? Well, you may need to go ahead and have the officer go show the photo array to the witnesses, but no one ever speaks to the officer to tell the officer what to do or direct them. So by the time we get the case, it's now, let's say, following the rules that they say 25 days. Now, let's say by the time we get it's 40, 50 days. Then you go to the victim or the witness, they don't remember what the person looks like because it's so far away from the time period in which it happened. So then a young person we could have given services that they could have been held accountable early on no longer is found a fact sustained for a car theft, but now it's only the unauthorized use, which is being in the vehicle without the owner's permission, which is now definitely going to be diverted. So what about the victim who now is out of their money? The other thing we're also finding out is we have victim fatigue, where a victim day one says, you know what, my car is stolen. Oh no, I have to take off from work. Now they take off from work, they pay the car deductible, $500 to maybe $1,000, depending whether or not their insurance is good or what's going on. They may have to catch the bus. They now, how are they going to get their children back and forth to school? They now have continued to take off from work. Police say, we found your vehicle. Now insurance, because so many cars are stolen, is 3 weeks to a month to fix, or maybe 2 months to fix your car. We reach out to them, tell them the court date, but because the court dates are so few and far between, now that court date is going to be 3, 4, 5 months from that time period. Now they got their car, they paid their money, and we're saying miss more work. They're like, yeah, no, I'm not doing that. And so we're finding out that they don't want to be involved in the process, and they're angry. And when I go to these community meetings, they are tearing me apart.
So the way things are structured, it could be 4 to 10 months before a case is heard.
Yes.
And what I'm hearing is that because of the lag, you probably have objectively legitimate cases that frankly just flounder because it's been so long, and I don't remember that. I mean, is that?
And that's correct. But the case may never come to us if DJS doesn't send it to us, so we don't know about it. So now you have victims who are really angry because they don't know anything about their case other than the police found their car. And so that, remember, we're up 200% in car thefts in Baltimore City alone. So the system is beyond broken. And counsel was correct. This here is a critical bill to dealing with the car theft cases. And we have another one in a little while as well.
Okay, it's a hot mess. Thank you.
Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. So, State's Attorney Bates, are you saying that if a juvenile commits this crime, was involved in this alleged crime, 2 things are going to happen? One, the case is going to get sent to diversion, it's going to be diverted, but it's also going to be a mirror case sent to the state's attorney's office?
No, not necessarily. So the gatekeepers, DJS, whatever DJS decides to do with the case, they may send it to us and forward it to us, or they may not do anything to it and divert it. One of the things that I believe Kate or Pam talked about, by the time we get some of these cases, we're realizing these young people have had 3 or 4 car theft cases already, or been involved in that before we even know what's going on. We don't have a clue of what's going on unless DJS tells us, and DJS, depending on the cases, decides what they want to do with it. We have no say.
Well, to put it a different kind of way, DJS might not tell you, but they might be working on the case. So therefore, the victim can't get any information from you as to what's going on. Is that what you're saying?
That's correct, but DJS isn't giving the victim information about the case either.
I understand that, but you're talking about juveniles, so you can't get a juvenile information on the whatever that is on the computer. So you can't get
Correct.
information. I
Yes.
asked about that earlier.
And they're extremely frustrated because they don't know, we don't know, and the only people who know is DJS, and DJS isn't saying anything to us.
Well, they protecting the juveniles, so thank you.
But isn't it true that you can, when the state's attorney's office is involved, you all can contact the victim and ask things, because isn't that true?
Yes.
Yeah, so that's the whole point of getting state's attorneys involved, so that you can contact the victim.
Exactly.
Well, among other things, yeah.
Yes, Madam Chair, and the sooner we can contact the victim, the sooner we can go ahead and really begin a real in-depth investigation. For instance, what if we're able to show that this young person did not steal the vehicle? We don't charge every car theft case. We don't charge every gun case. So what if we actually are able to show that? Then we're going to dismiss the charges against this young person, where they could have sent to us the case to go ahead and prove theft. To prove a car theft is a difficult thing to do. It's easy to prove unauthorized use, but unless really, to be honest, you're an expert, you understand how to prove elements, then you're going to give us a case and it's not a viable case. So then you're going to say, oh, we forwarded this car theft case to the state's attorney's office and they dismissed it, but we couldn't prove it in the first place. So we have to dismiss it. We're saying let the experts go ahead and get it as soon as possible so the victims and the witnesses can be involved at earlier stage as possible.
Delegate Tomlinson.
Thank you. You started to kind of talk, State's Attorney Bates, you started to talk a little bit about this about 5 minutes ago. The opponents of any kind of juvenile reform this year, they'll say over and over again in regards to car theft, well, it's nonviolent crime, it's not a big deal. Can you paint a picture of who are the victims of this crime? Because I would imagine this isn't Peter Angelo's, who's got 20 backup cars to drive, the rest of the week, month, year. Who are the victims of this crime?
I'm gonna let Kate Rosenblatt from my office. They're the ones who deal and see these.
That's good.
It obviously ranges. Oftentimes it's in the same community as where the youth might live or hang out. It ranges from a victim who says, you know what, this happened to me the very same thing last week. I paid my $50 deductible because I got really good insurance. I'm fine if he just pays me the $50 and we can figure out what's going on with him and maybe he needs services, but I'm not too pressed. To the single mom who was working 2 jobs, lost all of her child's clothing, which was brand new, and her child's stroller because she had 2 and 1 on the way. All she wanted from the kids who took her car was the stroller back. And let me tell you, when the police found the car, there was no stroller. So she just wanted the stroller back because she couldn't afford to buy another one. And now she has no car. How is she going to get to work? Her kids don't have new shoes because the new shoes she just bought them were in the car and nothing's in the car anymore by the time she gets it back. So these victims are sometimes struggling just as much as perhaps the youth who commits the crime. These are not, cushiony victims. These are not people who are not facing sacrifices themselves. Frequently, we hear the frustration from the victims being about, I had to get a rental car. I had to wait to get the car fixed. I haven't gotten the car fixed. I haven't even gotten the car out of the tow yard yet because I'm still going back and forth on who pays for that. And it's hard enough for me to get to work since I don't have a car anyway. Who's going to pay for my Uber? Who's going to pay for my Lyft while I try and get to work? Oh, okay, I have to take the bus and we all know how long that takes. So it's not a victimless crime just because it's not a violent crime. These are people in the community. The frustration is real. The anger is real, as is the appreciation that, yes, these are kids that are doing it, but these are also people who have kids of their own and are suffering as a result of the offense.
I appreciate that, especially the story there with the stroller. My wife's pushing my 4-month-old down the street right now, the stroller down in Annapolis here. So I know how important that is. Thanks.
Mm-hmm. Great. Thank you very much for this panel. And we're going to move on to unfavorable. We've got, please come up, Lauren Dollar and Michelle Kim. If you're here. Yep, you're here. Great. All right. You've been here long enough today. You know how it works.
Good evening, Madam Chair and members of the committee. So I'm obviously back to talk about diversion. So this bill is another way to shortcut diversion. Right now, the state's attorney's office already has forwarded all of the cases that involve possession of a handgun, any crime of violence, and any case that involves someone being injured. They already get those cases forward to them. What this bill does and what they're asking for is that any felony, including things where people don't get hurt and are not crimes of violence, also get forwarded to them. And the purpose for forwarding it to them is not so they know about it, it's so that they can formally charge the kids. So that's the one thing. There is nothing about the current system that keeps police from investigating motor vehicle theft immediately. They continue to visit victims and do photo arrays immediately, even if a case has been diverted. Also, just to clarify, DJS always contacts the victims when a case has been recommended for informalization. There's a letter that goes out to victims. There's a box they can check to say they'd like to appeal the decision, and the case then gets forwarded to the state's attorney's office. So that is currently built into the bill right now. The police and the state's attorney's office can share information amongst themselves. They don't need to get overrides for diversion in order to be able to get information about motor vehicle arrests in their jurisdictions. I'd also just like to note about who we know the victims. It's true that these impact victims and that it's impacting people's lives. The children who are found in these cars are often not the original takers. They are often passengers, and they are often very young. And that is the type of cases that we look to divert. People who are very young, first time involved in the system, trying to avoid formalization, and then we get them diverted. And once again, I realize you've heard me talk about this all evening, but diversion does not mean dismissed. Diversion means participation in programming informally. Thank you. I urge an unfavorable report.
Good evening, members of the committee. Thank you so much. My name is Michelle Kim. I'm a youth defender in Baltimore City, and for 10 years, I was a youth defender in Baltimore County. We urge an unfavorable report on HB 322. And I just want to kind of get to the heart of this. So this bill forces trained intake officers to forward all felony complaints to the state's attorney's office rather than use their experience and resources to gauge kids in services immediately. So I want to respond to this conversation about victims because I do think it's important. DJS is absolutely required to contact victims immediately. They not only send out letters, but restitution is oftentimes a requirement of that diversion process. Furthermore, DJS can engage people in what's called restorative justice or community conferencing, which means people actually come to the table. Victims can approach and engage with the kids who may have caused this harm and explain to them what this meant to them in a much more face-to-face way than you would get in the juvenile system. I'm going to also push back against the idea that the state's attorney's office is where these kids are going to get the services. They do not have proactive and preventative services for our kids. They do not have background information regarding our kids' home life, educational background, or mental health history. That's going to reside with the defense and with the Department of Juvenile Services. The state's attorney's office is not going to have the information to make those recommendations for kids. The other thing that I want to make very clear is that formalizing all charges actually is going to reduce the amount of kids who are going to receive services. So in fiscal year 2019, 46% of formal cases did not result in any court-ordered services because they were eventually dismissed. That means that kids who presented at risk, who were in crisis, who had needs, because they have due process rights and because they went through that system and because their cases were dismissed, got absolutely nothing. So for those reasons, we would urge an unfavorable report.
Thank you. Well timed. Two quick questions, if I may. First question is, does DJS have investigative capacity?
So the Department of Juvenile Services does not independently investigate crimes, but the police do.
Right. Does DJS interview witnesses? No, right?
They do. And I
Yes.
also want to make it clear, because I don't think I did, victims also have the right to appeal any diversion decision.
Okay, so to answer my question, DJS interviews witnesses.
Victims.
No, witnesses. I'm speaking of witnesses.
I apologize.
Yeah,
Madam.
I'm speaking of a lawyer preparing a case, because you need to be able to know at the onset, be able to talk to people as much as you can at the onset. And that's the argument the state's attorney's office is making. If diversion is not successful. So my question is, does DJS have investigative capacity? I thought the answer was no, but the police do. And does DJS interview witnesses? I would imagine that's no, but the police do.
That's my understanding. There are civilian complaints, so to that extent, they do get statements from witnesses sometimes.
They meaning DJS?
Yes,
Okay.
yes, ma'am.
All right.
And something I would add is it is inappropriate for DJS to receive a police report that is going to be forwarded to the state's attorney's office for petitioning if that investigation is not complete. If it's still in infancy stages, it needs to be complete before our kids are at risk of being charged with crimes.
But would it be in infancy stages if it's been decided to divert the case?
No.
Okay.
It should be, the investigation should be complete at that stage.
Right. Okay. Just want to make sure we're talking about the same level at the same time. Okay, Delegate Grammer.
Madam Chair, thanks for being here today. This whole system is dysfunctional. If this committee could trust you all to work together, we wouldn't be here. We are on Juvenile Crime Day. The Department of Juvenile Services is not here. You have a state delegate calling the agency X times, and they're not even getting back to him. So this is the ballpark in which we're pitching and hitting balls here. So what is the problem with just getting the complaint to the prosecutor's office, just so that they're informed, just so they can engage a victim? What's the disconnect here?
So the disconnect is that it's not just to put them on notice, it's actually forwarding the case for potential charging. And because the state's attorney's offices have the job to prosecute case, that's their job. I mean, that's what they're there for. They will be formally charging the kids. That's
Will
what's
is
gonna
a strong word. And I give the prosecutors flack when they do stupid things, but they won't always prosecute 100% of the time.
Especially if the case is a weak case, I agree with you.
Yeah, maybe it's a weak case, maybe they use discretion, maybe they're just saying, we have an alternative. Do youth not receive diversion? Do they not receive services if these complaints are sent to the state's attorney?
So,
I mean, they don't. Period. The state's attorney does not have services for our kids. They do not have proactive preventative cases, diversion programs for our children. They don't.
Okay, thank you so much.
I would say, part of the problem, and this is another point I wanted to bring up earlier, we're dealing with kids who are very basic in their understandings of things being fair, right? And so the state's attorney's office overriding of informalization is often very confusing for kids. So we'll have kids who have participated in teen court, almost complete teen court, have gone in, made amends, done the disposition that their peers have assigned them. I don't know if you all are familiar with the concept of teen court, but the kids actually give their peer a consequence, usually community service, restitution, and sometimes jury duty, so that they learn from other kids who are also in trouble and also get to see how that might have impacted other people as well. So they might complete that whole program and then it gets overridden because the state's attorney's office gets a hold of it. And then the kid comes to us and say, I don't understand. I already did my consequence. I've learned a lot from this. This feels very far behind me. And we have to start the entire process over again. If it comes to us while they're still in teen court, sometimes we have to tell them, you shouldn't do that process because you're going to be making statements about what happened. And, we are now going to have to deal with this in a very formal way. So it also interrupts the process, the programs that they might be participating in during that diversionary program. So it can be very confusing, the state's attorney's office override. Look, I think that the state's attorney's office should know about the things that are happening in their district, and the police can be in touch with the state's attorney's office about arrests that they've made. There's nothing preventing the police department and the state's attorney's office, who are the same body of the state working together to solve crime, for them to be able to essentially that's what the Constitution says. But they have to work together to solve this problem, and they can communicate with each other. And the juvenile confidentiality laws allow for that. And so there's nothing that DJS is standing in the way from an information sharing perspective that's preventing the state's attorney's office to understanding what arrests have been made. But what this does is it actually says we're not going to allow the Department of Juvenile Services to divert cases in a wider bucket of cases than we allow now.
Just to be clear, what you're saying is if the complaint is forwarded and the state's attorney's office formalizes, diversion and service delivery ends.
Not necessarily, but it is interrupted often because of the concerns that now they have a formal case against them. And also, you know, from a kid's perspective, things are like very black and white when it comes to fairness. Like, this is what I said, that I would participate in these programs so that I could earn not having a case. And now you're telling me I have a case. Why am I showing you all that I'm willing, like not willing, why am I showing you all that I can earn your trust and earn my case to be dismissed if it's not going to be dismissed anymore? So it's just, it sends kids mixed messages. It's very confusing for them. Look at how we have it built into the law that is part of our system for a lot of crimes, including cases that get diverted that the victims have appealed, or cases that get diverted that still get forwarded to the state's attorney's office, and then they do charge the cases, right? So, I mean, that does happen. I'm not saying that it can never happen, but I think that we should limit the amount that's happening.
And just to piggyback off that for a second, so if my case is formalized, if a petition is filed and they were supposed to engage in community conferencing, which is one of my favorite programs that has a 95% success rate amongst victims and kids who have caused harm, I'm going to tell my kid to not participate in that program, because anything that they say in community conferencing is going to be used against them in their delinquency matter. So there is going to be a conflict of interest at that point that doesn't really serve anybody.
Okay, thank you so much.
Delegate Conaway and then Delegate Kaufman.
Thank you, panel, for coming in. I think Michelle Kim, I think you said something about the restitution. And so if a juvenile joyrides in a car, smashes the car, it's a $50 deductible for the victim. I guess the insurance company pays the $9,500 and whatever, $50. So the juvenile would be charged that money to pay restitution for the insurance reimbursement?
Or at the diversion stage?
I'm just asking you, at what stage would they have to be required to pay restitution? You mentioned restitution,
Yes,
right?
yes, Delegate, yes.
But you
So
can explain how it.
I will. So absolutely. So at the diversion stage, what we see very often is the Department of Juvenile Services requiring restitution as part of successful diversion.
And how long does the person have to do the restitution?
It is a limited period of time before they rule that it's unsuccessful because you haven't paid, and because it's unsuccessful, we're forwarding it to the state's attorney's office.
So you could owe $10,000 easy and not pay it off in 5 years or 4 years. And
No. They're going to give them they're going to give them a couple months to pay that restitution.
Like $5,000, $5,000.
Yes, and they're not going to be able to pay. So that thing is going to be forwarded to the state's attorney's office.
Thank you so very much.
Delegate Kaufman.
Yes, Ms. Kim, and the hour's late. I'm hoping that you can explain something to me, Ms. Kim. You said emphatically to Delegate Grammer's question that the state's attorney's office doesn't have diversion programs or different, like that's what you emphatically stated. But every time I talk to my state's attorney, Mr. McCarthy in Montgomery County, he brags, and rightly so, about the truancy program, the truancy anti-truancy program that they have about for kids that are truant in middle school, in middle school. So I consider that a diversion program. And then somebody else is saying that in their particular county, their state's attorney has diversion programs. So am I wrong, or is the hour late and we just accidentally made an absolutist statement?
Yes, I apologize. I didn't mean that the state's attorney doesn't have any diversion programs. I mean, as soon as the case is formalized, there are no programs that the state's attorney's office is going to offer that are proactive for our kids.
Okay, thank you for the clarification.
Delegate, every time I look down and I look back up, there's like lights just kind of grow. So whatever fertilizer we got going, I'm gonna get rid of it. Okay, Delegate Simpson, then Erican, and then Valentine. Feel free to ask your questions. I'm just joking here.
Okay. So what is the purpose of juvenile law?
Wow, that's a big question.
Well, you can find it in the purpose clause of the Juvenile Causes Act, which includes to hold youth accountable, account for public safety, as well as to do what's in the best interest of the child and the family, and to make them contributing members of society, essentially.
It is a very long time since I was at child welfare and child protective services, but I always felt like we were all working together. Even if we didn't always agree, I did think we were always working together. And I am in Frederick, so I can say that Frederick State's Attorney's Office, and we've got 4 Frederick County individuals on this Judiciary Committee, has, and I just checked, 5 diversion programs.
So I
5.
think that there is some confusion around the term diversion programs, because often what we find with, at least, and I'm very open to being corrected, but my understanding is many of the state's attorney's diversion programs are post-petition diversion programs. So we have opportunities for kids to earn the right to not have what's called a fact sustained finding on their record, but that does happen after the formalization of a case. It is possible, and maybe I'm wrong, maybe state's attorney's offices are running pre-petitioning diversion programs that I'm not aware of throughout the state. But my understanding, most of what I think is happening is that the state's attorney's office takes a case, essentially, which is formalizes the case and charges the case, and then gives the child an opportunity to earn that case's dismissal through participating in their program to avoid a fact sustained problem. And they call that diversion. I could be wrong. I could be wrong, but that's my understanding. It would be surprising to me for the state's attorney's office to offer kids programming pre-petitioning, but it might be happening.
If I could just add one thing, I definitely applaud the efforts and the resources that are expended by state attorneys' offices to provide diversion programs. That's not universal. Baltimore County State Attorney's Office does not have a diversion program, and we shouldn't make diversion jurisdiction specific and limited.
By all means, I definitely think we need a better way. You know, my little statistician nerd person would love that we did a better job of keeping track, because that is one thing we learned over the summer during all of this, of looking at this. Every jurisdiction seems to be doing a little bit of their own thing. So it's very hard. We all tried to, compare notes. We all went to our, particular agencies, and we all found things were different. And that, I think, is the heart of where we're trying to go. Not necessarily this bill, but all of them. Is that how is it that we can get you, so far, both panels have fired each other. You fired everybody. I don't even know what happened here. And I'm more than happy to redevelop it from the ground up. I'm a program manager, so I love that kind of stuff, but I don't think they're going to go for it. How do we get you guys to work together for the kids and not have this us and them?
So
that's what we want. That's what we want.
Everyone wants kids to succeed. That's why we're here. All of you deeply care about this. We care about this. The problem is when we start talking about the criminal court system, we're adversaries. And that's why we want to talk about non-court solutions.
And non-court solutions are found in diversion programs, such as Ms. Kim was saying, the community conferencing programs. I think a big part of the issue is that there needs to be more information gathering, I think, about the diversion programs, about the history of the kids who are being diverted. And that information maybe is how we start the conversation about what's happening and how successful. I mean, I know DJS does collect preliminary information about this, but certainly we could be collecting more information. And I think that we are all on the same page. I think we all have different perspectives. We work with the kids, so we see that the impact that the system's having on the kids themselves and the way that they're reacting to the formal criminal system or the formal legal system. The state's attorney's office are talking to the victims, and they're having that perspective. And so what I'm saying is that for the kids that we're working with, there are ways to get them the help we all want to get them without the formalization.
This is great. I had a bill that everybody was favor and all you guys were working together. And what I would like to see is when you, even if you're coming up as a con, I want to hear how you can become a yes. That's what I want to hear. I want to hear change number 3, change that line this or whatever. I want to know how it is that you're going to be able to, I'm totally into the carrot and the stick. I'd rather have the carrot by all means. What do you want that will work? You guys are in the trenches. You're in it together, whether you realize it when you're firing each other. What's going to work? That's what I want to know.
Yeah, we love restorative solutions to harm, which is the model in which the harm is addressed within the community in part of community conferencing, restorative response, where the kids get to sit down with the person who's been impacted and they get to work it out. And that is also being tracked by the Department of Juvenile Services. We need a more robust set.
Okay,
of
bring
options.
us in.
Yes.
Bring us in because I'm not there at that table. I want to know what in law and within this can we fix so that it works better. That's what we want.
Oh, yes.
Instead of firing us.
Right. Give us a robust non-court program and we will be front and center at that program. I promise you. You give us support. You give us money for social workers for our kids. You give us money for sports programs for our kids. We will show you results and we will show you a dramatic reduction in crime and an increase in public safety. I promise you.
You're an arm of the court too.
I know, but I don't want my kids in court.
So you want to become a social worker?
As youth advocates, we kind of are.
Okay. Thank you.
Thank you.
All righty. Delegate Erican.
Thank you, Madam Chair. Thank you, guys. I'd really like to hear a little bit more about community conferencing, just because what you said I thought was really interesting, that these kids will go into this teen court program. They'll start essentially atoning for their sins in a very public way. And then potentially it could be formalized. And now you have to advise them to stop. And I guess my question is like, is it possible? Is there any way to finagle it so they can still continue to participate and you can, I don't know, assert privilege in some way to close those conversations so that they can no longer be utilized in a formal court setting, so that process could continue where they could still be honest with the victims and who else in the community they've hurt, but then at the same time, that conversation would be a privileged conversation that could not be entered as evidence.
So it's just very complicated. I think we have some of those protections built into the law technically, but there's always a risk. It's very scary for defense attorneys.
I have no doubt. Yeah.
It's very scary for defense attorneys.
Yep.
And it's also very confusing for clients to say, okay, do this program, but also come to court to deal with this later. And now we have to prove something you've already apologized for. It's very confusing.
Right. Don't tell anybody you did it, except for these people. Tell them you did it, but nobody else.
Everything. Very, very confusing. And these programs like teen court, community conferencing, they're really great ways to address kids, to address behavior quickly. And they have really great results. And the kids walk away. I had a mediation. It was post formalization, and I wish the kid could have avoided having to be through this intimidating process. But they got to sit down together. People walked out of the room in tears. There was so much reconciliation that had happened because they had an opportunity to sit down and work it out. And that can happen before a kid has to walk into court next to me and be so terrified they're going to go to jail, even though no matter how many times I tell them this is not on the table, you're not going to be locked up. Right. But they can't internalize that. And it is a scary process. And if we can do the restorative piece before that, avoid that altogether, I think it would be great for community members and the kids. We are not opposed to kids being held accountable, learning from their actions. We don't want to see our clients come back.
Right.
We would like them to learn and become like contributing, thriving kids, who are going to school and teaching other kids how to treat other kids well.
Yeah. I mean, I believe you. Every one of you is always very passionate. You obviously do this because you love it. I think we have so much pressure, all of us, truly less so in my community, but there's a lot of pressure. People are and, you know, rightly or wrongly, they feel like kids are out of control right now. And we have been commanded to do something. So if you could get me any kind of language that could strengthen this part of the code so that you guys would feel comfortable letting your kids continue through the teen court process, even if they did become formalized. And it's going to be painful no matter what. This stuff is horrible. It's always painful. But I would love to see a place where these two worlds can exist. And you don't have to be afraid that if your kid says something, it's going to get used against them later. Because I love to see a kid that's not being told, you have to stay silent. You can't tell anybody what you did because I don't want you to get in more trouble than you're already going to get in. I'd love to make sure we're telling each kid, you can tell the truth about what happened, baby.
Absolutely.
It's going to be okay.
And also just, I want to put a plug in for diversion again, that kids don't have to be competent to stand trial to participate in diversion. They don't have to understand the court process. Kids who are low functioning, kids who are having a hard time understanding due process, they don't have to understand. They can just participate. They can just participate in the program.
Yeah.
Because competency only gets raised once it's formalized.
Okay, well, that's good to know. So, and the other thing is, if you have data on this, where is it happening? Where is it not happening? How many kids are involved? I think we would be very interested to get that data.
Absolutely.
The more data, frankly, the better.
Absolutely. Thank you so much.
Delegate Valentine.
Thank you, Madam Chair, and thank you, panel. Two of my questions have already been asked, but I will start with a statement and I have one question. Just for your information, Frederick County does have 5 diversion programs. They are all pre-petition with no charges required. But my question about the Office of the Public Defender has to do with how you could be engaged with these children when the Office of the Public Defender doesn't kick in until the petitions have actually been filed. So you have no contact with them until a case has actually been charged, correct?
That is correct, but we would love if we could be brought in earlier. I know that in Anne Arundel County, our colleagues do get involved. They try to get involved at the intake stage. So the earlier, the better that we can get connected to these kids from our perspective, the earlier.
But currently, as it stands now, only once they've been charged does your office get involved.
It depends on the jurisdiction. It really depends on the jurisdiction, from my understanding. And also sometimes families can call us to get connected to the case before the actual petitioning. That does sometimes happen, but you're right. In Baltimore City, as a matter of course, we are currently formally only getting involved at the time of the after petitioning. Yes, you're right.
Thank you.
Okay, thank you. That concludes the testimony for House Bill, what are we on? 322. Thank you.
Thank you so much.
Thank you. We're gonna move on now to House Bill 927, Delegate Attar, our honorary Judiciary Committee member tonight.
Thank you, Madam Chair. And on the topic of working together, Delegate Simpson, you have a defense attorney and several state's attorneys working together at the table.
Come on up, please. Thanks.
House Bill 927, I'm sorry, thank you, Madam Chair. House Bill 927 would require a child to have a pretrial status hearing within 24 hours after the child is charged with a crime of violence, unlawful possession of a firearm, and motor vehicle theft. I do need to say that it's come to my attention that this is what's happening in many jurisdictions. It's just not happening in Baltimore City, that I know for sure. So we may have to amend this bill, and it's actually on the schedule tomorrow morning to be heard in the Baltimore City delegation. And we're going to have continued conversations tonight. We may have to amend this to make this a local bill because this may not be an issue statewide. And I'll leave it at that.
So something I would like to talk about. I was a defense attorney 20 years. And I guarantee you, I've probably been in the juvenile system more than most people have, probably anybody here. And I will tell you the way the system really works, it's not working. DJS is the gatekeepers. Public Defender's Office told you, they don't even get a chance to talk to their clients in reference to this diversion program until we charge. But sometimes we charge and it's called a indefinite postponement. We postpone for the diversion programs. So if a child is in a program, this school program, we're not stopping it, delegate, for any reason whatsoever. We want the children to be successful, but we also have to hold them accountable. And that is what this is really about. This bill that's right here, this local bill, is for gun cases. DJS is not sending us gun cases. I think my team probably has statistics about that. Even though the law says do it, they're not. by DJS and who's not here. They're the gatekeeper. They're deciding what's happening. What we're saying is we're tired of getting the same kids 3, 4, 5, 6 times. The first murder in Baltimore this year was a juvenile. And if they would have done what they needed to do, that juvenile, I do believe, would have been alive. And so what we're clearly saying is if the court has these young people for the first 24 hours, we're not trying to hold them. We're trying to say, DJS, this is a young person in a stolen vehicle, put them on electronic home detention. What program do you have? An answer to this court and to this judge so we can make sure this young person's alive and we can make sure the system works for young people. That's what this is about. We all really want the same thing. The public defenders, the defense attorney in me still wants young people to be successful. I always want young kids to win, but we can't win if we do not have structure. And we have structure when we raise our own kids. We need to have structure within the system because these are still us raising. You also have my testimony.
Okay. Just for clarification, Ms. Chung, I don't have you listed actually on this particular bill.
Okay.
Okay, great. All right. Ms.
Rosenblatt,
Yes, Ms. Rosenblatt.
Thank you.
Mhm.
Yes, so this is critical because the sooner we find out what's going on with the kid and the circumstances and situations under which that case comes to us, the more we can start to repair any damage. These are cases sometimes that while DJS does under mandate have to forward us the cases like the crimes of violence or the handguns, there's no time limit. So sometimes we see cases where a child has brought a loaded gun to school and we won't get the case until weeks or months later. That's detrimental, not just to the community who now has the child back in the community, but it's that the community has the child back in the community and there are no services that that child is receiving. There is no extra supervision. The public defender has not had an opportunity to speak to that child. We have not had an opportunity, of course, to speak to that child. They have not been before a judge or a magistrate. We don't know what's going on in the home. The parent has not had a chance to tell us. So essentially what that child experiences is I did this thing and nothing happened. That can lead one of two ways. If it's a call for, if it was a cry for help, it goes unanswered. And if it's not a cry for help, then the community is left crying for help and being unanswered. Sometimes in the worst case scenarios, it does end up in the child having, in the child dying before services can be rendered, which is of course horrific and the worst case scenario. Frequently it means that we're playing catch up. Sometimes that means we're trying to go back to the kid and find out what's going on. Is your home life bad? Is it school life that's bad? What brought you to where you are? The sooner we get the cases, the sooner we can figure that out.
Thank you, Laura Wilt, Frederick County State's Attorney's Office. I am testifying in support of this bill with amendments. This is a problem that's statewide. It appears to me this language is trying to address certain crimes and that those crimes need to come before a magistrate or a court for determination about what's appropriate next. It's for an immediate judicial decision about what's appropriate. I do think that these are serious crimes that need immediate attention. I do think that the bill could specify what options the magistrate has. I mean, the magistrate could have lots of options, such as referring back to DJS, putting it on hold for the investigation. Let's do a background. Let's give the parties time to get counsel, investigate, come back in 30 days. Well, maybe they need to be on an electronic monitoring. Let's stop and figure out what's appropriate. But if you don't put the judicial magistrate involved, what you have is, and I really think Madam State's description was perfect. You have months after the fact, this kid's like, what? Why am I bringing, oh, it's such a big deal now? 3-4 months later, now I got a public defender. What happened? Like I did this thing months ago. Nobody cared about it for the last 4 months. Because maybe they didn't even show up to the intake and it takes 2 months then to get into court. A month later, you get a lawyer, so this gets it before a judicial magistrate to make a decision about what the appropriate next step is. I do think you can leave those options open, that it could go to diversion. It could go to DJS to divert, but it's on everybody's radar right away. Everybody gets a say. Thank you.
Thank you. Delegate Conaway.
Panel for coming in to testify. So if this bill passes and the pretrial status is not determined within the 24 hours, is that a cause for a person to ask for dismissal of charges?
I don't see a remedy.
No, in the sense that it would, the way the system is enacted now, DJS, if you technically has 25 days to decide what they're going to do, then they send it to us. We'd have technically 30 days. Then if we decide to charge that individual, that youth, then that case would probably come in a month or 2 months later. So it's not like the adult system where you have the speedy trial violation. This youth doesn't even know that they could potentially be charged until DJS sends us the paperwork to charge them, and then we begin to do the investigation. Only thing we're saying here is the information says swift and certain consequences. For young people, there's nothing swift and certain about the system the way it's enacted right now. DJS decides what they want to do, and it just takes forever. We're saying here, when that young person is a crime of violence, when it's a handgun, or a car theft case, only those three, car theft, then the juvenile magistrate or the judge gets involved to say, what's going on? Let's give the person these wraparound services. What's the programming? They can start the process of holding that young person accountable and see what's going on with them. That's all we're saying right here. Gets the public defender involved, gets DJS involved, it gets all the services involved that meets what they say, swift and certain consequences. That young person did, because our issue is this: with car thefts, it's the same kids over and over and over again. Gun cases, it's the same kids over and over again. What we're saying is the judge sees who you are, most likely 99.99% of the time, put you on electronic home detention to send you home. And then DJS is giving you programming. And then we have the opportunity to not only the prosecutors build a good case, but also make sure that this young person gets the services. And once again, public defenders, defense attorneys are involved at the early stage to figure out, hey, you know what? My client was only a backseat passenger. Can we get some diversion here? As opposed to us thinking this person is the actual person who stole the vehicle. Things like that. The system, think about the adult system, how it happens. Think about that's what we're saying in reference to these three. Still have the opportunity to give the youth the same program, same diversion, but what we're saying is that we're here at the very start with those three crimes. And I also say, I do believe if we can get these three early on, you will see a remarkable decrease in the stolen cars and some of the juvenile crimes because they will get the services from day one.
Yes.
Okay, so I'm looking at the synopsis of the bill. I know you don't have your computer in front of you. It says synopsis, requiring a magistrate for juvenile cases to determine a child's pretrial status within 24 hours after the child is charged with a violation. My question was, if the pretrial status is not determined within the 24 hours, let's say they did it 25 hours, sort of like when you get a speeding ticket and they mark down AM, but it was PM, and you request that it be thrown out because the time was wrong. So if you have a time violation based under this synopsis, can you request that the charges be dropped and your case be dismissed?
Well, without a doubt, the defense attorney is going to make that argument.
Okay.
Because I know I did and I would.
Well,
but what I
I'm
would
just
say
saying
then
is to educate my constituents. You know a lot of things. I know a lot of things, but a lot of people are watching and they don't know these things.
But unless the judge found a willful wanton violation that we did something, the answer would be no. But let's take, for instance, a young person is stopped or arrested on a Saturday night, then you get to see the juvenile magistrate first thing Monday. So that answer would be no.
Well, we call it the bookings game, and you need to straighten that out. I mean, if you put this in there and you violate the 24-hour period, how can I obey the law if you don't obey the law? You tell me, well, you got locked up on Saturday, you'll get there Monday, and it's like 30 hours, but your law says 24 hours.
Well,
I was just asking.
No, I understand you're supposed to still see the commissioner or the bail review from a certain time period, and sometimes you can't, depending on what's going on and people working. Now, it would say 24 hours and less on the weekend. I mean, you can always change the law, change the wording, but the thing for us is that they would have to see a juvenile magistrate as quickly as possible. Some definitely will see them sooner. Let's say a young person is stopped at 3 o'clock in the morning in a stolen vehicle, and then they'll probably see the juvenile magistrate at 10 o'clock in the morning. The juvenile magistrate will be working. So, our goal is not to hold the young people at all, but the goal is to make sure that we know what's going on, that we can go ahead and move forward, because those types of cases are the types of cases we are most likely going to move forward on. We're working with the police to put the case together, but we also are ensuring the young person has the services and they're just not going home, coming back 4 months later.
Okay, that was just being specific on this bill in reference to the Central Bookings game and the ice cream truck game. Thank you very much.
Thank you very much. And Delegate Attar, would you be interested in an amendment to say something to the effect of, or whenever the next business day, or something to, to.
Absolutely.
Okay.
That's actually what happens with like a bail review. If someone's arrested Friday night, they don't have their bail review until Monday morning.
Mhm.
Yeah, thank you.
Something that, yeah. Okay, Delegate Grammer and I believe that's Delegate Arakan.
Thank you, Madam Chair. This is a statewide issue and it's been happening for a long time. It's happening in Baltimore County, quietly, throughout communities. So I'm glad you've brought this. I really like the idea of having the ability to pump the brakes a little bit. It prevents the Dundalk kids from saying, I'll see you tomorrow. I do have a question because it does seem to be a little broad and open-ended, determining the child's pretrial status. I wouldn't want to be prescriptive, but couldn't you be a little more formative about how we want to structure this? I'm hearing the ideas where you'd like to go with this, but it doesn't seem to be formative in the way that it's structured and what we're looking for the outcome to be.
Thank you, Delia, for that question. As a sponsor of the bill, I could say I'm absolutely open to amendments strengthening the bill. Absolutely.
Okay, thank you.
Thank you, Madam Chair, and thanks for staying here forever with us. This is a little bit unconventional, and I hate to put pressure on the audience, but no one in the audience is from DJS, right? Nobody, okay. I'm online about to put out an APB for Vincent Schiraldi, so I might have to contact with my trooper, but I'm actually like kind of confused and offended, frankly, that the administration has just completely dropped the ball on this entire day. Like, who in their right mind?
They had people from the administration here most of the day.
They didn't speak?
I don't know. I wasn't here the entire
So
day.
they were
but I
just
know
note taking?
There were several people here from the governor's office. They were here. I
But they
don't
didn't
know.
command their secretary to come down?
I don't know.
I mean, Sam Abed was here every day. We practically lived with a man.
I-
Sometimes we didn't want to, but he was here.
And I don't think they gave a position on last year or on the last legislation either. They didn't want to put the position on the record.
I'm appalled. I'm so appalled. I'm so sorry for everybody that's busted their butt all day here because this is crazy. They are a huge piece of this puzzle. How can we even solve this when all we have is, 2 legs of a 3-legged stool? It's embarrassing, frankly. So I appreciate you. I appreciate your effort with every one of these bills. You clearly put a lot of thought into this. And I'm just really sorry that it feels like we're missing a huge chunk of this puzzle and it's not anyone's fault, but frankly, theirs. So anyways, that's my soapbox and I'm gonna just leave you.
And if-
Isn't that so?
If I can just say again,
Yeah,
I
go
can't
ahead.
say if anyone from DJS was specifically here, but I know for a fact the governor's office had people here because I spoke to them and discussed bills with them, things like that.
Yeah, I'm trying to think like,
Yeah.
what would Hogan do if Sam had just not shown up?
I cannot answer that.
I don't know, but I don't think it would have gone real well.
I do want to say one thing. I know it probably seems sometimes that the public defender's office and the state's attorney's office are at odds, but what you really see is we both are very passionate. Without a doubt, without a doubt, the public defender's office, they love their children.
Yeah.
They love their kids and they really want the best for their children and their kids.
Yeah.
Without a doubt, we have to, as prosecutors, balance the public interest and the children's interest. So you're right. I do feel DJS, there's certain things that they're in the blind, we're in the blind, and I think it's misinformation with everybody, but you cannot, and I know I tend to fight a little bit the public defender's office, without a doubt, you know, Ms. Margaret Renaud, who's in the back, truly loves that office and loves the people, as do the young ladies who are with her. So I also wanted to say that because I know sometimes it's like, rah, rah, rah. We're not rah, rah, rah. We love the kids. We just trying to figure out the best way to do this, as you stated,
Well,
Delegate.
don't tell us you guys share pizza together in the back room like we do, okay?
Yes, yes, yes.
Delegate Phillips.
Thank you, Madam Chair. I'm looking at the flow chart associated with how all the stuff is supposed to work. And what you're referring to in terms of expediting are those relatively more violent or serious offenses that a child may be engaged in. And what I thought I heard is that in some cases, these cases are being referred in 1 day or in 2 days to the magistrate, but in some cases they are not, right? In some jurisdictions. Did I hear that?
That's what I was told, that it is happening in some jurisdictions earlier today, and then now I'm hearing that it's not, so I can't say for sure.
Okay, because I did ask excuse me, it's been a long day, DJS about this, and my sense is that they also said in some cases it's already being done, but not in all. So I'm trying to figure out, is this do different jurisdictions have different policies and practices with DJS?
That is probably what the case is over here, and in that case, it may be better to keep this as a statewide bill so we can have uniformity everywhere. But I will, again, we'll do some more research on that, and I'll also leave it up to this committee to decide if that's the appropriate.
And I just want to make sure clear, all of these from a statutory perspective are already the matters that should be referred back over to a formal intake. Correct?
Except for the car thefts, because that's a nonviolent felony.
Okay.
And
All
the
right.
firearms. Well, it's
But they're all are
firearm because it's a misdemeanor.
because it's a misdemeanor.
But in some jurisdictions, it is. In some jurisdiction, it isn't. I think there needs to be some real clarity with
Clarity
that.
on that. Okay. And but everything that fits into the violent piece immediately has to go to a magistrate. Is that correct?
That is in fact, that is a requirement that it get forwarded to my office, to the state's attorney's office for charging. There is not a timeline requirement. This is proposing a timeline requirement.
Well, the timeline requirement I thought was originally 25 days.
Yes, my apologies. The timeline requirement is 25 days.
And under 814, should that pass, it would be 15 days.
Would be 15 days.
And you all are saying you need it faster than the 15 days, even that's in 814.
Yes, on these, so in these particular cases, especially the handgun cases, because when we often see what are the circumstances under which a child has a handgun? They're either protecting themselves from something else, or they're going to use that handgun themselves. Either way, that child needs help. If we have to wait 3 weeks before we even get the case, that's 3 weeks where nobody has been able to talk to that child, and nobody has been able to talk to anyone who saw that child with a gun. That's also 3 weeks before the case comes to my office for charging, which means it goes quite similar to the adult system at that point into the clerk's office for process. We are arraigning cases now that happened in August. That is a very long delay for a child with a handgun to not have anybody addressing the issues.
And if I can add, the bill is specifically for 24 hours after the child is charged. So they get charged, and then within 24 hours, they need to go before a magistrate for these crimes.
Got it. Okay. This is one of the areas I think we were on the same page. Thank you.
Can I answer a question about DJS policy on that?
Yes,
Specifically,
if you move that microphone over to you.
Our State's Attorney Association asked the department, because we had heard a response by the department saying, well, category 1, I think is what they call it, offenses must be sent. And so I asked, the lawyer 8 million questions. What do you mean by that? What's the list of crimes? So the list of crimes that they have to send to court immediately, like next business day, is much smaller than the list of crimes of violence. They just pick certain category 1 offenses. And the big qualifier here, that decision, that policy to send them can be overridden by staff. period. So there's where you have the jurisdictional difference. So they could have a policy that that small number of crimes comes in, and they gave me that list, but the jurisdiction. So, I mean, DJS has done a big turnaround where it's no longer regional anymore. Every decision has to be made by Baltimore. You know, this small group of people has the decision-making power now. But what we're seeing is very different answers.
So that confuses me because I thought the referral issue was in statute.
No. They have the ultimate decision whether to send the case to court.
Well, so it is two different issues. Crimes of violence and handguns do have to be referred by statute to our office. But the timing is where you can have staff override. So it's within that 25 days, which works out to being 5 weeks or 3 weeks if the other bill is, if 814 is passed. But either way, that none of that is necessary. It can be shorter, but that again comes down to staff who's dealing with the intake staff in that region, in that very office, dealing with that very case.
And then the issue of shall or may is addressed in 814, correct?
I believe so, yes.
Right. And at that point, there would no longer be that discretion that the staff might have in terms of taking additional time.
Right. And that's also what this would do, would say, we understand that you might want to override for various reasons. Why don't we talk about it in front of the judge or the magistrate who's going to make the final decision?
Okay.
And also 814 does not deal with the 24 hours that we've suggested.
It does not. And I understand that. I got it.
Delegate Grammer.
Wanted to follow up on Delegate Phillips's point because it's a huge one. And what we hear about the stories about cases, is there an issue with the variance between intake, which cycles kids through the system, and communities say, we're just getting them over and over and over, which makes us have this reflexive, someone pump the brakes. What's your experience there? Is the variance in intake among jurisdictions, is there a problem? Do you see a lot of variance there?
Why don't you two answer the question? Kate,
I definitely think there's a big difference in intake and a big difference in intake decisions. I can say in the last 2 years, I'll call it, there's been a general override from the state not to send anything to court. So if it is a misdemeanor, like the local worker in my jurisdiction anyway, will petition to their supervisor. You know, we got an out of control situation, three motor vehicle thefts. Like, what do I do? I need to send this on. And the Baltimore decision is no, you may not. But your short answer is absolutely. When we have our weekly meetings with our state's attorneys, juvenile, the answers are very different according to jurisdiction, what the regional directors and Baltimore will approve. And the regional directors are largely, they just don't have a lot of discretion anymore.
In my experience, it can come down to who is running intake that day.
You are Baltimore City.
In Baltimore City, it can depend on which DJS workers are reviewing the case. There is a very large consistency issue in my jurisdiction, which makes there a larger jurisdictional issue. When I talk to the woman who runs juvenile in Baltimore County, who I used to work with, she is not seeing the same things that we're seeing. And I know she's in her relationship with DJS is different. She's working with different people. Our relationship with DJS is different. We're working with different people, and the level of DJS that we're working with is also different. And that differs jurisdiction by jurisdiction. It makes consistency very difficult.
I believe there was an intake officer that was just removed in Baltimore City. I wonder why. I feel as if, again, I appreciate that we're putting some specific charges here and saying, these are the big ones, this is what's killing us. But if we're letting the city kind of dictate the ultimate result here, we have all these little crimes, one-offs around the state, you kind of get the feeling that might be a bigger issue. and kind of controlling this problem, getting toward the pumping of the brakes so that the problems that communities like Dundalk and Essex have had for 6 years plus, you have to get at that to make the issue stop.
So now hearing the feedback, I am not opposed to, I won't put in that amendment.
I
making
like
it a
you,
local
Delegate.
bill. It sounds like, it sounds like this is not a local issue.
All right, thank you, Madam Chair.
All right, thank you, panel. Appreciate your questions, and we're gonna move on to the panel of one for unfavorable, Lauren Dollar. Come on down.
Good evening.
And ironically, members, I was gonna ask, since it's such a late hour, that you direct your questions to one person, and here you have it.
Good evening, Madam Chair and everyone. My name is Lauren Dollar. I represent young people in Baltimore City, and I am asking this committee to vote against HB 927. But I also come with proposed solutions, of which I believe that my colleagues will also agree is a good idea. So one, it just doesn't make sense in terms of how this bill is drafted and how it works with the rest of the way that we do charging, detention, diversion, to have a child have to appear in court 24 hours after charging, because charging is a petition. If a child has been detained, they will see a judge within the next business day. And Delegate Clippinger, you did mention, not Delegate Clippinger, I'm sorry, Madam Chair. I was reading your sign. But I was going to note that this would be a huge overhaul of our system to try to implement courts on the weekend and on holidays, even though I don't think that's a bad idea in the big picture, but it's a huge change to make with this bill. So I think it doesn't really make sense, I think, to require 24 hours after charging, because it doesn't give families enough time of notice to get into court. But what I do think makes sense is what is already in HB 814. And I even suggest we build on that. So that shortens the amount of time that DJS has to recommend and to forward to the state's attorney's office to 15 days. I think we should also be asking the courts to schedule the initial hearing also within a prescribed period of time once the petition has been filed. So right now, there is no timeline requirement for once the state's attorney's office has filed a petition for a case that has not come through the emergency process, that there's no timeline requirement for the courts to schedule an arraignment. And actually, our clients would like to come into court sooner. So that is my suggestion, that we build on the HB 814's requirement for 15 days, and then also include a requirement for the courts to schedule it, but it gives the families enough time to get to court.
Okay, Delegate Conaway.
By today. So if this was an adult, they might not see or might not have a determination for a day or 2 days, something like that.
If someone's arrested as an adult, they'd see a commissioner within 24 hours, and then they see a judge on the next business day.
Within 24 hours, they see the commission.
Yes.
So what happens in the case of the juvenile?
So right now, if they're detained on an emergency basis, they do not see a judge or a magistrate until the next business day.
And why would you be against it being 24 hours within 24?
I am not against it.
So you're for it within that time period?
I just think that this is a major overhaul.
That's not important. Look, everything
I'm for, yes.
COVID came through here. We had to start using computers. I put in a bill on that
15,
20 years ago.
Under the
we overhaul this all the time. It's not a problem.
To be clear, the United States Constitution requires someone who has been detained to see someone within 48 hours, and we do not do that in Maryland.
Thank you so very much.
So I agree that if someone has been detained, that they should see they should see someone within 48 hours. But this bill does not only address people who have been detained. We already have a law that says that someone needs to see someone by the next business day if they've been detained. But this law says they need to see someone within 24 hours of being charged. And there are lots of reasons that people don't get charged immediately on the day of the incident. For example, we heard there are citizen complaints, right? So if a child's parent
gets in a fight with another kid and the parent goes down and files a citizen complaint and then the state's attorney's office decides to charge them with a very serious crime, they still need notice to appear in court, right? There are times when they put it together later that a child's been involved with something because they get evidence later and then they end up filing charges against the child and send notice in the mail. So there are lots of cases where a child actually gets charged and needs time to be able to get to court, if that makes sense.
Yes, it does. Thank you very much.
Yeah.
Delegate Grammer.
Testimony. So I appreciate the recommendation as well. The problem in my district, and it has been for a long time, is the story of community association knows the kid, they know his story, they know where he lives, they know his parents, they know his name. He goes in for one crime, literally he'll be back on the street and commit another crime the same day. And that's kind of the pumping of the brakes, which resonates with me. Waiting days or weeks as an alternative isn't going to keep people from, there's a big sentiment like we're just going to move out of this area, and I have to fix the problem with the juvenile system where you have kids out the same day. So how do I fix that without this language as drafted?
How do you fix the problem?
Because what they're kind of proposing for these bigger crimes is to say, like, look, if we get these crimes, we want to see this kid very quickly.
So in my experience, and I don't want to speak for my colleagues' experience, but in my experience, handgun violations and crimes of violence are coming in on what we call emergency arraignments. And those children are being detained either in a secure detention facility or on a home monitor, which does put them in front of all of us very quickly. And so I think that it's a much bigger question than having us, it's a much bigger policy decision and a much bigger question than us making sure that we schedule a pretrial status within 24 hours. I think that the handgun cases and the crimes of violence, I do see them emergency petition and seeing a judge quickly. The motor vehicle thefts, not as much sometimes, but not as much. Does that make sense? Did I answer the question?
It does make sense. And that's why I always refrain from talking about the crime. I'd much rather have if a juvenile was arrested 2 times in the same week, then we get the pretrial within 24 hours. So that's like a hard stop. Like we're done here with you, repeat offender. You're going in front of a magistrate and that we're going to have that talk.
And that would be a policy decision by DJS in terms of putting together protocols to ensure that people make it onto the emergency arraignment docket if they meet certain criteria. Does that make sense?
It does make sense, but they're not here. Thank you.
Thank you, Ms. Dollar. That concludes our testimony. Oh, I'm sorry, Ms. Dollar, don't go anywhere.
Yes.
Sorry about that. Delegate Crutchfield.
Okay. I think I'm on now. Okay. Just really quickly, you were about to make a statement before you were timed off.
Oh, I don't
it's okay. I know there's been a
I don't
couple
remember.
You were talking about the 15 days and agreeing with that.
Yes.
HB 815.
Yeah, so HB 814 shortens the amount of time before that the DJS has to make a charging recommendation. We could shorten the amount of time that the state's attorney's office has to make their put out the charging. We could shorten the amount of time that the courts, because there is, I guess maybe what I was saying is currently within the law, there is no timeline requirement for when the clerk's office has to schedule an arraignment for a petition that has been filed. So we do see some surprising time delays, and our clients would like to come to court sooner for their cases.
Oh, thank you.
Yes.
Thank you. Now that concludes the testimony for House Bill 927. We're going to move on to House Bill 556. Delegate Attar.
Thank you, Madam.
And we're going to call up, if you don't mind, or do you want to, yep, you've got your panel. We're going to call up State's Attorney Bates, Laura Wilt. That's all I have.
Thank you, Madam Chair and members. For the record again, Delegate Dahlia Atar here. House Bill 556 requires that if a child is placed on community detention under an electronic monitoring and they violate that agreement, the DJS must notify the court, the state's attorney, and the child's attorney within 24 hours after the violation. This, I can say, I've seen this as being a problem in adult courts also, and I know it's being addressed, but it should be done in juvenile court as well. That's all. Thank you.
Yes, thank you. I do have my written testimony, but very briefly. The reason this is important is because unfortunately we're finding young people with ankle bracelets at some of my murder scenes. And young people with ankle bracelets, some of the murder scenes, because we did not know. DJS may know that they violated, DJS may know that they're gone. And all we're saying is let us know the time period so that we can make sure this young person is not out there doing something wrong. Their attorney, and sometimes the attorney may be the only person that can reach this young person. For all we know, they could have had an issue with their telephone service, anything like that. The court, the state's attorney's office, as well as the public defender or whoever the defense attorney is. This way we can make sure this young person is going to be okay. All this bill says is give us the opportunity within a time period to ensure what's going on. I don't want to automatically think the worst of what's going on with the young person, but if they've decided to abscond, at least we understand what's going on and DJS. And if anyone sees this young person, they'll know how to proceed accordingly. All this is saying is the checks and balances. DJS must give us the information. If a young person absconds for 24 hours, we didn't say 6 hours, we didn't say 8 hours, because a young person may walk away and come back. But then that's not supposed to be what happens, but we don't want to hit the alarm button right away. But 24 hours is sufficient to say something's wrong here. We need to really figure it out. Thank you.
Thank you, Laura Wild, on behalf of, in support of Bill 556. I do think this is a necessary language. I think it's sad that we have to have this specified in a bill. I can tell you that is the practice in multiple jurisdictions to ask a judge to write this language onto the order. So we, on a regular basis, when we have a child who's been a repeat problem, like not the first time they're on ankle bracelet, repeat problem, we ask the judge, and our judges do it all the time. DJS has no discretion, must notify all parties and the court. They're not saying have to send to court. It says you must tell people if they violate. And sometimes we are notified as a result of that. But I can tell you we're dealing with a very serious case right now where once the records were actually subpoenaed, our local agent got us the records, one statement from the community detention worker that said, you know, Johnny violated on X day at this time. But then when we subpoenaed the actual electronic, the beeper that told us when they were in and out, it was a different report. We need accountability for this agency, and it should make them tell the parties. We can request a hearing or not request a hearing, but full faith and true information is critical from this agency that's supposed to be supervising our kids and our community. Thank you.
Delegate Atar, quick question. Why is, or actually, anybody might be able to answer this. Why wouldn't the child's defense attorney be almost like one of the first calls if a child violates when they're on electronic monitoring?
So the way the bill is written, it says that the defense attorney, the state's attorney, and the court.
Right.
It doesn't like put in order.
No. And I get that.
Yeah.
I guess, right. I'm asking, why wouldn't they already know? Okay.
Yeah, I can't say why not.
I can tell you what I can tell you is sometime when the defense attorney, they're the last to know the child or may just not tell them, may not say anything to them whatsoever. But this way, I think it's important that everybody knows, because then the defense attorney can then hopefully reach out to the last known number, the mother's number, the uncle, the cousin, someone's number, to say the child is A-okay. They had an issue with the electricity or the phone company turned off the service. There's no need to issue a warrant for this child. That's why I think it's really important to ensure the defense attorney, be the public defender, defense attorney, be involved, because a lot of times they're the ones who can stop the problem before it gets bigger.
And Madam Chair, if I can just say, you bring up a great point. So I have no issue with amending this, that the child's attorney needs to be notified even quicker than 24 hours, and then the courts and state's attorneys within 24 hours.
Yes, that's kind of where I was going with that. Yeah,
Absolutely. That
okay.
makes a lot of sense.
Great, thank you. Delegate Simmons?
Thank you, Madam Vice Chair. So, looking at, obviously the need for electronic monitoring, and currently the way the system is, when we go back to, the Brooklyn home shooting and the aftermath of that shooting with so many people, and we talked about the electronic monitoring system, would you say that system is currently broken at its current status?
If I can jump in and say, a lot of this was based around that incident.
Thank you.
And it's an open case, so I won't say it.
I know you can. I appreciate
But I'm
you
not in
being
their
here.
office.
Exactly.
Thank you very much.
Thank you. I think that's our last bill. Thank you very much.
All righty, thank you for
Thank
hanging with us. Until you stayed here till 4 a.m. All righty, we have Laura Dollar unfavorable.
Good evening, Madam Chair and everyone. My name is Lauren Dollar and I represent young people in Baltimore City in the youth legal system, and I'm asking this committee to vote against HB 556. So community detention, or CD, is basically house arrest for kids. A child is placed at home or with a relative and they're not allowed to leave the house. But some are on total house arrest and many are not. Many are allowed to leave for approved activities like school or an outing where they are directly supervised by a parent, for example. And sometimes the children in this program have a box on their ankle that measures whether they are home or not, and that is the electronic monitoring part. Under the statute, GPS is also considered a community detention program, and GPS is a heightened curfew monitoring, essentially, where the child's allowed to leave the house for 8 hours during the day, but has an enforceable curfew. Right now, judges are totally free to order what this bill is asking to be mandatory in every case. Judges can ask for a notice after every violation, or that the child be taken into custody after one minor or major violation. And the state's attorney's office can ask the judge to order this, and judges decide it on a case-by-case basis. We are talking about kids living in poverty, often with parents who are busy and functioning with intermittent access to phones, and kids are not the same as adults. Minor violations happen all the time, especially when the child is allowed to follow a schedule to go to school or go to programs or to go out with parents, and when they're on GPS getting home late. Requiring a report to go out after every violation that occurs will be an inefficient system where minor violations are going to deluge our emails, and the major violations, which we already do get notices about, will get lost in the sauce. Judges can already order this where they feel it's appropriate, as can the state's attorney's office request it, and how much and what information the parties receive should remain in the judge's discretion. Thank you.
Thank you. Seeing no questions, I do. Delegate Simmons?
Dealing with, obviously, this is, it's all deep in aspect of what's taking place here, right? So if a kid is on home monitoring, who's responsible for the accountability of that child? The child, the parent, or the court system?
So ultimately, the child is responsible for themselves.
The child's accountable for himself?
I mean, and the parent should be accountable for the child as well.
Who's first accountable? The child or the parent?
I think it's a sliding scale depending on how old the person is. But ultimately,
I think we were stuck in the 10-year-old, 11-year-old, 12-year-old in that range.
In 10, 11, and 12-year-olds, I would say the parent is ultimately responsible. But this is just my personal opinion. I mean, I guess I don't really understand.
You don't understand the question?
Yeah, I don't understand the question.
We're talking about home monitoring.
Right.
So we're talking about the responsibility of home monitoring and whether or not the process is effective and what we should do around home monitoring.
Right.
My question to you is, knowing that there are multiple people violating currently home monitoring, my question is, who's responsible for that child to make sure that they don't violate and they're held accountable based on the court's order?
Oh, I mean, the first line is the parent. First line is the parent. Is that the?
That's it?
Yeah.
Thank you.
I think the first line is the parent.
Delegate Conaway.
Vice Chair, thank you for coming in and testify. Real quick question. The home monitoring or ankle detention, ankle bracelets, are they done by a landline or can you use a cell phone?
So my understanding is that the equipment plugs into the wall, but does not require landlines anymore. There are two types of equipment that we use in the juvenile justice system. We have one type of equipment that's used for the community detention program where a box is plugged into the wall and it measures whether someone is home or not. And the GPS box speaks to a satellite and then has a charger that is plugged in. The issue is that we see lots of violations because these are kids and a lot of times the violations are very minor. And so getting emails every day with every violation that's occurred is just not an effective way to address the behavior. But for very serious cases, the judge can totally ask for that or order that, and then DJS will comply.
Thank you very much.
So is there a range of violations that would make sense to put in statute?
I certainly think that putting a reasonable range of amount of time that a child has been out of the home would make more sense than what is currently in the language, for sure.
Okay, great. Thank you. That concludes this testimony for House Bill 556.
Thank you so much.
All right, Delegate Attar, it's been lovely. Good night. All right, Delegate Embry. House Bill 703, Delegate Embry. And we have the wrong. Here we go.
I know. It's not your fault.
All right, I just have the two of you listed and Delegate Embry, please begin.
Thank you. Thank you all. Well, I shouldn't say that because I don't want to lie to you. I'll be as fast as I can. So this is a juvenile bill, but it's a very different kind of juvenile bill. It just had that word in it. So I got trapped and poor Carrie got trapped on this lengthy day. So this bill is brought on behalf of the Attorney General's office. We created, before my time at this body, created the Independent Investigations Division in the Attorney General's office in 2021, excuse me. And that was part of, efforts around police reform and transparency. We expanded it. They handle police involved, not just deaths of civilians, but also serious injuries. They have a duty to the public to provide information, to make public what happened. And then they do a report with recommendations and explanations of their legal analysis. And Perry will elaborate on that. The reason for this bill is our law protects police records that involve children, juveniles. They're confidential. That's good. There are exceptions to that confidentiality for missing children, for warrants, for other reasons, for school sharing information. But it also restricts the IID and the AG's office from putting out information if a child has been killed in a police involved event or seriously injured. And so to correct that, to allow for that information to be shared where appropriate, this would create an exception, but only with the consent of the parent. So the parent, the family of the child, who is in most cases deceased, would be able to decide what information can be shared. So this would align with what would happen in a case involving an adult victim. Police records include, of course, written records, but also body camera footage and other things that I will let my excellent witness talk about. So I will stop early and turn it over.
Thank you,
Mr. Rossman.
Good evening, everyone. I'm impressed that you're all here and asking great questions. My name is Perry Wasserman. I'm an Assistant Attorney General with the Independent Investigations Division. I've been with the division since its inception in 2021. I was a violent crimes prosecutor for a decade in Baltimore County before that. IID to date has conducted 47 investigations into civilian deaths. We've looked at about 105 police officers, their actions from 20 different law enforcement agencies in more than half, just over half of Maryland's 24 jurisdictions. As Delegate Embry said, one of the hallmarks of our work has been public transparency. In every case we take, we strive to provide the public as much information as we can, as long as it doesn't affect the integrity of the investigation. And it'll we can still uphold our ethical and legal obligations as prosecutors. So what we're talking about specifically is that in the days and the weeks after a police involved fatality, we release the name of the decedent, the age, we release the name of the subject officers, we release body worn camera footage. For cases where we don't charge, where in this case, the Attorney General will decline charging, we put out a report that explains the interaction between the two. The concern here, as Delegate Embry said, is because of the way the law is written in Maryland, that a juvenile record has to remain confidential. We would not be able to put out almost anything about the case if what we learned about the case came from that police record. And just to be abundantly clear, we're not talking about publicizing physical copies of police reports or anything like that. The concern is that information derived from a protected source is protected just like the source itself. So if what we're learning about this interaction came from a protected source, we wouldn't be able to put it out. So that's why we're asking for this bill.
Thank you very much. Delegate Conaway.
You all for coming in to testify on this bill. I was wondering, since the last comment was about body-worn camera footage, you would just release body-worn camera footage on to the news media? Is that...
So what we do in our cases now is we have a video channel and we do publicize body-worn camera footage in our cases. It's not been done in every case, and there's reasons why it may or may not happen. But in the vast majority of our cases, we do put out that body-worn camera footage.
How do you choose which cases you're going to put out and which ones you're not?
Well, first of all, we have a very detailed protocol document on our website that explains exactly how we decide what we can put out and what we can. The number one thing is that we will not put it out if we haven't been able to finish all our witness interviews. We don't want witnesses, civilian or law enforcement, having access to video before we get to interview them. So that's really the main reason. We also want to always protect the integrity of any potential prosecution. So if we do have questions about the ability of that video to be admitted into court, that could give us pause, whereas we might not want to put it out right away. So it really depends. But in the vast majority of our cases, we have released video, and now we, with our new protocol, since we got prosecution authority starting in October, we aim to put it out within 20 business days of the incident. All of this, Delegate, goes to what we see as our mission of public transparency, to let people know what happened in these interactions between civilians and police. That was what we took from the General Assembly, from various enactments in 2021, 22, 23. And again, that's why we're here today. The specific concern is that if a juvenile is being investigated by police for a delinquent act, or even just contemplated by the police to have committed a delinquent act, the prohibition on sharing information derived from juvenile records is so absolute, we don't think we would be able to really tell the public much of anything, which we don't think is productive in cases of alleged police misconduct.
Well, that was wonderful, but I'm talking about children injured or killed in a police-involved incident. Am I on the correct bill here?
Yes, sir.
Yeah, I know I am. Thank you. I know I.
You are.
Yeah.
You are,
Okay,
yes.
so what's gonna I'm in favor of your bill. Well, here's my question. When you go up to the African American Smithsonian Museum, down in the basement, you'll see a dude named Emmett Till. And when you see that footage on TV, what's going to happen? When you see George Floyd's footage on TV 20 days later, what's going to happen? When you see Freddie Gray's footage on TV, what's going to happen? I understand what you're trying to do with your transparency. I'm for your bill. But if you have a real handle on, in my opinion, on what's really going on, you might want to rethink doing this. That's all I'm going to say. So thank you very much for indulging.
Thank you for the question.
Delegate Erica.
Thank you, Madam Chair. thank you guys for being here at this late hour. So you'd mentioned that you guys have had 47 investigations, is that what you said?
Yes.
And I mean, I like the idea that with 20 days a report goes out. I think it's really helpful and, you know, could potentially give us some long-term improvements in the
The
public
body
perception.
worn camera footage goes out.
Okay, so the report's not 20 days. Okay. Okay, that I was, dang,
report
you guys
we-
are the fastest government agency I've ever heard of in my whole life.
The
Okay,
report
that
will
makes
go
sense.
out, if it's a declination, if we're not prosecuting it.
Yeah.
The report will go out within 30 days of the decision.
Okay, and so that's my next question. So how many declinations have you had?
So the Attorney General's office, so up until October 1 of 2023, the local prosecutors had complete prosecution authority. They made the decisions. My understanding is that of all those cases, one was indicted.
Okay.
And actually that individual was a police officer. He ultimately pled guilty in Baltimore City Circuit Court to a involuntary manslaughter. My office, the Attorney General's office, was not involved.
Okay.
So since October 1, 2023, which I think is probably what your question is, we have released, I believe, one report, which was a declination.
Okay.
And our other cases are still kind of in the pipeline.
Okay, cool. All right, that's.
And can I just add, you put all of your reports are on your website?
Yes, yes, along with the body worn camera.
We love transparency and data on this side, right here, the non-lawyer section. We're super into the data and the numbers. Okay, cool. Well, thanks for coming in. Just give you an opportunity real quick. What do you think your opposition is going to say about your bill?
We both, I think, had a conversation. I think the concern, I mean, I don't want to presume, but I understand the concern is once material is out in the ether, it's out. So we're of course open to any thoughts. We think having the parents give permission is sufficient because they can consider, they can weigh, this is what happened to my child and I want the world to know versus this is painful and I don't want the world to know. So
Okay.
we're putting it in the hands of the parents, but I think I'll let the opposition speak on that.
I
but,
think that seems like a smart move. Good work, guys.
But that's our thought. Thank
Yeah,
you.
yeah.
Delegate Simmons.
Thank you, Madam Vice Chair, and appreciate you, Delegate, for bringing this legislation. Can I just ask you, is there any concern with the releasing of this information of contamination of the jury pool on, you know, the court system and things of that nature? Can you talk to that?
Absolutely. And I think that was that I should have brought up those issues to Delegate Conway's
You can talk
question.
today, don't worry.
Because what I was suggesting when I was saying, if we're not certain that the video can come into evidence, then that could be a potential contamination of a jury pool, let's say. And so those are the types of things that we factor. Now, of course, courts have ways of dealing with that. We have an extensive voir dire panel, voir dire process where we can strike jurors and that type of thing. But that's not, the point is to not just rile people up. It's to tell the public what's going on with these interactions. So it's something we're concerned with.
I get that, but that's exactly what happens, right? Because people can take information and then they can change it and then put it back out. We often talk about social media and what that looks like when it comes to information, and people are very social media driven, right? And there's a lot of misinformation out there. So you may put out correct information, but by the time it get to me, it becomes misinformation because it's been reprocessed and things of that nature. So I'm just concerned about, although you may have good intent, but the reality of the bill and what it will result in when it comes to social media and how people will perceive it, especially before something even get into the courts, right? So the whole jury pool is out the window.
So I'll tell you what we are doing. We are putting out, and I take your concerns. I understand completely what you're saying. What we are doing is we're putting out the information in as raw footage as we can. We're providing it directly to the public. It's not being mediated in any way. It's available on a YouTube channel that's linked off the OAG website. We take great lengths to not editorialize in any way. We don't comment on what we think the footage shows. So we take those types of steps. And again, we have had cases where we've had to make the determination to not put out video, even though we have video that depicted the fatal encounter. But, you know, it's something I think, you know, as criminal practitioners at large now, it's something we're facing.
Sure, and I appreciate the criminal practitioners, and I would just follow up with this. Is there still a presumption of innocence until proven guilty?
Yes.
Okay, thank you.
Absolutely.
Thank you.
Thank you
Thank you very much. That concludes this panel. We're gonna call up Alicia Capozello on the panel of unfavorable.
Good evening, Madam Chair and members of the committee. My name is Alicia Capozello. I'm Deputy Public Defender for Baltimore City, and the Maryland Office of the Public Defender seeks an unfavorable report on House Bill 703. This bill allows not only for just the details of an event inside of a police report to be publicly released, but also the public release of the name, age, photo, or video of a child who was killed or injured in a police-involved incident. It does not further any safety or investigative purpose, and it's counter to the very reasons that these materials are generally confidential. Protecting the identity and records of children is an established tenet throughout our culture in recognition of the heightened vulnerabilities and risk of exploitation that children encounter. The confidentiality of police records is particularly important given the stigma associated with police involvement that children are ill-equipped to defend against, but will stay with them for years, if not decades to come. Again, this bill does not further any investigative or prosecutorial function. The police records are already available to law enforcement, and they can already be shared in a relevant court proceeding under seal. Authorizing dissemination of this information to the public serves no purpose. It serves the purpose of transparency as stated, but at the expense of the child. It's fodder for the public to learn about and stigmatize a child who has interacted with the police, and perhaps even worse, it may be used to justify abusive police behavior and police violence not being prosecuted. To address the issue of parent consent, the consent of a parent or guardian does not offer much protection. Firstly, the parent or guardian is unlikely to understand the full implications of allowing this information to be released. Moreover, a request from law enforcement to a grieving parent or guardian shortly after their child has been killed or injured is not truly conducive to voluntary and informed consent. And then there's no control over the use of the images and information after disseminated. Again, because this is a public transparency at the expense of a child, we're urging an unfavorable report. Thank you.
Thank you. Delegate Simmons.
Thank you, Madam Vice Chair. When you talk, when we're talking about this bill and we're talking about the impact of this bill, I haven't heard anyone yet talk about the victim. So, and talking about releasing footage, is it possibility that the victim can get caught up in the footage that's released?
Well, my understanding of the bill is that we are talking about a child victim. It's the name, the age, photos and videos of the child victim that this bill would allow the public release of.
Thank you.
You're welcome.
That concludes our testimony for House Bill 703. Next, we have House Bill 319, Delegate Kipke. And I'm going to call up Laura Wilt, unless you have a specific order of a panel.
No, just want to make sure Delegate Shalega is included.
I've got her here favorable with amendment.
Yes, thank you very much.
Okay, so we're going to start with favorable testimony. Delegate Kipke, obviously you're favorable.
Thank you, Madam Vice Chairman. Good evening, members with great endurance. The HGO committee had a long day. We ended at 6:30. But I appreciate your dedication.
Move unfavorable.
I appreciate your dedication to the people of the state of Maryland. I know you've heard a lot today and in recent times about juvenile justice, in not knowing what might be presented. I know the speaker had a robust bill that was heard today. We sought to offer ideas as well. And I present to you today the House Bill 319, co-sponsored with Delegate Kathy Shalega and others, titled the Juvenile Justice Restoration Act. This bill seeks to address concerns shared by many throughout the state related to the dangerous crimes committed by youth in our communities, which have increased substantially in recent years. I'm sure you know and have heard extensively about the calls for reform in this area, as we see dramatic increases in certain types of juvenile crime. In the past 3 years, youth gun violations have risen by 220%, carjackings involving minors spiked to 85%, and auto theft by juveniles increased by 65%. What the bill does is it addresses the issue that is related to interrogation, allowing for parental consent. Police and state's attorneys have requested this to allow parental consent as a substitute for the required consultation with an attorney. It also addresses some of the things that the Speaker's bill did as it relates to certain crimes of violence to have them dealt with the juvenile justice system. Delegate Shalega has an additional amendment, and I kind of sped through that because I wanted to draw your attention to, I have a constituent who I hear from weekly named Carla Moreau, and unfortunately I had to attend the funeral of her son who was murdered in my district just not too long ago. And I asked her to share with me some thoughts about this because the reason I hear from her is she follows the juveniles that were involved in the murder of her son. And what she wanted me to share with you is the following. While our son lay dying in the yard, these criminals went to a royal farm only a few blocks away to buy snacks as if it were just another day. Her son was a bystander in a party, not the desired person that they were seeking to harm. But he died in that yard. They went on to hide out at one of the criminals' homes and were caught the next day. We would then learn that all 6 were juvenile repeat criminals starting within their juvenile years. Some still had open cases waiting to be heard, but continued to be postponed, delayed, and unfortunately, I've had to suffer following all of their cases. These crimes range from theft, carjacking, robbery, drugs, gun violations, and now the murder of our dear son, Matt. Just conclude that the family has had to follow this for years, and she says it's gotten worse. And she asks that this legislature take action to address this increasing problem. Thank you.
Thank you, Ms. Wilt. Ms. Delegate Shalega, I'm gonna get to you last because you're favorable with the amendment, okay? Okay, Ms. Wilt?
Thank you. I am testifying in support of the idea and the premise behind this legislation. I do see that I believe it would need some tweaking, and that is, I would point out the idea that on page number 2, that if committed by an adult, so there are certain offenses that would have to, okay, I'm not speaking clearly anymore. I've lost it. The court, it says, it starts by saying the court would have jurisdiction over certain youth, right? And one of the categories is number C, where if the youth has committed any crime, if that particular youth has been arrested on 2 prior occasions. But the thing is, we wouldn't know about those 2 prior because they couldn't have been charged. So if they weren't charged because they were under 13, we wouldn't be able to now charge this one because we don't have the police making a record of the prior. So the idea is there. We need to figure out who has repeated offenses, but if we can't charge them, I can't see, and I've run this by some other people to see if I'm missing something. I don't see how DJS could possibly have a record of the 2 prior offenses for this to be effective. So just something to think about there. And the point with the parents being able to give consent, our very first time we had youth taken into custody, and the police called the public defender so they could have the youth talk to the public defender before being interviewed. I can't tell you that father pacing outside the room, he was told to leave. He couldn't even be there. The fact that the parent is made to leave the room while the public defender is speaking to the child, the father couldn't even be there. He was so angry. There's so many parents who want their kid to be able to tell their story. I understand the public defender has a different purpose than the parent, but the parents are rendered superfluous and ineffective, and it's very upsetting to our parents out there.
Thank you. Delegate Shalega.
Thanks so much, Madam Vice Chair, members of Judiciary. Thank you for your long-suffering hours in this committee and for being here this evening. So Delegate Kipke and I would definitely entertain amendments that you've spoken about. We would like to see the Juvenile Reform Act repealed completely. That was the bill that Delegate Arkin and I had last year. But this amendment you have before you, and I hope it's in your floor system, is perhaps the most important part of this bill right now. It will close the juvenile sex offender loophole. So what the amendment says is very simple. A child may not attend a public school in person if the child has been convicted of rape or a similar sexual offense that, if committed by an adult, would constitute a felony. And the school shall provide alternative educational opportunities. Why would we have this be the most important thing? Well, I'm not sure if you've seen it on the news. It's been all over the Baltimore news, but if you're not from that area, you may have missed it. Very sadly, just in December, a 15-year-old boy pled guilty to raping a 3-year-old girl. And during that, I've spoken to the child's mother. This is a firsthand account of what happened. Right now being adjudicated any day now. This same young man, when he was, this boy, when he was 13, raped a 2-year-old girl. This boy is at Patterson High School. The mom called the school and said, in the fall, when the boy started 9th grade, you have a child in your school that raped my 3-year-old daughter. And the principal said, we cannot get the child out. We had a Baltimore County delegation meeting last week on Friday. We asked superintendent directly, can you get a child out of your school that has raped a child? And they said no, because there is no child sex offender registry. So this is happening right now. And, if you do nothing this session, please close this juvenile sex offender loophole. Thank you.
Thank you. So I have Delegate Kaufman, Conaway, Grammer.
Thank you. Thank you, Delegate Kipke. It's good to see you.
Good to see you.
I would just say that I have some from the outset. I have some concerns about your bill because if mom or dad or grandma or grandpa, whoever the child is living with, waives the rights, it's not mom or dad that's going to do the time or face the consequences. It's the kid. But my question for you is that if your bail is successful, are you at all concerned that that it is a slippery slope where later on next year a bill is going to come before that will say, yeah, let's waive my child's right to a jury trial because they're a jerk, so they just deserve to be in prison, or let's waive their 8th Amendment right to cruel and unusual punishment because I think they did something heinous, so we can have them, killed by a firing squad or something. Are you just at all concerned about the precedent that once you start letting a parent waive one amendment to the Constitution, they'll waive some other ones?
No, I respectfully think that that's kind of absurd. We lived for many years under laws that allowed for what I'm suggesting. And none of the things that you are suggesting were ever suggested by any reasonable mind.
Well, I understand that it may seem fanciful, but I am concerned because it's the kid that is going to end up suffering. So I think while my examples might have been extreme, I am concerned about the precedent that it sets, but we can agree to disagree on this, and I thank you for bringing the bill forward.
Thank you.
Delegate Conaway, I might have said Graham. I don't remember the order I said, but
Vice Chair, thank you.
There you go.
Panel, how you doing today?
Good evening.
My question is in reference to page 6, line 16 through 18. The child's parent, guardian, or custodian consents to the custodial interrogation of the child without the child's consultation with an attorney. I guess you just stated it when you were speaking to my fellow seatmate that you're in favor of this. Is that correct?
So state prosecutors in our state have communicated to the legislature that without this ability, there is no conversation with the offender or witnesses, people participating.
You left out a word juvenile, right? So we're talking about an adult who does not know the law or may not know the law saying, it's okay, go ahead and talk to law enforcement or whoever and just spill your guts, tell everything you know. And the attorney might say, no, we need to see the evidence against you. So you might have a conflicting view, but now you're gonna have the child's rights waived by the parents. That doesn't seem right.
Well, I would suggest to you that what happens now in practice is they're told not to say anything ever, and it inhibits the ability for justice for victims.
And as an adult, if I was your attorney and they were questioning you and I said, listen, I'm your attorney, don't say anything. Take the fifth, be quiet. What are you gonna tell me? No, I would just want to confess.
But in my case, I would say, as a father of 4 children, I'd want to ensure that justice prevails and that the rights of my children prevail as well. So I think it's a little bit more of a nuanced position than what's currently happening today.
Well, not really, because your child could be a victim of targeting, racism, all kinds of things. So, and you might not know about it. It's a lot of things that happens in a child's world, as I understand it, that parents don't know. But I thank you very much.
Delegate Grammer.
Thank you, Madam Chair. We appreciate you bringing the bill tonight. I have a couple brief questions. So your bill includes something that the Speaker's bill included, that was the addition of the use or possession of a firearm. It seems multiple bills have included that today. We love to see that, so kudos. One of the things that your bill we've debated today is having statutorily defined crimes in which we can bring a child into the system. But what your bill does is it says if the child has been arrested on 2 prior occasions. And what I see a lot sounds like your story, Delegate Kipke, where you have a youth or a group of youths who have an escalating course of conduct. They're involved in multiple crimes, and then someone gets hurt, someone gets killed. I think the way that your bill addresses that really speaks properly to trying to deal with repeat offenders. Can you talk a little bit about your experience in your district and the experiences your constituents have?
Of course, there's no perfect way to go about this, but I hope most see that we have an increasing problem of violence in our state that's putting youth and others at risk. In the case of my constituent, the Moreau family, they have followed the people who were involved in the murder of their son. They had priors when they were juveniles. They just, hear stories about when they were young, and they learn from the neighborhood about what's been going on with them. And now that they're adults, they continue to follow the continued violence. And they're very frustrated with the fact that there doesn't seem to be real consequences for them. All that aside, I think that it's just appropriate that there are protections for the public. I appreciate the work that this committee has done. I voted for a lot of the policies that ended just locking everybody up. And I appreciate the work, but there has to be a sweet spot, a middle ground as it relates to these situations. And you all are the experts. And I just implore you on the behalf of my constituent and others to keep up the good work that you're doing and seek out that middle ground that protects the public and ensures justice for all of our citizens.
One final question, a point to Delegate Kaufman's question. You cannot waive a right, but that's not what our legislation does. The bill that we passed last year, what it does is it binds the ability of an officer to conduct an investigation. So what your proposed change says is that if a parent acting on behalf of the child, because as we know, the ability of law enforcement to work with children, witnesses, and potentially victims to figure out what happened is really important to get to the heart of the crime. So what you're saying is a parent acting on behalf of the child or the youth that they have guardianship over, if they give consent, that child or juvenile will be able to work with law enforcement under the investigation.
That's correct.
Okay,
And
thanks so much. Go
If
ahead.
I can add, the current law would require that youth be read their Miranda rights. It would still have to be proven to be free and voluntary. And the law requires that interview with police be recorded. That was part of the law that you all passed. And I think that is probably the sweet spot right there, is that interview with police has to be recorded so it can be fully litigated, whether there is coercion. It is not free and voluntary. It is all out there. We just love the body cameras. We love the video recording to protect the rights of the youth and our community in general.
Sounds reasonable for youth that want to see justice served. Thanks so much.
I have a couple of questions. This one's from Ms. Wilt. You mentioned about the father who was upset outside of the interrogation room. So if it had been a girlfriend, let's say, I don't know the age of the person who was being interrogated, but if it had been a girlfriend and she was outside of the room, or if it had been, let's say, a group of individuals who felt like the questioning was wrong, maybe family members, maybe cousins, whatever. That example that you gave, while I understand the spirit it was given in, you're not suggesting that we should violate a child's rights because of the folks who are outside of the interrogation room.
No, it was the relationship of the parent being controlled by the public defender, not to be even able to be sitting in the room.
Well,
Not to give the choice to the kid, to let the youth say, do I want the parent there? Do you feel more comfortable? Do you want your parents sitting with you? Those options weren't given.
Well, those options weren't given, but that is actually not what the law states. The child must consult an attorney, and I need someone to explain to me why it is wrong for a child to consult with an attorney before an interrogation. The child can waive their right after consulting the attorney.
Right.
The
Yes.
parent can come in the room after that child is consulted with an attorney. So all of that could have still happened. That parent outside of the room could have come in later. But the first step, because we have to get to knowingly and intelligently waiving the right, but you can't waive a right that you can't knowingly, intelligently understand.
I understand what you're saying, and I understand your perspective. I think what I've heard from our community is that the parent wanted to be there during the advisement with their child, and and I understand that's not dictated in the law, but that is the policy and the practice of the public defender, not to let the parent in the room.
Right, because it is in the law that it has to be confidential. Because that is in the law. It's
The
confidential.
person can waive it. I mean, the youth can tell them whether they're comfortable and they want their parent there. But
Confidential. You can do that. You're right. You can waive a child, an adult can say, I want someone else in the room, and they can waive attorney-client confidentiality. But what we're stating is we're trying to get that child to that level of knowingly and intelligently. And the way that the best way we can get them there is through having consultation with an attorney. I understand parents' rights. Parents can come in the room afterwards and they can stay there all night.
and that's been allowed.
Yeah,
Yeah.
yeah.
that is.
Okay, so I just want to make sure we clarify that, but moving on, I've got some folks who's got questions. Delegate Conway for a second bite of the apple.
Thank you. I've seen people today get 4 and 5 bites. So here's my question. I normally don't do this, but I want to know, do you have any data that says that a 13-year-old can understand their Miranda rights being the sweet spot? Do you have any data that says a 13-year-old can understand what that means? You have the right to remain silent. Now talk to me.
No, I
Anything
didn't-
you say that, will be
No, I
used,
didn't
and
bring
help-
data
will be
about it.
used against you. Now talk to me. No? Okay.
Delegate Conaway, I'll get back to you about
No,
that.
I don't need you to get back to me. I know you
Okay.
don't have it.
Okay.
All right, we're getting late in the hour. let's move on. Delegate Boucher and then Delegate Phillips. You all know who was first, but I'm going to call you in that order. Thank you.
Thank you, Madam Vice Chair. And thanks for your patience here this evening. This question is directed at the Councilor Wilt. Can you name for this body right now any United States Supreme case law that grants a third party the right to waive the constitutional rights of a second party? Because that's basically what would take place. A parent would be the third party waiving the constitutional rights of the child. Is there any United States Supreme case law that states that can be done?
No, and I didn't read it that way. I thought the child still had to waive the rights. The
Well,
child still has to waive the
Can
rights.
a child sign a contract?
I'm so,
Can a child sign a contract?
so no. Not a legal
Exactly. They
right.
cannot. You're saying that a child who cannot sign a contract
Mhm.
has a legal right to waive
Well,
their
that's what our
constitutional rights that
courts-
they don't understand.
The courts have allowed that. We've gone above, beyond and allowed additional rights and provided additional protections than what's allowed throughout the rest of the country, right? This is an additional, the laws that we have in place are above and beyond anything that's been required by our courts anywhere else.
But you cannot cite for me any United States Supreme case law that grants the right of a parent to waive their child's constitutional rights.
And again, I want the parent to have a voice and the child to have a voice, not one or the other.
But I
That's
think
what I read this to mean, that the parent or the attorney is consulted. The child still has to be advised, still has to be recorded, still has to give that knowing and voluntary waiver. And the court still has to evaluate whether it's free and voluntary. And the case law, the court decisions have said, you don't evaluate that free and voluntary waiver like you've evaluated an adult's free and voluntary waiver. You have to consider the age of the child, the intellectual ability, the education, the prior experience. Has this kid ever even talked to a police officer? There's like 14 factors or more in the case law that say this is what a court has to decide to determine if that kid understood those rights. So there is case law that says the child should not be treated like an adult. It's not an adult's waiver of a constitutional right. It has to be evaluated at the age and then the position of the child and that's what a court is to do. And that's why recording these things is critical.
when you state case law, you stating a Maryland Supreme Court case law or a
Yes.
United States
Oh,
Supreme
absolutely.
case law?
All of the above. There's so many cases that talk about how you evaluate a child's waiver of their rights and the many factors involved. And if I was doing it yesterday, I'd give you the name of the cases. They've been litigated so many times. They're decades old.
All right, thank you.
Thank you.
Thank you, Madam Vice Chair. Is anyone on the panel familiar with Yusef Salaam, that name? Yusef Salaam.
No.
Okay. I had an opportunity to meet Yusef Salaam a few weeks ago. He's now a council person for the city of New York. Yusef Salaam was one of the Central Park Five. Yusef Salaam served approximately 6 or 7 years in prison. If that is not a case for the reason why this change in the law was passed, I can't imagine that there is no other case that suggests otherwise. Yusef Salaam and 4 others were interrogated by the New York City Police Department. It was taped. Some of them had their parents actually show up. Some of their parents told them, you tell them something. None of these children were involved in this rape that took place in Central Park. None of them. The parents said, you tell them or you admit. That is why this is in place. I don't see how we get around this idea of at least informing our children that they have their rights to be protected and that they be informed in a way that they can understand by people who have been trained to teach, to tell them what they can and cannot do. what their rights are. I don't see how having a parent in the room changes that. Please help me understand.
Having the parent in the room, I would argue that the parent being there and holding that kid's hand while they're talking to the attorney. I mean, I cannot fathom someone giving my child advice and me not at least hearing what they have to say uninterrupted. I mean, just if my child wants me there, all of that needs to be recorded and known. I understand and certainly know that case you're talking about, and everyone probably does know. I just didn't know the name. And we do need to have protections in place to make sure those things never happen. And we need to figure out what they are. But having a parent not being able to be with their child when their child wants them, that just does not feel right at all. But I understand what you're saying as well. That's not right either.
Thank you. That concludes this panel. We're going to move on to unfavorable. I have Ken Phelps Jr., if you're still here, and you get a prize if you're still here. Keith Lottridge, Sarah Wendell, and Evelyn Walker. And if you would just make sure when you come up, if you could identify yourselves, that would be great. And whenever you're ready, you can begin. This is unfavorable, members, if I didn't say that.
Good evening again. I think you know why I'm here. So I'll go first and I'll try to be brief. This is another bill which increases the number of juveniles who could be charged when you're dropping the age. That's the first portion I will address. I've already told you these types of cases require more services. I'm sorry, I thought I was talking into the mark. So I thought you all knew me, but you're right. It's so late, I'm just skipping ahead. Good evening, I'm Keith Lottridge. I'm the Deputy Public Defender for the state of Maryland. And I am here again to address this bill and its effect on the Office of the Public Defender and the fact that it will in fact have a financial impact on our agency that we are not able to absorb. This bill, like other bills today, increases the number of children who will be brought into court. It drops the age of children for handguns down to, I believe, 11 or 10. I'm sorry, I don't have the bill in front of me at the moment. 10. The last time I testified a few minutes ago, I gave you the stats from 2022. 1,081 children under the age of 13 were charged. About 3% of those were charged with handguns and deadly weapons. I don't know the exact number that were handguns, but it's about 3%. So this is about 30 children. That's not a large number, but it is a number that we will have to address. And it is something, quite frankly, that we don't have the resources for. It's also rather a lot to do for just 30 children who, quite frankly, would be better served by services as opposed to being brought into the juvenile system. The second portion is the waiver of an individual's rights by someone other than that individual. Now, I'm just going to talk about the cost, because the cost is this. Every single case, we will litigate the constitutionality of this law, everything that was collected by that child, the derivative use of that information, and we will take that every step of the way, because quite frankly, there is no precedent for this. It is unacceptable. So again, we would ask for an unfavorable report. Thank you.
Good evening, Madam Vice Chair, members of the committee. My name is Sarah Wendell. I am a juvenile public defender here in Anne Arundel County. We also urge an unfavorable report on House Bill 319 because, again, as you've heard multiple times, these are 4th, 5th, and 6th grade children that we are talking about. And specifically looking at the additions to the jurisdiction, especially the provision about bringing in children of that age for any crime if the child has been arrested on 2 prior occasions. Again, crimes of violence that are alleged to have been committed by 10, 11, and 12-year-olds are already within the jurisdiction of our court system. Those cases are already coming to court. And by adding these very broad provisions we are moving backwards. When Maryland raised the age of criminal responsibility to 13, they brought themselves in line with international human rights standards. This takes a huge step backwards. And again, it's very broad. Charging a child with any crime 2 or more times makes you consider which children we are talking about in which areas, which communities. And those are the children that are going to be captured by this bill and perhaps do have needs, but they can be fed and met through other services available through the SINS petition process, through the Department of Social Services. There are other agencies apart from our juvenile court system that can meet that need. And they can usually do it hopefully a little bit quicker, because as we've all been talking about, if these cases come to court, the kids have constitutional rights. They have constitutional protections and their right to effective assistance of counsel and to have a full trial. It's not like teen court once you get there. It is very procedural, very serious. And these things take a lot of time and they're very harmful to the kids who get there. And again, these are 4th, 5th, and 6th grade students. And for those reasons, we urge an
Good evening, members of the committee. My name is Evelyn Walker, and I am an attorney with the Maryland Office of the Public Defender in the Juvenile Division here in Anne Arundel County. The Maryland Office of the Public Defender respectfully requests this committee issue an unfavorable report on House Bill 319, and I am specifically here to testify today regarding the amendment essentially to the Child Interrogation Protection Act, which would allow a parent or guardian to waive a child's right to be consulted by counsel. Overall, SIPA must remain as written to protect the children of Maryland's constitutional rights. Evidence suggests that the presence of a parent neither increases a juvenile's assertion of their rights nor mitigates the coercive circumstances inherent in police interrogation. Many parents themselves are unaware that their presence or participation in their child's interrogation can fail to protect their child's rights. Every child has the right to understand their legal rights and protections, and this cannot happen unless they are properly advised by a lawyer. As an attorney who works on the Youth Access to Counsel hotline, I am trained specifically on how to advise children. I am able to objectively assess a situation and help a child understand what's going on with the legal system, explain their rights to them in an age-appropriate way, and allow them to make decisions for themselves about whether they want to talk to the police or not. This amendment would allow a parent to waive their child's rights with no regard for what the child wants or needs. Children are constitutionally entitled to legal protections as individuals, separate and apart from their parents. And parents cannot replace legal counsel for a child, especially when the child is accused of delinquency or criminal acts. To allow parents who may be scared, confused, or angry to override their child's right to counsel would be detrimental to children across Maryland and is unconstitutional. And therefore, we would respectfully request an unfavorable report on House Bill 319.
Thank you. Delegate Conaway.
Coming to testify to the last lady that testified. Previously, we were given information about how important it is for the parent to be present during this interrogation. Would you agree with that?
I would not agree with that.
Okay, well, let me ask you this question. Let's say a severe trauma happens to your child and they needed open heart surgery. Would you agree that the parent should be in there with those doctors just helping out with tools and swabs and all of this?
I would not agree with that either.
Thank you so very much.
Delegate Simmons.
You had open heart surgery.
I did. Thank you. Yeah. No, nobody was in there.
Your parents were there with her.
Yeah, no, they wasn't there. Let me ask you this. So obviously we're once again talking about the mechanisms of our criminal justice system. When a child is being detained for purpose of interviewing them or questioning them relating to a crime, is there a mechanism that triggers CPS?
If police are provided with information that a child is being neglected or abused, they are mandatory reporters, so they should report to CPS. And I can also tell you that sometimes officers even call the hotline, which isn't what the hotline is technically for, but we're glad when they use it, to ask us questions about information in regards to CPS. And we've, with the consent of a child, have actually provided information for that.
Okay, so if CPS gets involved, let's say immediately, like they call and they're put in touch with a CPS, do the CPS representative supersede the public defender in a sense of advocacy for the kid?
What I would say is that I think CPS's involvement is separate and apart from what the Office of the Public Defender's involvement would be. Our involvement is simply to advise a child of their constitutional rights. We are there to explain their Miranda rights to them and make sure that they understand them so that they can make a proper waiver or non-waiver. CPS is involved in a different capacity than us.
Would CPS supersede the authority of the parent?
I don't know that I can answer that question just because I'm not, fully involved with CPS, but they may be able to.
They do. Yeah, thank you. All right, appreciate it.
Delegate Boucher.
Thank you, Madam Chair. Do juvenile offenders have a higher rate of parents who neglect or abuse them? Do you see a pattern where juvenile offenders come from homes where their parents aren't the best parents, so to speak?
Now, I don't have any of that data specifically, but what I can say anecdotally is that a lot of times that the children that I represent come from homes that struggle. And sometimes we have parents that struggle. Sometimes we have parents that don't struggle. But yes, trauma is surrounding the children that are involved in our system.
And the second question, do you think those parents are in a position where they have the knowledge and ability to waive their child's constitutional rights in their best interests?
Now, I can't speak for all parents, but generally speaking, the studies suggest that adults are while children understand their Miranda rights much less than adults do, adults also struggle. And again, we are specifically trained in juvenile brain development. We have a youth access to hotline council within the Office of the Public Defender that spent months coming up with appropriate language, especially language that came from Dr. Grisso, who's the main doctor that studied this. And so we are more equipped to advise of their Miranda rights. We are not more equipped to parent these children, right? Or anything like that, but we are more equipped to advise them of their constitutional rights.
So these children have a potential of having a parent that would not be looking out for their best interests or thoroughly understanding their rights to waive their rights.
That is a potential. And one thing that I think is very important for everybody to know is that sometimes also adding a parent into a confidential conversation puts the parent in a very bad position. Because if a parent listens in on a confidential conversation between a child and an attorney, that parent can be called to testify against their child. And a lot of parents do not want to be put in a position where they testify against their child. So this is not to say that parents are not included. What they're not included in is confidential attorney conversations that are not only going to harm the child, but can harm the family unit as a whole.
Thank you very much.
Thank you very much. That concludes the testimony for House Bill 319. We're going to move on. Delegate Simpson, House Bill 445.
Now, aren't we? I'll laugh, don't be bored. I ain't laugh. Woo. We ready? All right, let's go slam. All right, so it's not good afternoon. We'll have to change that one on here. I was gonna say, good morning, everyone, and my judiciary family. I'm here to ask for that beautiful yay vote on House Bill 445, minors convicted as adults sentencing transfer to juvenile court. Last year, we took the significant step in becoming a safe harbor state for sex and human trafficking child victims. So what this bill does is just applies that basic idea to the sentencing portion. It's not required. It just provides that discretion of the judge and the courts. Just provides that other little exit ramp or a ramp back to the juvenile court system. So it's late or early, depending on how you look at it. So I hope for your yay.
Thank you, Delegate. I would also like to ask for Gordon Pack Jr., if you're here, if you would come up, and Serene Holmes, if you're here, you can come up and be a part of this panel.
They may be asleep.
Okay. Serene Holmes or Gordon Pack Jr. Okay, moving on. Ms. Virgin, if you want to go next.
Thank you, Madam Vice Chair, and good evening, members. Thank you for the opportunity to express support for this important bill. For the record, my name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. This bill seeks to address a troubling trend that we've seen across the country: the prosecution of child victims of sex crimes and trafficking who have harmed their abusers, and many of these children receive lengthy prison sentences in adult court. Because of this trend, legislatures across the country either have adopted or are considering similar policies. The premise behind this bill is simple. Children who have been trafficked or sexually abused who take action against their abuser or trafficker should not be sentenced in an adult criminal court setting. If passed, the bill would allow, but not mandate, an adult court judge to send a child defendant to juvenile court for more appropriate sentencing, if the defendant has proven by clear and convincing evidence that they were the victim of trafficking or abuse at the hands of the person whom they are accused of harming within 3 months of the offense. Grooming tactics and traumatic bonding, coupled with the fact that children's brains are not fully developed, prevent them from understanding the consequences of their actions as it relates to people who have committed severe abuse against them. While children who have been victimized have real feelings of danger that are triggered by their abusers, self-defense laws usually don't apply because those laws require a threat of imminent harm. And even though a child feels real danger, sometimes they also can premeditate their actions under the law. The fact remains that the child would not have committed a crime if it were not for the abuser having abused or trafficked them, and the law should focus on treatment, not punishment of these child victims. They deserve our understanding, empathy, and love, and they don't deserve to be demonized and thrown away by the justice system. Thank you.
Thank you. Vice Chair, members of the committee. Elizabeth Hilliard, I'm the Acting Director of Government Relations for the Office of the Public Defender. We agree with everything that Emily just said and urge you to read our written testimony that details why children who have been abused and trafficked are hypervigilant and why they need the care that is permitted, not mandated in this statute, and why we urge a favorable report on this, but we also urge a consideration of allowing children who have been victimized to be sentenced in youth court across the board. But this bill specifically, we urge a favorable report on. Thank you.
Thank you. We have 2 individuals who are testifying virtually in favor. If they're available, I want to go ahead and make them part of this panel. Okay. So that would be Sarah Cruzan, I'm sorry. Sarah Cruzan.
Yes, I'm here. Thank you for the opportunity to be here and hearing the voices of children who are still being unprotected, suppressed, underrepresented, misrepresented, quietly sifted through oppressive systems and disposed of in the current criminal justice institutions. I am a member of the Child Justice Reform Team at Human Rights for Kids, and I'm also a survivor. In my work at Human Rights for Kids.
Excuse me, do you have a video camera capability?
I do, but I'm just choosing not to turn it on at this point.
You don't usually do that, Ms. Cruzan. Is it for a particular safety reason that you don't have it on?
Yes.
Okay, we'll go ahead and let you testify without your camera. Go ahead.
Thank you. In my work at Human Rights for Kids, I conduct outreach to women and men who are incarcerated for crimes they committed as children. As of today, I have spoken to a woman and a man who is incarcerated in Maryland's Department of Corrections who are survivors of child sexual abuse and child sex trafficking. Today, I'm serving as their voice, and it's an honor to uplift their voice here today. One of the men in contact with has been shot. He's experienced being stabbed, molested, and sexually exploited by an adult woman as a child in the community, which was unable to protect him. All of this before he came in contact with the criminal justice system for the conviction he received as an adult. Yet the alleged crime took place when he was under the age of 17. His victimization was not acknowledged prior to the trauma violence, which brought him in front of a judge. This case also included 2 police officers who were not wearing their badges. This incarcerated young man is currently serving a 70-year sentence. Another American victim is a woman who was sexually exploited through sex slavery and a victim of domestic violence while as a child, was too convicted by the court of law in Maryland. Her victimization was not considered when a life sentence was being considered as her debt to society. This woman has experienced a continuous cycle of violence while incarcerated. These survivors are currently in institutions that lack in real-time accountability, transparency, rooted in dignity and social support, tailored to meet their immediate individualized needs. The state of Maryland has continued to lead in reimagined child-centered policy, and we can continue to reflect and act on what reimagined policy can look like, placing children at the forefront and leading the way. Thank you.
Thank you. And Ms. Cruzan, I'm going to leave you available for questions. I would like to note, however, it is not our policy to have individuals testify who do not have video testimony. In this particular case, I allowed it because she said because of protective reasons. However, I'd prefer if you're going to testify, if you're not going to use your video, submit written testimony or at least advise the committee before you testify so that the chair can make a decision as to whether and to approve non-video testimony. With that said, Delegate Grammer.
So I want to reread this paragraph because it might be the most awkward paragraph I've ever read. So let me reframe it. If a youth commits is charged as an adult against a person who has sexually abused or human trafficked them, the court may waive that charge to the juvenile court.
That's correct.
That's not entirely correct.
Well, I mean,
the charge doesn't get waived. The sentencing gets waived.
Right. So they would have the opportunity for a reverse waiver before trial in all the applicable scenarios under the current law. This gives them an opportunity after trial before sentencing to go back to juvenile court.
Like interesting kind of self-defense.
Listen, what sound they make.
Ma'am, your mic is still on. Please turn it off. Refresh the committee as to the charges for which a youth might be charged as an adult.
There are 33 of them, and it might be a bit too late for me to recount them by memory. Carjacking. I want to look back at our youth attorneys right now. Murder, sex abuse,
The ones that are going to
carjacking.
apply here, likely assault, murder.
Yes.
Something likely that the youth would have committed against their attackers, probably violent.
Yes.
Correct.
Okay. How interesting. Thanks so much.
Delegate Taylor and then Delegate Erican.
Thank you, Madam Chair. Am I reading this right in that the person that was against whom a crime was committed had to be convicted of a sex crime in order for this to be applicable?
No, there's no conviction required.
Okay.
What the judge would have to find is that there was clear and convincing evidence that one of these crimes was committed against the defendant, the child victim defendant. I know it's a complicated scenario, but there's no conviction required. No.
I mean, keep in mind that sometimes you may not know, particularly when it comes to abuse, you may not know it right away. So, I mean, that is a possibility. It is a possibility that it was known throughout. And at this point, it gives the judge the discretion, even if it was a crime that would be, of course, tried as an adult, convicted, obviously, of the crime. And then this is the sentencing portion.
Thank you.
There may perhaps be a missing comma as I'm reading this. But it is,
Good old Bill Jones.
yeah.
Yeah, they're wonderful. Thank you.
Delegate Erican, and then
I
Delegate.
don't want to
Thompson.
beat this dead horse, but this is really confusing. Okay, so this cup is, so I just want to make sure I'm not confusing it, is the minor who is convicted of committing the offense previously committed a sex crime.
No, already no.
Yeah.
So
I can
the,
give you sort of like a specific case that would
that
help
be-
you.
Yep.
So I'll tell you about the most common scenario is where there is a child who is being trafficked, sexually abused, and they commit a crime against the person who is trafficking them or abusing them.
Right.
So we've seen it where, you know, someone takes action, commits a violent crime against their trafficker, their abuser, because they want to escape.
Right.
That child is then prosecuted.
Okay.
And what they have to prove under this bill is that the person that they committed the crime against trafficked, sexually abused them under the current law.
Okay, I'm not convinced that paragraph says that. But maybe a comma problem. I can definitely see places where there could be a comma that might help, but I don't. There's gotta be a better way you can draft it. It's just really dense and convoluted. So I mean, I'm not saying that judges can't figure this shit out, but if none of us can, if none of us can, maybe they can't.
Well, it won't be in all caps either.
That's always helpful. That's always helpful. Welcome to.
Or bold.
Yeah. Okay, I think I understand what's happening. Okay.
All right. Delegate Tomlinson.
Thank you. I wouldn't ask this if they were here, but I don't think nobody's giving unfavorable testimony in person, right?
That's correct.
Okay. I was looking at a couple and have, Maryland Coalition Against Sexual Assault, Human Trafficking Task Force, Network Against Domestic Violence. Have you been able to connect with any of those organizations? And
Yes.
okay, well, yeah,
They want, I don't want to speak for them here. I think they submitted testimony.
Yeah.
and
so I would just defer to the testimony that they submitted.
my understanding is that they want the bill to be broader. That's what my understanding of their testimony is.
Little baby step.
They wish it was a bigger step.
Okay, thanks.
Okay, that concludes the testimony for House Bill 445.
Thank you very much.
Did you have a question? Oh.
Welcome.
Next, we have Delegate Conaway for House Bill 727.
I don't know about that. Thank you very much, Madam Vice Chair and Committee. I'm Delegate Frank Conaway Jr. here to introduce House Bill 727, Juvenile Law Custodial Interrogation, in-person attorney consultation requirement. The bill does one thing, but I had a very interesting day and I have 2 minutes. So I tried to do this from my desk, but I have 3 minutes. So in the last bill, I think it really hit home how impersonal it feels when a person is talking to you on a very sensitive subject and they're not there with you. And I was hoping that my state's attorney was going to be here, but now I have to call him on the phone if I want to talk to him. What my bill says is if you're going to talk to your attorney and you're a juvenile, you have to talk to the attorney, what? In person, face to face. Therefore, I can know that I'm talking to you. You can know that you're talking to me. I don't know whose phone this is. I don't know who's listening in on this phone. You see, so all this bill says is in person, line 16, page 2. I'll be glad to take any questions.
Thank you, Delegate Conaway. I appreciate your brevity. Are there any questions? Delegate Taylor.
Just one question. Is this referring to the hotline? So when a child is detained and have to call and the hotline is called,
It's in reference to their right to talk to their attorney in person, a juvenile, not on the phone, not on the hotline, not on the phone that the officer might give them or whoever it is. It's already traumatizing enough. You're 13, 14, 15 years old. You should pick up the phone and talk to delegate who's talking to me. How do I know I'm talking to you? And it's very it's not personal. So I think we could do a little bit better than that. And we've been talking about all this trauma to the juveniles. I don't know how many people have experienced trauma with law enforcement or anything like that, but it's really not a good feeling. And if your parents can't be there with you, or maybe they shouldn't be there with you, you need someone there with you. I just think that's just fair for the children. Any other questions?
Delegate Sample Hughes.
And I'm gonna be very brief. Thank you, Delegate. You see the fiscal note?
Yes, 1.6, right?
Do you think that's like?
I think it's worth it every penny.
Exaggerated?
I think two
Or do you
things. I think two things.
me finish
1.6 on
sir.
that note, and 1.6 on teaching children how to prevent getting in trouble. Go ahead.
If you would allow me to finish
Go-
my
Go
question,
ahead.
it was very simple.
Yes,
Do you think that number is exaggerated, or do you think that's really in line with what it truly is gonna cost?
I have no idea. I didn't even calculate that. That's never really not important to me, because I'm the kind of guy that if I think that sending you to private school might help you, I might have to work 2 jobs to send my child to private school. That's the kind of guy that I am.
And likewise, I am as well. I'll do what I need to do. My only question for asking you about that is because I've seen fiscal notes where they'll put in a high number to make sure your bill doesn't pass. So I
Right,
just
I
wanted to know.
understand.
It's happened to me, so I was just asking.
Thank
for
you so
clarity
very much.
purposes.
I don't know. I didn't calculate it, but I'll
Okay.
try if you want me to.
Sure, thank you.
Thank you.
I'm just reading the language in the bill, and I am concerned that it may be not clear, because I hear what you're asking for, but it says a consultation with attorney under this section shall be, and it gives alternatives. I think the shall be is still there. Or are they saying 1 and 2 are completely out and only 3 in person?
Yes.
Okay.
Yes, we're gonna take out the telephone. We're gonna take out this video
Okay.
without someone there, and it has to be in person. And another thing you might want to think about if you read this bill, page 6, line 31 through page 7, line 3. As a juvenile, we've
7.
Thank you very much.
Okay,
asked for
unfavorable. Okay, so now we're gonna move to unfavorable on House Bill 727. We have Keith Lockridge, the office, Madam Public Defender, Natasha Darty, and Evelyn Walker from the Office of Public Defender. And Madam Public Defender, if you want to start, and then you can take any order from there if you like.
Thank you. Good evening, Madam Chair, distinguished members of the committee. I am Natasha Darty, Maryland State Public Defender, and the Office of the Public Defender opposes House Bill 727 and requests an unfavorable report. HB 727, the requirement that attorneys be physically present during communications with a child is both unnecessary and unduly burdensome. The Sixth Amendment right to counsel is a fundamental right afforded to all individuals regardless of age. It is paramount, especially in our respective roles in the legal system, that we safeguard this right. We must create opportunities that enhance the right, safeguard engagement, and support due process. It is important that we facilitate communications between lawyer and child, not enact policies or practices that break down a child's right to counsel. Remote communication methods such as telephone and video conference are common and reliable. In fact, we use them today in these proceedings. Requiring physical presence would create logistical challenges and a nightmare for attorneys and clients, as well as law enforcement. In situations where the child and the attorney are located far from each other, alternative means of communication is necessary and important. These methods allow for real-time communication and consultation between the attorney and the child, even if one cannot physically be present at the same location. It also allows communication to be immediate, allows the attorney to engage with the child and advise the child. OPD services the entire state. As you're well aware, certain areas of the state are more remote. The hotline runs 24 hours a day, holidays and weekends, 365 days a year. OPD opposes House Bill 727 and requests an unfavorable report.
Good evening, Madam Chairman, members of the committee. My name is Evelyn Walker, and I am an attorney with the Maryland Office of the Public Defender in the Juvenile Division in Anne Arundel County. And I have been heavily involved in training OPD attorneys across the state in the Youth Access to Counsel Hotline, and have myself been working hotline shifts since its inception. The technology utilized to conduct phone and virtual advisements is quick, effective, and sufficient way to advise youth of their rights. Requiring in-person advisements when they are not needed will diminish the efficacy of the YAC hotline, and we therefore urge an unfavorable report. OPD attorneys who staff the YAC hotline are trained using the latest science and peer-reviewed studies about juvenile brain development, speaking to young clients, identifying key differences between children and adults for advisements, and to assess whether to advise a child via hotline, phone, or video call, or in person. As someone who has trained OPD attorneys and staffed numerous hotline shifts, I can tell you that in-person advisements are rarely needed. Myself and OPD attorneys have been able to speak to the children who call the hotline, hear their concerns, hear their fears, and adequately advise them from over the phone or video calls. Because we are trained in adolescent development, brain science, and mental health concerns, as well as intellectual disabilities, it should be up to our professional and ethical discretion whether to advise remotely or in person. Overall, the YAC hotline allows for attorneys to effectuate important conference advisements to kids all across the state. Requiring in-person advisements does nothing to benefit the children of Maryland. Rather, it would strip qualified attorneys of their professional discretion and would cause unnecessary delays to the detriment of children by increasing detention times, and would further burden law enforcement by pausing their investigation to wait for an attorney who may have to drive long distances to conduct an advisement. And it would cause an undue hardship to the attorneys and staff of the YAC hotline. As someone who really, really loves working on the YAC hotline, I can tell you that I want to protect it, and it is adequate to advise children over the phone. So I urge an unfavorable report.
Good evening, Madam Chair and delegates. I am Keith Lottridge. I am the Deputy Public Defender for the state of Maryland. You've heard from my two colleagues, and they've
Perfect.
I don't know why I keep failing to do that. I apologize. Better? Okay. I always lose 10 seconds when I do that. Good evening. I'm Keith Lottridge. I'm the Deputy Public Defender for the state of Maryland. I will again be addressing the cost. As I've stated before, we're stretched to the limit. Right now we have the YAC hotline, as we call it. It is a 24-hour, 365-day a year service. Last year we had 300 children on that hotline, and we advised all of them. That was not done at that much of an expense to the state. I would note that here on the desk is the final catch-all. We have 3 attorneys assigned at any time other than business hours. If they don't pick up, it comes to me 24/7 days, 24 hours a day, 365 days a year. That's required because, quite frankly, our attorneys are busy and things happen. For us to staff a hotline like this in person would require significant personnel. We want our children to be advised and advised well, and we are doing that. We put in our fiscal note, our bottom line, $1.6 million. And I think that's conservative, to be honest with you. That would allow us to have essentially 16 attorneys hired for this purpose. We would have to cover the entire state. They would have to be available essentially 24/7. That does not even fully account for the fact that many juveniles are not arrested by themselves, meaning one attorney would not be enough for many of these cases. We'd either be sending 2, 3, 4 attorneys at a time, potentially in the middle of the night, or we'd be paneling, meaning we'd be paying relatively high rates to private attorneys to get up at 2 a.m. to go to the police station or wherever these children are held. That's the cost. It would also be very we are asking for a favorable report. Thank you.
Thank you, Delegate Conaway.
Madam Vice Chair, thank you, panel, for coming in to testify. I would like to ask you all, since you all are experts, and if you talk to a juvenile 13-year-old on the phone, are you able to determine, with your expertise, that this 13-year-old juvenile can understand their Miranda rights? Are you qualified to do this?
Yes, we are.
And by who?
So I would say one, we're qualified by the training that we conduct.
No, would you say like Johns Hopkins, you have a certificate on your wall or something? Or?
Well, I would say I have my, my law degree, and I'm specifically trained in juvenile law and juvenile advisement. So
yes,
I would call myself an expert in
yes,
that.
But then you testified that there might be a little bit different in a child's brain development. So are you trying to tell me that you're that type of physician / attorney that you can understand the level of the brain development without it being scanned? Is that what you're saying?
So just in terms
you
of.
You said that a 13-year-old, 14-year-old, they might not have the brain development of a 20 or 30-year-old person, right? So how can you determine if that person who has this immature brain can understand the Miranda's rights?
So
you're saying you're experts, so I want to know.
So essentially through training in terms of how to speak with juveniles, how to speak in terms that are age appropriate, our juvenile attorneys go through separate training in addition to the regular get-in training because juvenile practice is a specialty. Our juvenile attorneys are also receive training that is specialized through the Galt Center, which is a specialized training for individuals who practice in juvenile law.
Right. So therefore, you're saying that you would be able to know if a juvenile could understand being Mirandized. That's what you're saying. It's just yes or no.
Yes.
Thank you. Okay. You have that ability.
Delegate Simmons.
How you doing, Madam Public Defender? Thank you for hanging in there with us tonight and your wonderful team for all the work that y'all do representing individuals here in the state of Maryland. Let me ask you, we talked about in-person attorneys being called out. Can you tell me the number of fleet vehicles the public defender's office has provided for the public defenders to go around our state and in-person represent?
Our attorneys are not assigned vehicles.
None at all?
There's one vehicle that we have.
One vehicle for the entire state?
Yes.
Okay, so you would say that you wouldn't have the capacity to move about unless you're using your own personal vehicle?
Oh, they would definitely have to use their own personal vehicle.
Thank you.
Delegate Phillips.
I'm sorry. Thank you very much, Vice Chair. Let me ask this question though, because I've heard this comment before. I've even heard it from the state's attorneys. It would be better for the young people to have someone physically with them explaining all of this. And I think it would be better, but I see the fiscal note. One option might be all video conferencing. Is that something that could be done without having a $1.6 million fiscal note? And what would be required to do that?
So in terms of, well, I would want to say two things. There are instances where the attorney does in fact go to the location where the child is. So I want to make that clear after the initial conversation. If it is needed that the attorney appears, they make an arrangement with the officer as to what time they're going to arrive, and then no one should be speaking with the child until the attorney arrives. So I do want to make that clear. And I'm sorry, the second part of your question.
What would it take so that instead of just doing a phone call, what would it take to do these things via video conference?
Well, I would say in terms of making it universally video conference, it would also depend upon the capability at the location. And then we would have to address, because essentially the ability currently to make it statewide is that there is a specific phone number that all law enforcement call into, and then it's the hotline. In terms of the technology, if we were not using a phone number, I'm not sure how that would specifically work. If it was video instead.
So I remember this time. In point of fact, we do have attorneys, and I myself have occasionally, as I said, I occasionally get the calls, and it's an iPhone. So sometimes we're able to do that. Sometimes we're not, quite frankly. These calls will come at 2, 3 in the morning. Sometimes the police are not able to do that. I mean, we could have that conversation and sit down. I think it would require communication with, I don't know how many different police forces there are in the state of Maryland. I know there's over 23 in Prince George's County, having been the head of that county for quite a while. Each police department would have to have some type of established procedure, and they'd have to coordinate with us, and we'd still have to have some type of software to make sure that it was secure. Quite frankly, iPhones are pretty secure, but we could do something like that. Essentially, we could probably work on it. I just don't know that we could get that done tonight, but it's a possibility we could look into, and I'd be willing to meet on that.
Thank you.
Delegate Simmons, that's just an error in technology, right? Or was your light
No, I
actually?
have a very important question.
Very important question?
Very important.
Okay, go ahead with your very important question, Delegate
you.
Simmons.
Madam Vice Chair, that's why you're my favorite, During COVID, can you talk to me about how did the Public Defender's Office mitigate representation during that period of time with so many restrictions put on the court system?
So during COVID, I was not in my role. I was in leadership in Baltimore City, but it required us to really pivot, and especially with individuals in the institutions, it required the institutions to establish video conferencing, because generally that was not, in most of the institutions, that was not available. So I think they had to infuse iPads and things of that nature so that we would be able to access our clients.
So did technology work during that time?
It was a transition.
Okay, thank you.
All right, Delegate Arakan.
Thank you, Madam Chair. Thank you guys for being here. I know you guys are all from OPD. Could everybody that's from OPD raise their hand in the audience? Okay, thanks. That's all I want to know.
Delegate Tomlinson.
Thank you. How long are the phone calls normally? I mean, or is it could be
It varies.
all over the place?
It varies.
And I would say as someone that I do a lot of hotline shifts, I've taken a lot of calls. I would say on average, they're about 45 minutes to an hour for me. So they are a significant period of time. It's not just a quick, hi, here's your Miranda rights. We have a very, very long process that we go through to make sure the kid understands everything.
Okay. I mean, are you guys talking the entire time, or is there a lot of pauses, breaks? I'm just asking, as far as, I mean, I mean, you guys are talking for a straight 45 minutes, or is there a break? Because I don't know, something's going on.
I would say that I've had advisements that have lasted just myself talking to the child for 45 minutes to an hour. Obviously when we get a call, we're first talking to the officer, we're getting information.
That's what I meant.
That can take some time, but that's usually the quickest. The officer and I are able to, quickly communicate. Then they've usually already put a child in a room. give the child the phone, allow the door to be closed so that we can have that confidential conversation. And then we have an advisement that does take, a significant period of time. And it varies based on the child. If a younger child needs a longer advisement than maybe an older child.
Gotcha. Okay.
Delegate Valentine.
Thank you, Madam Vice Chair. I'm just trying to get a kind of figure out the process of how it works now. And I'm also trying to figure out the fiscal note. So just to be clear, you're having in-person consultations now, like during normal business hours? Does that occur?
During
Like normal business hours? Does every consult via the hotline is what I'm trying to get at now? Or is that only after hours?
So whenever an officer has a child in custody and wishes to interrogate them, they call the hotline.
That's how it's set up. It goes to the hotline.
It goes to the hotline.
And last year, there
It could
were
be from
about.
anywhere in the state. Yes.
Correct. I didn't know if that was the default or if like during normal business hours, it would be in person. The process is automatically the hotline.
Yes, because the calls are coming from anywhere.
Correct.
Yes.
And last year, there were approximately 300 total. I heard testimony was around 300?
Over 300.
It was over 300.
Yeah, we don't have an exact number. We weren't collecting all of the data at the very beginning because we had to throw it together pretty quickly. But it was over 300, I think, in the first year.
And the reason I ask this is knowing that the Office of the Public Defender is in every county. I was just trying to think how that would be handled if it was a lot of the rural counties, you may not have any inquiries at all, or you may have very limited. I'm thinking Western Maryland, where I represent, you may not have the volume that you do in the metropolitan areas, but you still have offices in every single county. And I'm just trying to think how that would be supplemented if you needed someone in a Western county. If this were to happen and it would be in person, how that would be handled to try to knock down, because I'm trying to think, how did you come up with the figure of 16 additional pins? So I'm trying to think, how did you get to that number?
We divided the state into quarters. Western Maryland, we did quite a few in the central part of the state, the Eastern Shore and the Upper Shore that basically carved out part of the north. And then for instance, Western Maryland, Lower Shore, we reduced the number of people possibly needed. Because remember, you're doing 24/7, 7 days a week, potentially.
Correct.
So you can't have one person cover, even though I don't anticipate that we're going to get a lot of calls on the shore, I couldn't have one person cover the entire shore for a year. It's not possible.
Right.
In point of fact, two people wouldn't be possible. But we would still have to limit it to a certain number because we were relatively conservative on this fiscal note. So that's how we broke it down. At the central part of the state where we thought we would have more people, we would have, and I don't actually have the breakdown here. I think it was included in the fiscal note potentially what the breakdown was per area. But we would have more people in the central area because you'd be including Baltimore City, Baltimore County. And I think we actually divided off Prince George's County and Southern Maryland because of the volume there as well. So we had those quadrants. So that's how we were breaking it down, a certain number per area. And then the issue was, again, 24/7. Right now, we do occasionally have people meet after there's a call, but that's during business hours. Most of our juvenile defenders are in court every day. They couldn't drop what they're doing and go meet to talk to a juvenile. If they can take a phone call, because that's not getting in a car going to a precinct, the precincts are not at the jail, and that just takes a lot more time. So we are able to kind of cover during the day, but again, it's a little bit more sporadic. Does that make sense?
It does. It helps explain it to me, yes. Thank you, Madam Vice Chair. I think that's all my questions.
Okay, that concludes the testimony for House Bill, House Bill 727. We're gonna move on to our last bill of the evening, House Bill 169, Delegate Acevero. He did. Well, let's use this as a stretch break.
You thought I fell asleep? Good. Appreciate all your work. I've been listening. We don't get it. We don't get it. We're definitely gonna get it. All right, everybody got quiet for me.
Okay, we're gonna bring ourselves back to order. We just needed a little stretch break, Delegate Acevero. We are ready for you. Is this your first time in judiciary this year?
It is.
All right,
It
welcome.
is. Yes. You know, I always file these bills just to come see y'all. Well, most of y'all, you know. You know. Yep.
All right.
Here we are.
Well, Delegate Acevero, please start with the introduction of your bill.
Appreciate that, Madam Vice Chair. Thank you all so very much. I know we're late into the evening, but it's certainly an important day to be hearing a lot of juvenile justice bills. And this particular bill, this topic is certainly related. And as we have a discussion, really a debate about what we're going to be doing around juvenile justice, my hope is that this would be part of that discussion, how we protect our juveniles, particularly during interrogations or when they are with law enforcement officers. I think we did a lot of good work around the Juvenile Interrogation Protection Act, and it was a good step, but there's certainly more that we can do. Folks are familiar with the Central Park now exonerated 5, exonerated 6. And this is legislation that would ensure that whenever police lie to kids, to juveniles, use coercive tactics in order to elicit a confession, that would be inadmissible in juvenile and criminal proceedings. We certainly took a good step with the Juvenile Interrogation Act as we discuss what we're going to be doing, whether it's around the JRA or juvenile justice reform. My hope is that this will be a part of it because it's about protecting young people. We see what happens in the absence of laws like this. We see that play out in New York. With those 6 Black and Latino men who were traumatized, whose lives were disrupted, all because of an overzealous prosecution, laws that did not protect them, and quite frankly, the ability of police to lie to kids. This is about protecting our kids, and I've always posed this question, and to date, haven't gotten anyone who has answered in the affirmative. You know, regardless of political affiliation, no one would be comfortable having their child, their nephew, their niece, you know, a neighborhood kid be in a room with law enforcement and know that what they say could be used against them. And in addition to that, that it is very legal for law enforcement to lie to kids. We're not talking about adults here. This is not a bill about removing that for adults. We're talking about kids who are impressionable, who are a little bit more trustworthy than adults, and ensuring that we're basically protecting them. So as I said, as we look at juvenile justice more holistically, this has to be a part of it. My hope that it is a part of it this year, particularly as there's some discussion about rolling back what we've done. This will send a clear signal that we care about our kids. We care about what happens when they're in interactions with law enforcement, and we're committed to protecting them. I urge a favorable report. Thank you, Madam Vice Chair.
Madam Public Defender.
Good evening, Madam Co-Chair, distinguished members of the committee. I'm Natasha Dartig, Maryland Public Defender, and the Office of the Public Defender supports House Bill 169 and urges a favorable report. This is an important bill that addresses custodial interrogation of a minor. Children are often less capable of understanding their rights, comprehending the consequences of their statements, and distinguishing between reality and fantasy. Their cognitive and developmental limitations make them more susceptible to suggestion, coercion, and manipulation. As a result, they may provide false or unreliable statements when subjected, for example, to deceptive interrogation techniques. When a police officer uses a false statement or deceptive tactic to elicit statements from a child during an investigation, the child may feel pressure to provide information that aligns with the false statement. This compromises the integrity of the investigation and potentially leads to wrongful accusations or wrongful convictions. Law enforcement professionals should be trained to use age-appropriate language and developmentally sensitive interview techniques when questioning children. The goal must be to gather accurate and reliable information without unduly influencing or pressuring the child. It is important that we prioritize the well-being, protect the rights of children, and ensure a fair and just investigation that includes providing them with appropriate legal representation, considering their age maturity, understanding the weight and admissibility of the statements. Children are more vulnerable and easily influenced. Ultimately, it is essential for law enforcement agencies to adhere to ethical standards and best practices in conducting interviews and interrogations with children, with an aim of obtaining truthful and reliable information while safeguarding the rights and well-being of the child. OPD supports House Bill 169 and urges a favorable report. Thank you.
Good evening, Madam Vice Chairman and members of the committee. My name is Evelyn Walker. I am an attorney with the Maryland Office of the Public Defender in the Juvenile Division in Anne Arundel County, and we respectfully request that this committee issue a favorable report on House Bill 169. In the state of Maryland, police officers are legally allowed to use deceptive interrogation tactics on vulnerable young people. As the law stands, police are not prohibited from lying about what evidence they have in order to get a confession from a child. These tactics can pressure innocent children into falsely confessing to crimes they did not commit, and this policy is at odds with everything that we know about juvenile developmental science. Not only are children more likely to falsely confess just by the nature of being children, research shows that teens are more likely to take responsibility for wrongdoings that they have not committed when presented with false evidence. Youth are more vulnerable to deceptive interrogation tactics because their brains and reasoning abilities are still developing. Overall, and unlike adults, they are more emotional, more susceptible to social influence, have greater difficulty evaluating risk and reward, and importantly, are deferential to adults in positions of power. These deficits can be exacerbated in high-stress situations such as police interrogations. The indisputable and fundamental differences between children and adults justify treating children differently than we do adults, and children should be provided more protections during interrogations. The use of deceptive interrogation practices must be discouraged to protect the due process rights of children and ensure the integrity of both the criminal and juvenile legal system. And therefore, we respectfully request a favorable report.
Thank you. Delegate Simmons, you have a question?
Yes, actually, I have a repeat of a question from earlier tonight. So once again, thank you all for coming out, and Delegate Asper, thank you for championing great legislation. When it comes to representation of our juveniles, what role do the CPS play in working with the Public Defender's Office for advocacy when it comes to juveniles before the criminal justice system?
So as the attorneys, I guess I'm not clear as to your question.
So do y'all have any relationship with CPS during the interrogation process, during the arrest? When is CPS involved in this? Because aren't they a part of this process? Or are they not included in this process?
They are not included in the process, and we would not engage with them unless they were introduced by another party and became part of the case.
So they wouldn't be there part of advocacy for the young people once they're dealing with an arrest?
They may or may not be involved in the case, but they are not, I guess if I'm understanding correctly what you're saying, they're not a partner in representation.
Advocacy, I was talking about advocacy. You know, because earlier it was stated that at some time law enforcement will contact CPS as well as the Public Defender's Office. So with that being the case, I was asking, is there a relationship with the Public Defender's Office and Child Protective Services in relation to advocacy when it comes to juveniles that's being detained?
That's really on a case-by-case basis if CPS is involved with the child, but there is no automatic communication. I'm not sure if I'm clear on the question. I apologize.
Could you tell me if CPS is a state agency?
Yes.
Okay, thank you.
Thank you. And Delegate Conaway?
Much, Madam Vice Chair. Thank you, delegate and witnesses to coming in and testify. This is for the witnesses.
I know.
So I've heard
I know.
that children are less culpable in understanding their rights. And then I've also heard things about juvenile mental science. I would like to get a transcript of your two's testimony. I'm looking for Ms. Natasha's testimony, but it just says oral, so I don't know if we have it written. But I would like to get a copy of your transcript in reference to this specific issue. But my question is, are you saying now that you believe that a juvenile some kind of way can be educated under this great stress to understand their Miranda's rights?
So it is not our role to educate. We advise them of their rights, and we ascertain whether or not they have an understanding.
What does it mean? Okay, understanding is different than education. So if they don't know it and then you telling them this new information under this stress, I mean, you all said stress. You believe under this stress, they'll be able to, a juvenile with, let's say, maybe not a fully developed brain will be able to understand exactly what's going on, what their rights are, and waive them and all this kind of stuff.
Well, what I can say is that we would assess that on a case-by-case basis. So if there is a specific juvenile, for example, that we are speaking to on a hotline call that we don't think understands what is going on, that would trigger the attorney to say, okay, we need to do an in-person advisement here. So we would go in person, we would advise that child in person. And then frankly, again, if we get to the point where we have advised both on the phone and in person, and we don't think the child even understands in order to make a knowing and intelligent waiver, then we would address that with the police officer and say, listen, this child can't even be advised at this point, so they can't be questioned. So again, that's why we talk about this on a case-by-case basis, so that we can see and listen to on the phone or on a video call where a child has certain deficits that would trigger that need for an in-person advisement.
Okay, so now are we talking to 300 cases? That's what we're talking about. That was like last year, you had 300 juvenile cases. Is that right?
Yes, and I'm also speaking anecdotally from my time being on the
Right.
hotline and doing
And out of the
advisements.
300 cases, how many in-person visits did you have to make, you think?
I don't have the data in front of me, and I'm happy to provide that to you
Yeah.
later, but I can say that it's a small amount.
Yeah, I'm very interested because according to my math, if 300 can be divided into 365 days a year, so that's less than average 1 a day, 2 a day. So you might only need 1 or 2 brand new green fleet vehicles to travel around the state to handle this. But I thank you very much. And don't forget to send me your transcripts if you have them.
Yes, and I also did written testimony that has that citations that we talked about.
Thank you very much.
No problem.
Okay, on the bill, Delegate Valentine.
One last question. Thank you, Madam Chair. Thank you, panel. I have a question. I just want to see, and this might be splitting hairs, but I want to see if both these examples would fall under what you're looking for in this bill. Obviously, the first example would. Officer or detective is interviewing and says, I have video surveillance of you committing a crime and it's clear and convincing and I know it's you, and he knows that he does not, and that would be false. That would be covered. My question is the second example where they're interviewing that same individual, that same child, and saying that we've pulled surveillance, okay? He didn't say he has him on video or her on video, but infers that they have videotape of the incident, but it may be grainy. He's not saying they do, but is that inference? Are you looking for that to be captured on this as well? He's kind of inferring, but he's not saying we have you committing this crime. Do you see where I'm going with it? Would that be something that would be interpreted as this as a lie? Because he has pulled video. He's not saying that he sees the individual on video. He's just saying, I want you to know that we pulled video of everywhere in the area. But knowing that he does not have that individual identified on that tape, but he does not say it, would that be included in this bill? Kind of implying I have evidence, but I'm not saying I have evidence of you.
You know, Delegate, I think, and committee of hypotheticals, right? But I think what we're talking about is a hypothetical situation. And what the bill says specifically is, lying to children and using deceptive tactics. So I think law enforcement, would have to ensure that whatever it is, whatever answers that they're seeking, that they are in conformity with that. I mean, we could talk hypothetical situations all evening, but ultimately, people know, people know when we are talking about certain situations, if we're intentionally leaving something out, by omission or what have you, we have to ensure that we're protecting kids and we're not providing them with information that would give them, that would essentially allow them to provide false statement. And there's a very fine line about that. If you look at the Central Park now exonerated 5, right? And you look at that situation where they were saying, well, people saw you and so on. And they may not necessarily have said, well, we didn't see you, et cetera, but they inferred that. But this is what happens when we create situations where there's no clarity, where, people can infer, et cetera. And you have young people who are thinking, well, goodness, I need to provide this confession. I need to say this in order to go home, when in actuality, what you're doing is providing evidence that is admissible in a juvenile and criminal proceeding. And that's the intent of the bill, to disallow that, to protect the kids, and to ensure that if law enforcement has to do their job, they can do so. But when we're talking about kids using deceptive tactics, lying to kids is just not an acceptable practice.
I guess my question is, but it wouldn't be a lie. I use that scenario because I know that specific scenario, because they have, say, pulled video. So they're not lying, but they're not being completely honest either. So I'm just trying to see where that would fall on this particular spectrum in this particular bill. They're not specifically lying and say they have something they don't have, because they didn't say, we have you and we can see you clearly on this tape. They're just simply saying, I've pulled surveillance tape and I had that in my possession. So I'm trying to see where that would fall in this bill, because they're not actually lying to a juvenile.
And that very distinction, I mean, we're expecting kids to understand that distinction, right? The very distinction that we're talking about right now, right? Is it a lie or is it an inference? We're talking about kids here, kids who may not necessarily be able to make that distinction. And that's the whole point of the bill, acknowledging that kids in a lot of situations may not necessarily be able to make that distinction, or cannot, for whatever reason, age, development, so on. And it's about protecting them.
Thank you, Madam Chair.
Thank you. And we have one more person testifying favorably. We want to make sure we include Ms. Chaudhry. Ms. Chaudhry, if you could go ahead and testify, please. Thank you.
Thank you so much, Madam Vice Chair Bartlett, members of the House Judiciary Committee. It's been a very long day, and I know all of you are also very tired. I really appreciate you just powering through this today to listen to our testimonies. As a civil rights activist who's deeply involved in social justice work and advocacy for a decade on behalf of diverse communities across the state that often struggle with trust in law enforcement, I've seen firsthand the detrimental effects that coercive interrogation tactics can have on minors, particularly those who may be vulnerable or easily influenced. The American Psychological Association has conducted extensive research on the vulnerability of minors during interrogations, highlighting the increased susceptibility of juveniles to suggestion, coercion, and false confessions due to their developmental immaturity and lack of understanding of legal proceedings. I just want to personally give a shout out to Delegate Acevedo for championing this issue, because I know it's not an easy issue, but it's a very, very important issue that affects many children across our state and across the country as well. Many of you know of the Innocence Project. They've documented numerous cases of wrongful convictions involving minors who've confessed to crimes that they did not commit, often as a result of deceptive language and interrogation tactics that have been used. It's important that we safeguard minors' rights in the criminal justice system and ensure that their statements are obtained through a fair and ethical means, which requires maintaining a certain level of standards with how these practices occur. The use of false information by law enforcement officers to elicit statements undermines the integrity of the justice system. These tactics can lead to coerced confessions, wrongful convictions, as we've seen many times and irreversible harms to the lives of young people. And they disproportionately, unfortunately, affect communities of color who already stand to be disenfranchised in many aspects. In my own personal work, in my experience, I personally have spoken and worked with young members of our communities from diverse backgrounds, racial and ethnic and backgrounds, who harbor a deep-rooted fear of law enforcement. And I will wrap up here. I know that you have my testimony before you, but I do encourage you to review this carefully, and I do urge a favorable report. Thank you so much.
Thank you, Ms. Chaudhry. Are there any questions? Yes, Delegate Phillips.
Madam Vice Chair, I know everybody wants to go home, but I've got to ask the question that normally would be asked by my good colleague over there, Delegate Kaufman. I think he's tired, so he didn't address this. The judiciary, has issued its unfavorable in opposition to this. Have you all? You probably are not aware of their comments. Is that correct?
I am not.
I'm aware of their comments.
You're
yeah.
aware of their comments.
Yeah.
Would you like to address it? And they say a couple of things. One thing they say is that it would put them in an awkward position trying to figure out voluntariness, and the other, that there are other ways that this is already handled in the judicial system, basically using the jury as the fact finder of whether or not it was voluntary or not voluntary, coerced or not coerced. Would you like to respond to that?
So I think those were similar testimony that I provided last year. And what I'd say is that, look, we're open to working with the judiciary in terms of that fact-finding piece, but the intent of the bill here, which is to ensure that police don't lie and use deceptive tactics, that is pretty much the essence of that, right? Ensuring that that practice is something that ends. Similarly, this legislation was considered in New York and a couple other states. I know the judiciary had also expressed some concerns over there as well, and they managed to work around that in order to do that. So again, I'm open to working with folks on amendment. I don't want to get into, we'll do this, et cetera. That's the amendment process. But at the heart of it, I would hope that whatever disagreements that they have with the bill, is something that we could work out so that the essence of this, which is protecting juveniles, young people, particularly during interrogation and interactions with the law enforcement, that's something that they would agree on, right? But I mean, I've seen it. I think, the concerns are noted, but we're also open to working on amendments. And it's not a concern that hasn't been expressed and also haven't been addressed in other states as well, because Maryland's not the only state to look at this bill and certainly not the only one to pass it.
Thank you.
Will pass it.
And sometimes it's a badge of honor when they don't. So,
yeah. Yeah.
Okay, that concludes our testimony for House Bill 169. I want to make sure we give a big shout out, because while we're sitting here and we're engaged, our trooper is back there totally hanging in there with us. I want to give it back to the trooper. I want to make sure we give a shout out to committee counsel who stayed on, committee staff, my chief of staff, and the incomparable Chair's Chief of Staff, Hunter Marsh. Thank you all for staying in there with us.
I know y'all had a long day. I've been watching y'all here.
Say the best for last.